All right. Good morning, everyone. Happy Friday, second day of fall. Let's all take a moment to send positive thoughts, supportive thoughts to Ms. Feely, who had a bit of a calamity this morning. Ms. Wood, what I know is that her house caught on fire. Is her house gone? Is the roof gone? I mean, how she's okay. So before anyone says, oh my gosh, let's get to the hospital. She's physically okay. All right. What else are you comfortable sharing?
There's some walls left, but
okay. That doesn't sound positive.
Yes. It's pretty traumatic this morning, but
okay.
She's okay. Everyone's made it out. So I'm sure she'll be appreciative of good thoughts.
So her people and pets in her household are okay. They'll be working through, but what about the prized quilt or importantly, work laptop and work files? Not that I'm prioritizing since we have a trial calendar.
I know that the files on the laptop were with her. I'm not sure if they made it through yet.
Are you supposed to bring work files out of the office to a place like this where they could catch on fire?
You were assigned to Judge McBurney.
All right. Well, good. You're not supposed to catch on fire when you're assigned to Judge McBurney. I'm glad she's okay. I let Ms. Primovic know, not that she can get emails now because she's jetting off somewhere, that we'll do whatever we need to do. And that remains the case. So I get it. You'll be pitching in today and we'll have to put our heads together this afternoon about what it means for the trial calendar. I'm confident her clients will still want to move forward, but they'll want to move forward with a lawyer who can be prepared and doesn't have soot in her hair and stuff like that. So we will figure something out. But I'm glad that she and her family are okay. With that, we have a status conference calendar. Remember the way status conferences work. We are making sure both sides have discovery. Assuming they do, this is the day. If a defendant wants to resolve his or her case with a plea that can be withdrawn, if that plea is not satisfactory to the defendant, you can do that. After today, I remain a big fan of pleas if that's what people want to do, but the right to withdraw goes away, assuming the answer to the question of I've got all discovery is yes. Obviously, if you're missing your client's statement or critical surveillance video or dispositive DNA, this isn't the day where your right to withdraw your plea expires. So we'll see how that goes. I think our first two cases, even though it's on for status conference, it's not quite the status conference that we'll be doing for all the remaining ones. And of course, the very first one, prosecutor is in trial elsewhere and defense counsel is on an airplane. Hopefully someone is here to make an announcement. It is Samuel McCullum, who should not be on this session. There is someone at Wilcox, but I don't think that's Mr. McCullum.
That's position 4.
That's going to be Mr. Clark. Great. We'll get to Mr. Clark in a little bit. So Mr. McCullum got some other serious business going on. And the threshold question was, where is he in the appellate process? And ought we to just put this on judicial hold until both defense and state say, you know what, we need to go ahead and try the case. And the state may be ready to try it right now, meaning then we need to get Mr. McCullum here from his life without parole sentence and move forward. I'm going to start with the state. I don't know who's going to play Adrian Love right now. Mr. Hand?
It would be me, assuming.
Mr. Abate did walk in, so there is a major case lawyer, not his case, but we just need to figure out the state's thoughts about the way to move forward or not and put it on judicial hold. Mr. McCullum, don't know if you know anything about the case.
I know Ms. Love does intend to try the case. I don't think she's in a hurry to try it, just as your Honor stated, he is in custody. For life.
Forever?
Yes. So I don't think putting it on judicial hold would make a difference one way or the other, in the sense that when Ms. Love indicates to the court after speaking with, I think Ms. Promoter is defense counsel, I guess when they can decide on either a resolution or a date that works for both them and take it off judicial hold.
Okay, I think that's what we'll do. If you'll let Ms. Love know, Mr. Abate, and if you'll let Ms. Primovic know, Ms. Wood, that I'll enter an order. It's going to be sort of like what we did during the pandemic at defense request, when certain defendants and their lawyer said, hey, I'm just not comfortable being that first defendant who tries out a trial with masks and people far away. Said, all right, we're going to just put your case on hold until you let me know you want it back on track. But this will be, we'll need to hear from both sides. And really either side could pull it out. If Mr. McCollum tells Ms. Primovic, I want my trial, it just takes one to get it off. I just didn't want to put it on there if either side objected. Do you have anything additional, Ms. Wood, from Ms. Primovic about Mr. McCollum?
No, Your Honor, no objection to the judicial hold.
Okay. I'll enter an order to that effect. Case number 2 is Tyrus Hamilton, and I think Ms. Winfrey has joined us. It was originally Ms. Cousin, I think she's now Ms. Dutcher. It was her case. Mr. Hamilton, now ironically, is where Ms. Dutcher, Cousin, is. He's got a federal case, and if he's going to be handled federally, I don't know why we need to keep his case rattling around in this division. So, Ms. Winfrey, do you have an update from your federal counterparts? And good morning to you.
Thank you, Judge. Yes, and good morning. AUSA Irina Dutcher is getting ready to try this case on October the 18th. 2022. She's actually preparing this case for trial. The reason why we wanted the case to kind of stay around, because depending on the disposition of that case will determine whether or not we will pursue this case to trial ourselves. Of course, should she get the outcome that we expect, we would be moving to dismiss this case. We just ask that the court hold until that case is tried in federal court before that determination is made.
Sure. And I don't have an ability to make it go away. What I will do is put it on judicial hold and have Ms. Nelson check with you, Ms. Winfrey, maybe in a month, a little longer. If you've forgotten, if you get, hey, it was a outcome favorable to the government and the state, you can just let us know and that you intend to null process it. Is it an overlapping set of facts, or did Mr. Hamilton have something completely separate that the feds are going after?
No, overlapping set of facts.
Okay. Then just please keep us posted, and we'll put this on judicial hold. It's going to pop up on a calendar sort of like this in a few months if we're not getting an answer back from you, or you say, well, I'm not sure what we're going to do with it. But I understand your perspective that really the federal trial ought to be fairly outcome determinative.
Okay, thank you so much, Your Honor.
You bet. Ms. Wood, anything you want to add?
No, Your Honor, I actually spoke to Ms. Patel about this case. And she told me that the last time she saw Mr. Hamilton, which I believe was earlier this year, that he told her he did not want our services anymore. But of course, I don't know if that's still true.
Okay, we can navigate that if we need to. He's now in federal custody, and I don't know if he's going to fly solo there or if he's benefiting from the federal defender, but it sounds like he'll be going forward in a little less than a month. All right, excellent. Now,
I'm sorry, that concludes my business. May I be excused?
Yes, ma'am. Have a great weekend.
Thank you. You too, Your Honor.
Now to good old status conferences. Position 3 is Danny Jones. Do we have Danny Jones here? Not looking like it. Is this your case, Ms. Wood?
Judge, it is actually Miss Feely's.
Okay.
You could come back to this one. I'm going to see if I can find some contact information.
That'd be great. It would be nice if Mr. Jones doesn't have to forfeit his bond, but we'll come back on that. I will put bench warrant ? On that one. Position 4 is Tony Clark Jr., who I think is there at Wilcox State Prison. Are you able to come off of mute, Mr. Clark, or someone helping you there? I can ask it, but
No.
There we go.
All right.
Great. Are you Mr. Clark?
Sure am.
Sure are. Okay.
Sure.
Let's see. Let's get you right there. Ms. Wood, who is for today, you're handling Mr. Clark's case. Is it a Ms. Feely case?
It is, Judge.
Okay. So, Mr. Clark, I think you heard Ms. Feely, who is the lawyer who's been appointed to help you through your case, had a bit of a calamity this morning and isn't able to join us. Her house caught on fire, so she's okay, but she can't be here. So Ms. Wood, who is her colleague, is here, and all we're going to do is talk about the status of your case. If Ms. Wood, you have any info on that?
Judge, I will do what I can.
Okay. Well, let me start with you, Mr. Hand. Any reason to think discovery has not been provided in this case?
No, Your Honor. Discovery's been provided as well as an offer.
Okay. Ms. Wood, any info you're able to pull up?
I see some offers for the other cases.
Mr. Clark has more than one or other cases on the calendar?
Other of Ms. Feely's, I'm just looking, is it?
Yeah,
Okay, I found it.
Okay. Mr. Clark, you are in Wilcox for what?
Probation violation.
Okay. Any sense of how long that revocation was?
It was a 2-year revocation. I have like 4 or 5 months remaining.
Okay. Got it. Did Ms. Feely indicate that she felt she was missing any discovery, Ms. Wood?
No, but I've been incarcerated for 2 years. I haven't seen it yet.
Well, you probably haven't seen her because you've been
I've
incarcerated.
not heard the discovery.
Oh, okay. Well, it may be that Ms. Wood can help get a copy of that sent to you. Is it your sense? I know folks move around some in Department of Corrections. Are you expecting to stay at Wilcox for the foreseeable future?
She advised me that I would probably be going back to the county jail.
Okay. That may be when she was planning on meeting with you actually in person and giving you the discovery then. Ms. Wood, anything in the file about discovery concerns?
Judge, I don't see anything about any outstanding discovery,
Okay.
but I can see.
Why don't we do this? My thought is that we move the case to a trial calendar, but we preserve Mr. Clark's final plea rights. He can't have a meaningful interaction right now, just logistically, but it sounds like he and Ms. Feely haven't been able to connect all that much. So we'll further notice it to trial, but we will preserve final plea rights. And all that means, Mr. Clark, is that if you and Ms. Feely decide that the way you want to try to work the case out is a plea, but you're not interested in the state's offer, you want to do what we call a blind plea, where maybe Ms. Feely, at your request, recommends, and I'm making the numbers up, recommends 2 years to serve. And the prosecutor saying, no, there was a gun, someone got shot, 5 years to serve.
I'm familiar with that blind plea.
Okay, you know what it is, then I don't need to tell you any more about it. So you'll still be able to do that, and you'll be able to withdraw your plea if I sentence you to more than what your lawyer asked for. That right is preserved because we're not able to do today what I hope we could because Ms. Feely isn't here. But I'm going to ask Ms. Wood to tell Ms. Feely to get that discovery mailed to you so you can read it and carry it around with you, okay?
Mm-hmm.
All right, Ms. Wood, anything else on behalf of Mr. Clark?
No, Your Honor.
Mr. Hand, anything from the state?
no, Your Honor.
That is it. Thank you, Mr. Clark. You got any questions?
No, is it do you think that I've been kind of, by me just now receiving discovery so late, do you think that put me at a sort of a disadvantage?
So something for you and Ms. Feely to talk about. The discovery is not late to your legal team, which is what I look at. Now, Ms. Feely needs to get it to you. Ms. Feely's not at a disadvantage. She's got it. She's read it. She understands what the case is about. She certainly needs to connect with you, but I'm not going to rush you into trial. I'm going to make sure that you and she have a chance to discuss the discovery after you've had a chance to read it. Okay? All right. Thank you.
Have a nice coach right here. All right, thanks.
Okay. Bye. Thank you, Wilcox. All right. Next up is Derek Avery. Is Derek Avery here?
Yeah, I'm present.
There he is. All right. And Caitlin Johnston is,
For that stretch.
okay. So is this a Feely or a Wood case?
Feely.
All right. Mr. Avery, let me put you big on the screen there. Ms. Feely, did you hear me explain why Ms. Feely can't be here this morning?
I think you called him Ms. Feely, Your Honor. Were you saying Mr. Avery?
No, Mr. Avery's right there. Mr. Avery, you there?
Yes, sir.
All right. Did you hear me explain why Ms. Feely can't be here this morning?
Yes, I did, sir.
Okay. Ms. Wood, what's the discovery situation for Mr. Avery?
I don't see any notes for anything that's missing, and I do see an offer
Okay.
for Mr. Avery, Judge.
Any sense of whether Mr. Avery and Ms. Feely were planning on working the case out today?
Judge, based on this offer, I don't believe this would be working out, and definitely not from a Zoom plea.
Okay, got it. Mr. Hand, anything standing between this case and trial?
No, Your Honor.
All right. Mr. Avery, I'm gonna move your case to a trial calendar. Do you have any questions about what's going on with your case?
Yes, because I haven't really spoke to my lawyer since the case been going on, and then when I talked to her yesterday, she's saying that there wasn't no plea offer made yet. So I don't know what's going on with the case. Now I'm just hearing it is one made, but we can't do it by Zoom. So
so a couple of things. We can certainly take pleas via Zoom. What I understood Ms. Wood to be saying a little indirectly was whatever the state's offer is involves you going into custody. And that's harder to do by Zoom because we'd have to take the plea and then I'd need to trust you that you would then hop in a car and drive on down here to turn yourself in if I sentenced you to custodial time. I'm not bound by what the state recommends. I don't know anything about your case, your situation, but if the state's recommending that you serve time, it's possible that the sentence I give you involves time. And we tend not to do those via Zoom because I pronounce the sentence and then lo and behold, the phone goes dead and we don't see that defendant anymore. So we're not going to handle a plea like that. More important though, regardless of what the offer is, you and Ms. Feely need a chance to talk. My concern is,
like I said, I haven't even spoke to my lawyer since the case been going on. I haven't had to sit down, haven't been to the office, I haven't spoke to her. Like last time we spoke after we left your courtroom. I haven't spoke to her since the last time we came to court.
okay.
Need the office address or her number?
Yeah, but she has my number. She's supposed to be calling me so I can come to the office. She's supposed to set up a meeting.
You're the one that starts with a felony, so a little bit of the responsibility is on you, sir, to make an appointment with her as well.
All right, but we're not going to duke it out here. Do you have Ms. Feely's number, Mr. Avery?
Yeah, I probably have it around here somewhere. I have to look for it.
Well, that's not as reassuring as I might have expected. If we give it to you again, can you put it in a place where you can find it?
Yes, I could, yes.
Okay. Ms. Wood, what's a good number for Mr. Avery to use to reach out to his lawyer?
It's 404
404
612
612
3532.
3532.
All right. So Ms. Feely will be in touch with you. Things are a little chaotic for her right now. You should feel free to call her. It is easy. if you guys connect to set up a time for the two of you to meet and talk more about your situation, okay?
Yes, okay.
All right, that's what we'll do. Thank you so much. Ms. Wood, anything else?
No, Your Honor, thank you.
All right, Mr. Avery, you're free to go.
All right, thank you.
Well, that'll be an interesting meeting. Position 6 is Ms. Castillo. I have seen her on the screen. There she is. Good morning, Ms. Castillo. Can you unmute?
Good morning.
How are you?
I'm doing good.
Good.
How are you?
I am also good. And Mr. Richardson is on this call. We'll add him to the spotlight. There he is. Hello, Mr. Richardson.
Good morning, Judge. How are you?
I'm good. Mr. Hand, have you or has your predecessor provided all the discovery that you're aware of in this case?
Yes, Your Honor, that I'm aware of. And I believe case 6 will be a DB matter, but I have been talking to Mr. Richardson regarding case 6 and case 7.
Okay, right there.
Oh, no, sorry, case 7 is another attorney, Your Honor. But as far as I know, all discovery has been served and there's been an offer as well.
So I'm familiar with the case from bond hearings, and I know that the alleged victim had a relationship with Ms. Castillo. Are you not keeping the case? Is it going to someone in the SVD? Yes.
Yes, Judge. I received emails yesterday from Mr. Whitenauer.
Well, he's here.
Okay, and I'd spoken to Mr. Hand a couple of days ago. I did receive an offer, and I received an additional bundle of discovery. Haven't had a chance to go through it. I'm assuming that it is everything that I need, but I can't say in earnest that it is. But they have been open, have communicated, and I think we have a decent working relationship. I'd ask the court not to shut the door on a potential plea, but we're not ready to go forward yet.
So, Mr. Whitenauer, this will be your case going forward.
Yes, Judge. I'll be handling Jessica Bond Castillo, and I think Mr. Hand will be handling Javier Santiago Cano. So we'll be handling this case together. I mean, I'm happy to take on the co-defendant, but the way it's currently assigned in our office is that 6 is with DB and that 7 is with complex. I'm happy to just work together with defense counsel and resolve it if that's the way they want to go.
Well, one, your office chooses how to staff things, and if they want to have different lawyers on the same case for different defendants, that's a unique approach that you're free to pursue. I just need to make sure that each defense attorney knows to whom to speak. And so Mr. Richardson, who represents Ms. Bond Castillo, should be reaching out to you, Mr. Whitenauer. If he's trying to work the case out, talking to Mr. Hand isn't going to get him there.
Yes.
Okay. Mr. Richardson, you follow that?
I do, Judge.
Okay, so your prosecutor is Mr. Whitenauer, and he's in a position to resolve Ms. Bond Castillo's case short of trial. If there's a trial, we may have 2 prosecutors. That's not uncommon. There are often 2 lawyers on both sides. But for purposes of anything pre-trial, for your client, Mr. Whitenauer is the DA's point of contact.
Right. Yes, Judge.
Okay. Well, let's keep you, please, and Ms. Bond Castillo on. Do you have any, because I want to hear about Mr. Santiago Cano's situation since they're co-defendants, but before we pivot to him and his lawyer, anything else, Mr. Richardson, about Ms. Bond Castillo's case?
Nothing about her case, but in the issues of judicial economy, I do have another announcement, another case that I have on your calendar.
Okay, that would not be economical for me right now. So I will get back to you, but it might be economical for Ricky Richardson. I got to close out this case, so I want to hear about Santiago Cano.
Okay, good enough, Judge.
Thanks.
All right, thank you.
Ms. Bond Castillo, did you have any questions about what we were talking about?
No, Judge.
Okay, you're complying with the conditions of your bond?
Yes.
Great. Okay, I'm gonna take you guys off spotlight and get Mr. Santiago Cano. There he is. And where did Ms. Hingerty go? Right there. All right. Good morning, Ms. Hingerty. How are you?
I'm well, thank you, Judge. How are you this morning?
I'm hanging in there. So Mr. Hand, this is your part of the case. Is it your sense that you've provided all the discovery the state has to Ms. Hingerty or one of her colleagues?
Yes, Your Honor.
All right, Ms. Hingerty, are you feeling like you're missing any discovery?
I am, Your Honor. I feel like we are missing the photo lineup card. We were told that Mr. Santiago Cano was identified by Mr. Victor Castillo through a photo lineup, and we haven't received that yet. We have no body cam footage, which is mentioned in the discovery, and we are also not provided with the results of the phone dump of Ms. Bon Castillo.
Well, those would be three significant sounding things, Mr. Hand. Can you look into those and coordinate with Mr. Whitenauer? Because if before Mr. Whitenauer was involved in the case, those things were supposed to go to Ms. Bon Castillo as well. We need to make sure they're going to both defendants. Is it your understanding that there was a photo lineup done? Sometimes the police report says, oh, and there was a photo lineup, and the prosecutor learns ultimately there actually wasn't. Sometimes it's just a photo because they're not strangers involved in the case.
That is my understanding, Your Honor, but
Which is your understanding?
that there was a photo lineup,
Okay.
but I will check into it and make sure everything's sent over.
All right. Ms. Hingerty, please file what I call a discovery deficiency notice if within a couple weeks you don't have all three of those things, the phone extraction, the body cam, and the photo lineup, and whatever would be associated with that, the admonition, et cetera.
I will do it, Your Honor.
Your Honor, may I ask if Ms. Hingerty is with
She is.
I want to make sure, because my communication was with him. I didn't have much.
I understand. We did receive your offer, Mr. Hand, on Sunday, but you know, the offer was, you're obviously asking for a significant amount of jail time. So we want to make sure that before we consider that offer, that we have everything we need to review. And I am with Mr. App's office.
Good to know.
Ms.
I'm
Hingerty
playing the role
did.
of J-App today.
Yep. She handled, I think, the bond hearing for Mr. Santiago Cano. So definitely plugged into the case and a colleague of Mr. App. But I think the attorney of record is Mr. App. So send things to that office. It'll get to Ms. Hingerty.
Yes, Your Honor.
All right. Ms. Hingerty, anything else on behalf of your client?
I don't believe so, Judge. Like I said, we do have an offer. Hopefully we'll be willing to negotiate that offer. Right now, it's not something we're willing to consider while we're missing as much discovery as we are.
Okay. Does your client require the services of an interpreter?
He does not.
All right. Mr. Santiago Cano, you doing okay?
Yes, sir.
Any questions?
No, sir.
All right. So I guess it's not quite right to move this to a trial calendar, because you could get the photo lineup and then we could have a substantive motion where we need to have an evidentiary hearing. I don't know that identification is as complicated in this case as it might be in stranger on stranger, but either way, you're entitled to review that and pursue whatever relief you think is appropriate. So we may have to cycle back on this one, which is frustrating, and get everyone back in here to make sure that Mr. Richardson also got whatever you've identified as not present. All right. Mr. Hand, anything else in the Santiago Cano case?
No, Your Honor. I will make sure I get those items over to Ms. Hingerty.
Okay, great.
I
So-
couldn't hear that, Your Honor. Could you tell me?
I'll
what
make sure I
you
get those items over to you, Ms.
Okay,
Hingerty.
great. Thank you.
Is the microphone green or red?
It's very good.
All right, let's make that. Ms. Charles always had it red. Why don't we start? Your default will be always green.
Yes, sir.
That would be great. Thank
I've been
you. All
improving.
right. Ms. Boncastillo, Mr. Santiago Cano, Ms. Hingerty, you are free to go. I think Mr. Richardson has one more matter on here, which we can turn to now.
Thank you. Quick question. Will we just be noticed for another status?
Yes, we
Okay.
have to do another one of those.
Appreciate it.
Yep,
Thank you, Your Honor. Have a great weekend.
you too.
Have a great weekend. Thank you.
You're welcome. No great weekend from you, Mr. Cano?
Oh, yes, sir. Have a good
All
weekend.
right, there you go. Thank you. Mr. Richardson, what's your other case? Oh, from the trial calendar?
He's in state custody.
Oh, all right. He went away, so maybe he'll come back. Maybe that was the economy he wanted. Let's go to position 8, Justin Jones. He's here. Excellent. Mr. Jones, you can sit with Ms. Wood.
How are you?
Good. How you doing?
I'm okay.
Ms. Wood, how are we doing with discovery?
Judge, I believe we have everything. I do have an offer. Mr. Jones is rejecting that offer and he wants to be moved to the next available trial calendar.
Okay. What is the offer?
8 years probation.
8P. Okay. Is that your understanding of the state's offer, Mr. Hand?
Yes, Your Honor.
All right. So, Mr. Jones, I just need to go over one thing with you. You understand that today, if you entered a plea and I sentenced you to anything more than what your lawyer asked for, she might ask for 5 years probation instead of 8. I don't know how that would play out. But if I sentenced you to more than what she asked for, you'd have a right to withdraw your plea. No questions asked. You know what, Judge? I'm in for this much, not any more than that. But after today, if you enter a plea, because you can do that right up until the time of trial, you won't be able to withdraw your plea if you are unhappy with the sentence I give you. You understand what changes from today?
Yes, Your Honor.
Okay. And understanding that, you want your case moved to a trial calendar.
As fast as possible, Your Honor.
Okay. I will move it as fast as possible to a trial calendar. Sounds like discovery is in and we can try to move this to the front of the line. We do have some folks who've been sitting in jail for a while, also wanting trial fast as possible. So you may be in line behind them, but I'm getting the sense you're ready for this to go.
Absolutely.
All right. Anything else, Ms. Wood?
No, Your Honor.
Mr. Hand?
No, Your Honor.
All right. We are starting a trial on Tuesday. You be ready by Tuesday?
This Tuesday? Yeah, I will.
You would, but Ms. Wood wouldn't. So I won't do that to her. But she gets it and she'll be ready on our next published trial calendar. We have to, I'm required by law for all sorts of good reasons to give both sides at least 10 days notice. We don't just spring trial on someone. So, but we'll get it moving. Thank you. You are free to go if Ms. Wood doesn't need to chat with you more.
Thank you.
Danny Jones, come on up and sit with Ms. Wood, please.
Okay, oh, sorry. No,
So, Mr. Jones, you got here a little late. Everything okay?
Yes, sir. I had a little problem with my ride.
A problem what?
A problem with my ride.
Okay. Your lawyer is Ms. Feely. She couldn't be here today. She had a little personal crisis, but she's okay. Ms. Wood is her colleague and is going to stand in for her today. Because Ms. Feely isn't here, we're not going to do anything major with your case unless you and Ms. Wood are real comfortable with that. And it may be we do something major with your case, but I just want to let you know, I get it that Ms. Feely's not here, and that's the person that you may have been talking to about your case, all right? Ms. Wood, discovery for Mr. Jones.
Judge, actually, if there's a possibility we could work this one out today, if we could just have him wait for me to finish the call and then we'll come back to this one.
Let's do that. Mr. Jones, I looked at your charges and when you weren't here, I was feeling sad for you because these charges aren't nearly as serious as some of the cases I see. And you're on bond. And I thought, boy, I hope Mr. Jones doesn't lose his bond. But you're here. Your bond is healthy, is there. And it makes total sense to me that Ms. Wood thinks we may be able to work your case out today. So if you don't mind going back, sit on any one of those benches. When Ms. Wood gets through the rest of this calendar, she's going to talk to you to see what your comfort level is with working the case out, okay? Thank you. All right, Farard Fallon. It may be Fallon, I apologize. He's right there, okay. Is it easier for you to stay right there rather than come all the way up to the?
Judge, if we could have him sit there, I also need to speak with him. So
Okay.
we can come back to this one.
Got it. So is it Fallon or Fallon? Fallon. Mr. Fallon, Ms. Wood's going to talk to you. I think she has some information from the prosecutor and we may be doing something more with your case. So sit tight. And when we take a break, she's going to talk to you. All right? Great. Darian Peters in custody, and I don't have a prosecutor. Aggravated assault strangulation. So it could be one of 9 lawyers. It's Mr. Hand.
Yes, Your Honor.
Okay. We're getting them? Great.
Peters.
Do we have an issue with Mr. Peters? We have a picture.
Yeah.
Is this Mr. Peters?
Yes, I believe that's Mr. Peters.
We can call up his picture in Odyssey. Will that help? Hard to tell. How does he get over here without a wristband?
That's a big part.
Come on, sir.
Come on up to the podium, sir. How you doing this morning?
Good morning.
Good morning. What's new?
In court?
You are in court. I'm Judge McBurney. It's good to see you again. Ms. Wood, your lawyer right behind you there, and I and you are going to talk a little bit about your case because it's time to keep it moving along so you don't get stuck where you are. You ready to do that?
Yes, sir.
Great. Ms. Wood, do you have discovery in Mr. Peters's case?
Yes, Judge.
All right. Anything you're worried about that would prevent this from going to trial?
No, Your Honor.
Mr. Hand, anything from the state side?
No, Your Honor.
And you provided an offer?
Yes, Your Honor.
All right. So Mr. Peters, you're sitting in custody. I don't know if you've got other cases or if this is the only one holding you in. But I want to make sure we get you your day in court. I know you're in court right now, but I mean a day where there'd be a jury. If you want to have the state prove its case, it may be that you try to work it out. You and Ms. Wood talk to the prosecutor about maybe there's a plea. That's up to you guys. I'm here either way. I can take the plea or I can help you get a jury. But what I really want is for you not to be sitting around in jail any longer without resolution of this. It's a plea, the state dismisses, or a jury decides guilty, not guilty. That's what we're going to do next. When I bring you back here in the not too distant future, it'll be for a trial calendar so that we can either grant your wish of a trial or we'll have some kind of negotiated resolution. Okay?
Yeah, so what is the said subject of my court for today?
So today was for me to see you again, let you know we're moving your case along, for me to find out from your lawyer, does she have everything she's entitled to in terms of discovery, police reports? I don't know anything about your case. Body cam video, if there was body cam video, I'm making this up. If you gave a statement to the police, you are absolutely entitled to get that. So is your lawyer, and she would read through it to say, we should file a motion because he didn't agree to speak with the police, or they tricked him, or they threatened him, all that kind of stuff. I need to make sure that your lawyer has all that before I say, well, now we need to go to trial, because she needs that type of information in order to mount a defense on your behalf. And she has told me just now, this is why I was asking in front of you. Yep, I've got all the discovery. So she needs to spend some time with you and that discovery so that you guys can talk about, is this a case we want to take to trial or not? If there was a video camera that filmed everything that happened, maybe it's not a great case to take to trial because the state just has to press play and there's Darian Peters doing whatever they say he did. Maybe it's a case of mistaken identity and you've got a twin brother, Fred Peters, and that's your defense. It's the guy's wearing a t-shirt that says Fred. Then maybe that's one the state's going to want to work out. I don't know any of those facts. You and Ms. Wood are going to be talking about that, but I will see you soon to say, are we going to trial? And if you say yes, then we'll bring jurors in here. And if you say no, that means you've worked it out. So that's what we were doing today to make sure everyone had exchanged information and that the case was ready to go to trial. I don't want to make that decision in a vacuum and I bring you in here for trial and your lawyer says, well, I don't even have any of the discovery. Okay.
Yes, sir.
It's good seeing you. Ms. Wood, we will move this case to the trial calendar.
Thank you, Judge.
All right. And we're going to try to find you one of those bracelet things.
I'll come talk to you at the jail, okay?
Mr. Price should be back there. He's next. Who's handling Mr. Price's case? I don't have a lawyer written down on the calendar.
Myself, yeah, 88 hands.
Okay, I know who you are. Okay. Good morning, Mr. Price.
Good morning.
How are you?
Good.
Good. We're having the status conference in your case. I'm making sure that the state has provided all the discovery in your case and that your lawyer is ready to move it forward. Ms. Wood, do you believe that you've received all the discovery that you'd expect to get in this case?
Yes, Judge.
Okay. And Mr. Hand got you some offer?
Judge, we had discussed BHTC.
Mhm.
I'm not sure. I've asked Ms. Patterson to reach out. The last couple of cases that I've referred that are discharged, they've rejected based on the nature of the charge without conducting a follow-up interview. So Ms. Patterson is working on figuring out if there was a change in guidelines of some sort, because Mr. Hand and I thought that BHTC would be a great program for Mr. Price. So.
Okay. Yeah, please have Ms. Patterson check. And if she gets some kind of strange static, let me know and I will reach across, because that would represent a change. I know that the deflector shields would go up initially because this is a allegation of a crime of violence. But historically, especially for BHTC, but even on the drug court side, they'll drill a little bit deeper. And just from my part, the drug court part, it would be, he raised a stick in his hand because he was high. Well, it's the high. That's what we want to focus on. And we'll work through the anger management that might need to happen. So I think we can still move this to a trial calendar, but that doesn't take away the option of BHTC if we can navigate that situation. Mr. Price, it sounds like there are a couple of opportunities that you and your lawyer are trying to explore. I want to make sure we keep moving your case forward so you're not just sitting there in the jail, but we're getting you somewhere towards either some help or some other kind of resolution, okay? Do you have any questions about what we talked about? No? Mr. Hand, anything else from the state?
No, Your Honor.
All right, well, we will move this case to a trial calendar and we'll see if maybe we get you into accountability court. Thank you. Mr. Hawk, you are next up. If you could turn your video and audio on, please. Got to put batteries in that fire alarm. All right. Can you hear us, Mr. Hawk?
How you doing, sir?
I'm doing okay. It sounds like you can hear us. Who you got with you there?
It's my mom right here.
Hey, Mom. How are you?
I'm great. How are you?
I'm doing well. Thank you for getting your son on this call.
Absolutely.
Ms. Wood, this is your case. Do you have discovery?
We have discovery, Judge. We also have an offer.
All right.
I think this could probably move to a trial calendar. However, we've had some issues setting up an appointment for Mr. Hawk to come in. So hopefully we can get him in within the next week or two. But I think it's fine to move to a trial calendar at this point.
All right. Are there things Mr. Hawk and I should talk about in terms of issues for him showing up with an appointment so he can understand what needs to happen?
Yes, Judge.
So, Mr. Hawk, are you working or are you in school?
Yes, sir. I'm working.
How old are you?
I'm 18.
All right. What's your job?
I work at Wendy's.
What do you do at Wendy's?
I'll be on the grill and I'll be on the cash register.
All right. So you cook and you take money.
Sometimes I work days and nights, by the way, too, sir.
Meaning at the same time, like you'll do like a 12-hour shift or something?
No, so like it's just mixed schedule. Like sometimes she'll put me on the morning shift or sometimes she'll put me on night shift.
Okay. And she doesn't give you a whole lot of advance notice?
Oh, no, not really. Until I won't know until like a day or two before.
Got it.
But I'm about to get in to see my lawyer on like Monday or Tuesday.
Well, that's good because your lawyer's right here and she is very anxious to see you. Let me put her on the screen too. There she is. She's sliding over there. There's Ms. Wood. And she was sharing with me that she's had a little trouble connecting with you. And all I'm going to do is emphasize how important it is that you go connect with her. She is your number one advocate and has been talking with the prosecutor. And it sounds like there may be a way to work the case out. But of course, she has to talk with you about that and make sure you're comfortable with the direction she thinks the case should go. So I know you're busy with work. I'm glad you're working. But I need you to make it a priority in the next week to connect with Ms. Wood so that you guys can talk. Now, like you, she's busy. So I heard you say, hey, maybe Monday or Tuesday. It is entirely possible that next Tuesday, Ms. Wood is going to be with me all day long picking a jury because she's got other cases and we start a trial calendar next Tuesday. Not your case, no need to panic, But what I need you to do is work with her, call her or email her or text her saying, hey, this is Jeremiah's schedule. And then she can say, this is Ms. Wood's schedule. And we'll find out where they overlap. And then you get your little bottom over to her office so that the two of you can talk about the case. All right?
All right.
Good. I don't want to hear from Ms. Wood in a few weeks. Like I can't get this hot guy to come into the office. I'm not ordering you to do it. That's not my job. I would never order someone to talk to the lawyer. It's just going to make it harder for your lawyer to do a good job for you if you're playing hard to get. Okay?
All right.
And I will make sure that whatever day is available best for her, I did let her know that I will make sure that he gets into the office so that he's able to speak to her. Like,
fantastic.
I will let my job know also, and I told him to also let his job know that he would have to be out one day out of the week so that we can meet with her.
Yeah, and it's not like Ms. Wood is saying, I need to see you 6 times in a row, but there does need to be that we're going to spend a few hours together getting real serious about what this case is about, and figuring out which way to move forward on it. That way, then she can circle back to the prosecutor and more meaningfully discuss what Mr. Hawk thinks about the case. So you guys do need to connect, and I appreciate, Mom, that you're going to help out with that.
Yes,
but
sir.
it's not like you're going to need to take a whole week off from work or anything like that.
Right.
Mr. Hand, anything else from the state, or you're ready to go?
Nothing from the state, Your Honor. I'm ready.
Okay, sounds good. Mr. Hawk, do you have any questions?
No, sir.
All right. Ms. Wood, anything else on behalf of your client?
No, Your Honor.
We will move it to a trial calendar, but I understand there may be a non-trial resolution before then. All right, Mr. Hawk, you can go back to Wendy's. Thank you.
All right, thank you.
All right, that was the status calendar. Ms. Wood, if you would speak with Mr. Jones, still here, and Mr. Fallon. Is Mr. Trapadas here? He is, and I think Ms. Taylor is on. Ms. Taylor, you there?
am Judge.
With another great connection. All right, let's.
Oh, boy, yes. I'm here. I look, my emergency was not as bad as Miss Feely's. But sounds like this morning is the morning for emergencies.
Okay, are you okay?
I had to get in a spot that's not wet. And the plumbers are in there trying to work. So I'm good.
Okay. Well, what I'm going to do is turn your video off. We may get a better signal from you because we're getting the low internet or low bandwidth. So we'll do audio only right now for you. Mr. Trapadas, if you come up to the podium, that would be helpful. So let me tell you a little bit about what I understand is going on with Mr. Trapadas. And then, oh, am I mistaken?
Yes, I'm here. I'm from Mr. Kilgore.
Yes, she's working.
Oh, okay. Well, you know what? If you're going to do a plea, and I apologize for the cross wires. I thought you were Mr. Chapradas' lawyer. You are going to need to find a better internet connection spot or higher bandwidth because your client's going to need to be able to see you and hear you.
All right.
So you take a few and do that, and we're going to handle Mr. Chapradas' case, okay?
Thank you, Judge.
You're welcome. Who's your lawyer? Ms. Wood, you can sit next to Ms. Wood.
May I?
All right. This will be easier. So Mr. Trapadas had a federal case with which I'm familiar. In fact, I may have been involved with some of his federal case. I don't know that I need to recuse. If the state case is going to be resolved very simply because it overlaps very materially with the federal case. But I'm familiar with Mr. Trapadas from my time at the U.S. Attorney's Office. I don't remember enough for me to affirmatively say, I need to drop the case and recuse and get it to somewhere else. And so I'm going to not do that if there's an efficient way to handle it here. If it's going to get into substance and whatnot, then it may be most appropriate for me to recuse, just so Mr. Trapatis isn't concerned that, wait a minute, the judge is working with the FBI guys and this and that. I don't remember enough about it. He has a distinctive name. I remember that. And then I looked at the docket and Mr. Trapatis filed a pro se something saying, look, it's the same Bentleys. I'm like, oh, Bentleys, Trapatis. I know what this case is about. So his request back before, I think you may be plugged in, Ms. Wood, was, can't we do something? Because it's really the same case. I don't know that it's double jeopardy, but it sounds like there's some factual overlap. So I'm going to start with you, Mr. Hand. Can you let me know what your research into Mr. Trapatis's case has led you to think the state ought to do?
Your Honor, I have had only a brief moment to look into this. This is an add-on.
It is an add-on, and you've got a lot on your plate right now with the trial calendar and all.
Yes, Your Honor. I was looking into it and trying to figure out if they were materially similar. They do appear to overlap a bit.
What's the indictment number? It's an 18.
It's 16 SC.
16.
SC, Your Honor.
145311.
It's also because that is a while back, a file that I'll have to get from our archives, Your Honor. So I haven't had as much time to dive as deeply into it. I was talking with Ms. Wood about really only discussing rescinding the bench warrant this morning if he appeared, and then having him kind of booked in for the charges.
Right. I think Ms. Nelson shared some of that traffic stream with me. We do need to deal with a bench warrant. I can't let Mr. Trapatis leave with an active warrant. But the fact that he has walked in says to me that probably we can set that aside, but he will also need to be processed. It sounds like he's never been processed in connection with the indictment. So we can work through that. I guess then what I need to put onto your plate, Mr. Hand, is to have your team excavate this file, and then you can look into it more to assess whether for some or most of this same alleged criminal conduct, Mr. Trapatis has already served a sentence. I've been federal rather than state, but we'll need to sort that out.
Yes, Your Honor.
Ms. Wood, what do you want to add to the situation? And does Mr. Trapatis qualify for your representation, or right now you're helping out?
So when I became involved, he was in custody elsewhere.
So he certainly qualified.
Yes, Judge. We were under the impression you were released last weekend.
Friday, Your Honor.
Freshly out. How long were you in?
I've done a total of 6 years, a 24-month term for the for a supervised release violation, then a subsequent 5-year term that I satisfied on Friday, and they ran consecutive. They didn't run concurrently.
The 5 years was federal also, or for a state case?
Federal, sir.
Okay.
So I just did 51 months at the Robert A. Dayton Detention Center. And then prior to that, I did 24 months at Beckley in Beckley, West Virginia, at the FCI there. So.
And home is the Atlanta area, or you came here just because you've got this case?
No, Your Honor, home is the Atlanta area.
Okay. All right. So back to you, Ms. Wood.
So Judge, I know he's very eager to get this resolved. But first and foremost, the warrants are priority. And then if a round trip order is needed, I'm happy to get that for the court today.
Sure. I heard you say plural. Is there more than one warrant, or it's just warrants because there's more than one charge?
Yes, in Odyssey, if you look at it, it shows as like 9 active.
Okay.
That's just the electronic warrants.
Okay.
Because they're 9 counts? Okay. We will make them all go away. When you say round trip order, what does that mean?
I don't know if it's still called that. There used to be an order that you could do so that when he gets arrested, when he gets to the jail, he could basically book in and book
and book out. I'm happy to sign anything to that effect. It seems like getting Mr. Tripatis immediately on bond is appropriate, given the nature of the charges and that he may have already served whatever sentence he's going to get for this case, if this case results in any kind of disposition. So if you want to look into how that works, I'm happy to sign that today. Mr. Tripatis, you do have to go into custody, but it's only because you've never been arrested on these charges. So you have to be booked in. And I'm happy to make plain to the sheriff that you should then be booked out, right? I mean, sort of like, here I am and here I go. We just need to get a bond in place because they can't release you if there is no bond. And I don't know if let me look here. I think I put the bookmark in the right place. So burglary is not a unsecured judicial releasable offense. And that is the first charge in the indictment. So Mr. Tripatis would have to make some bond. I'm happy to make it a bond he can make through the sheriff's 10% program so that whoever puts it up can get that money back minus some fees. If you'll just chat with him about what that amount is going to be. And then we'll obviously need an address, where he's staying, that kind of stuff.
Thank you, Judge.
So why don't we do this? For now, I'll keep the case because I can get, since we're all here today, take care of the round trip order and the bond. If you all decide I should recuse, I'll respect that. But that would just leave Mr. Tripatis in jail for a while. So I think right now it makes sense for me to keep the case. And my suggestion is we leave it that way while we give Mr. Hand a chance to have his team research whether this is a case the state even wants to go forward with anymore, based on the time that Mr. Tripatis has already served for what looks like to be a related situation. And we can put this on an, I guess we'd put it on a plea and arraignment calendar. And, or do we want to just do that now? We could do plea and arraignment now. Yeah.
So just change to open and you can go ahead.
Yeah. So why don't we do the waiver of arraignment, however you and Mr. Tripatis want to work that out, so we can keep the case moving. But we'll put it on an inquiry calendar rather than wait all the way for a status. Not too far out to get that report from Mr. Hand. And that can just be your reminder, because you may, Mr. Hand, look at it, talk with a supervisor and say no pros, and just file a no pros. And that's what we do. I want to be clear. I'm not encouraging that at all. You may look at it and say, this is going to be my first big trial. And okay, maybe it will be. And then we'll keep moving the case along. My priority right now is to get Mr. Tripatis processed and out on bond. And then it will be to get that answer from the district attorney's office as to whether it wants to pursue this case any further. If the answer is yes, it does, at that inquiry calendar, we can revisit McBurney recuse, McBurney not. But I'll make it easy. I won't ask either side to learn from another judge. That I'll enter an order that will automatically recuse me after a certain amount of time unless, I got to remember how it worked. There is a joint motion not to, because that way no one has to be identified as the one who says, I think you should recuse. It won't hurt my feelings either way, but not supposed to put the onus on anyone to do that. So that's a little ways down the road. Don't worry about that. You need to do some homework, Mr. Hand, on this when you're able. And Ms. Wood, your short-term project is to figure out what I would sign that would have Mr. Tripatis process through there as quickly as possible, consistent with posting whatever bond we end up setting.
Yes, Judge, I'm working on that now.
Okay, that's fine. So Mr. Tripatis, you actually can't go anywhere. I'll let Deputy Gordon decide whether you sit in the jury box or you go back into lockup right now. I'm not going to have you leave here till I let you know what the bond is, because you need to hear that. And you need to hear the conditions that you'll need to reside at whatever your address is, et cetera. So we'll talk at least one more time today. Any questions about anything I brought up?
No, sir. I just appreciate finally being able to get in front of you. I know I've been zealously writing everyone and filing IADAs and everything else I could get here.
You have been filing what you needed to file, and at long last, we've reconnected. So let's process that one this morning as well. Deputy Gordon, do you need him to go in the lockup? Okay, just go sit in the jury box.
Okay.
And Ms. Wood will be working with you. She's got two other folks she needs to help out this morning. I'll come back out when we've got a plan for whatever it may be for Mr. Jones and Mr. Fallon and Mr. Trapadas.
Thank you, Judge.
You're welcome.
My bag and my.
Yeah, and just take it with you over there. So for this one, is that what it is?
Oh, yeah.
Is it 12
So,
months?
yeah, but I wanted to talk to you.
Okay.
You still got-
Yeah. we can-
Mr. Abate, good morning. Are you part of Court Watch? 1 o'clock. You bet. I figured you didn't have anything else to do anyway. You could just sit here, but no, 1 o'clock. You're welcome to stay. The benches aren't the most comfortable. You bet. All right.
Oh, I want to get, I'm just having a sense for it.
Okay, that's good. Okay. I just didn't know if we needed something to go with him.
No, I didn't.
Okay.
Okay.
All right. I'm gonna go do some other stuff and I'll come out when you say, please come out.
Judge, is my internet better now? Can you hear me better?
I can hear you better. Can you turn the video on? Let's see what it says.
Okay. All right. I actually came and sat in the car because they got turned it on. Because like I said, they're actually working on the pipes and they've done something with my electricity in the house. I had a plumbing problem this morning.
Got it. Sorry to hear that. So I'm trying to figure out what we're doing with, you've got a plea?
Yes, Judge, we have a negotiated plea of Mr. Kilgore.
Okay, yeah, your internet, I would give maybe a fair to middling level. But with who has Kilgore from the state? Do we know? Mr. Whitenauer, okay. Is that on I don't have any.
It's on the Outlook.
It's on the Outlook.
Pull it up.
Got it. No, I can pull it up. So that's, there it is. Okay, the indictment. And Mr. Kilgore is in lockup, so he's in custody. Okay. We can do that plea in about 15 minutes, if that works.
That's fine, Judge.
Okay, I need to, because we wrapped up everything else, I have to, at 10:30, address a group for about 2 minutes on Zoom, and then I'll come back out here and we'll start with Mr. Kilgore's plea and then follow up with whatever Ms. Wood may have. Even if she's not ready yet, we can certainly do Kilgore and Ms. Wood can continue to talk with her clients.
All right. And I understand there may be some issue. Judges, did they have a phone number or any way I could talk to Mr. Kilgore?
So Mr. Kilgore will be here in court. We could, if you need to speak with him privately, just get everyone else out of the courtroom. That's going to be a little complicated. It's not impossible. So hopefully you and Mr. Kilgore, I mean, the deputies would still be in the courtroom. He couldn't be left alone, but we could certainly get the prosecutor out of the courtroom and I could have the Zoom not broadcast everywhere, but
I need about 2 minutes, Judge, with him, and that'll work.
Well, that's going to be more complicated. I thought you said only in an emergency. So you need to talk to Mr. Kilgore no matter what?
No, Judge, I do not. I do not. It can wait. I mean, we can do it when we do the plea. It's okay.
Okay. We're going to handle it that way. He's still downstairs? Okay. Well, we got time. I'm going to leave the bench for about 10 minutes. And once I do this thing I got to do, we'll come back out. If we could do Kilgore then, we've got Mr. Whitenauer, we've got Ms. Taylor, and we'll do that. All right?
Thank you, Judge.
You all are welcome.
That's been me the whole time. Jesus.
What were they coming to the courtroom?
It's going on because ain't nothing showing up on the civil cruise. I don't know what to go through. You stay at this court. Citizens might just sign one, just send it to jail. Can't tell you, but no, I'm telling him. You want to tell you that? Yeah, I want to drop down quick. I know. No, not the way. Yeah. It should be a lot of them down. Should be a lot of them down.
So we need you. Oh, you by yourself? They move with you? Really cool. Okay. All right.
Hey, we just put you back here until we come back up. Okay.
You might move him out of there since he's been going to put him on that.
You just put the bag right here. I ain't gonna go.
I ain't none of this. I'm 97.
Take no plea for wrong reason.
I think that like also maybe a program for him. I don't know. So maybe so yeah, whenever the judge gets back out, and I'm working on this ground reporter. So if someone sent me one, I will.
Is there a reason why he wants to appeal? Like, is there,
I don't have any of the stuff, so it's hard for me to like go through and tell him. So yeah.
Okay.
So yeah.
Okay.
Thank you. here's who he is.
And for the homeless program, it's not okay.
I don't feel like, I just don't know what he's gonna be able to. So. Hold on, stand by. Do you have a question?
Yes.
Okay, let's go back outside, right?
Hey, Pierce.
Mhm.
So I was looking back on this Castillo and
Oh, yeah.
Santiago
Mhm.
case. And then I do see that there's a photo lineup and then also see that there was a search warrant for the phone. So I can follow up with them.
Okay.
About that.
Okay.
I've also reached out to my friend who works for Department of Homeland Security about the victim, the Castillo being in detention center.
Okay.
See if we can locate him. Obviously.
He's in the per his daughter, he's in the Dayton Center thing. I haven't confirmed that, but
That's what he's working on.
Okay.
And so obviously we have to work through him recanting
Mm.
and him
yeah.
potentially being in proceedings for deportation.
Yeah. So I was going to, or at least I was already reaching out to my investigator to figure out how do we even communicate with him about the matter. Like, does that mean visiting? And okay. And I think that's like Lovejoy. So it's like away, a ways away.
Yeah.
Like, I feel like we're kind of public defenders at this point.
Yeah, we have to take a little ride.
Yeah. Because I'd be interested in how that complicates our matter as well. You know, being that.
Is recanting or just being?
Well, the canteen, I think that part's clear. It's just so him being in custody. Like, how does that?
No, we just have to get a production order.
Okay.
I'm brought here for trial. If this does go to trial.
Okay.
I mean, I'm not too worried about him recanting. We can keep him
Yeah.
until you know.
Yeah.
I mean, that's fine.
Okay. Okay.
Yeah.
Okay. Yeah. It's bad what happened about Feely this morning.
Yep.
Don't know how that's gonna impact trial calendar.
I can't imagine we'll be making those cases go forward.
Yeah, I agree, and that's fine, kind of.
Why?
Well, it's the cases behind those cases.
I know.
That I'm like,
That you're referring for someone first to go?
yeah.
Yeah. So it's a lot. I have this calendar and a Dunaway trial calendar next week.
Yeah.
And, I wish we just had some more certainty about.
Yeah, like what's up? What's up? I'm like, is that what you're gonna say?
Yeah, just what, yeah, I mean, I know they say, well, you know, this case has been in your office for a year, well, or more. Yep, that's true. I've only been in that office for, 3 months. I'm in trial for, 1 week, just.
Yeah, it's like you've been doing constantly like putting out fires.
Yeah.
Yeah.
So.
Fine stuff.
Yeah.
That's the one that looks, well. Anybody done it? Not that one. The next station. They don't want to see. What time they come up, Gore? Gore. What time,
Maybe you got photos. Oh. No, for real. You go over.
some broccoli.
You don't go do,
Oh, I think I'm mistaken.
Yeah, yeah.
I the one that was on the.
you got some leaves.
What could be done?
I don't know, but I have a massive.
Somebody else. Well, for the order. 19.
All right, let's see what's happening. Zoom, we have Ms. Taylor. Before we turn to the Kilgore plea, which we were going to do, Ms. Wood, if you could give me what updates you have on the three cases still rattling around. Mr. Jones.
Judge, I did speak with Mr. Jones and I conveyed the most recent offer. He would like a little more time so we can actually speak with Ms. Feely.
Sure.
So we would just ask that he be able to move to a future court date to handle that.
Sure. So, Mr. Jones, that future court date will be a trial calendar. That doesn't mean you're going to trial. It may well be you still work the case out. In fact, if you and Ms. Feely talk about it and you reach an agreement, we can have you come in whenever. I'm a big fan of taking pleas well before the trial calendar because the trial calendar is congested and 9 million things going on. So Ms. Feely, as you can likely understand, is going to be out of pocket for a little bit. But when she is back in action, you two should speak. And if it's something that's worked out and Mr. Hand is ready to go, then we'll get you in here because you're on bond. We could do it almost any time, take that plea. But the next stop for your case will be an upcoming trial calendar, okay? Any questions about that? Do you know how to reach Ms. Feely?
She gave me all.
Good, okay. Do you need Mr. Jones to stick around anymore?
No, Your Honor.
Mr. Hand, anything else on Mr. Jones's case?
No, Your Honor.
All right, we'll move it to a trial calendar. How about Mr. Fallon?
Judge, I had a lengthy discussion with him and he wishes to move forward to a trial calendar.
Okay. Mr. Fallon, you understand that after today, you may still enter a plea. I'm not saying you need to or have to or anything like that. But today, if you entered a plea in your case, and I were to sentence you more than what your lawyer asked for. So let's say she asked for probation and Mr. Hand said, no, Mr. Fallon needs to have some jail time. And I sentence you, I'm making all this up, to 6 months in jail. You could withdraw your plea. You could say, no, thank you. I was willing to take what my lawyer asked for, 5 years probation, but I'm not willing to go to jail. And today, by you saying that, I'd say, okay, well, you can back out of it and we'll still give you your trial. After today, you can still enter a plea, which is often in a defendant's best interest because you really want the jury to hear everything that happened. But you won't be able to withdraw your plea if the sentence that I give you is more severe than what Ms. Wood asked for. So if it's that same situation where she helps me understand why she thinks probation is the right outcome for you, Mr. Hand helps me understand why there should be some jail time. Maybe I hear from the alleged victim in the case. And I think, you know what, Mr. Fallon, he's going to need to do 6 months in jail. You're stuck with that sentence. You don't get it back out of it after today. Today, you can back out if you want. After today, whether you go to trial or you plead, if there's a sentence, that's the sentence you get. You understand what changes after today?
I kind of understand some of it. You on I understand that, but I can't accept nothing that I'm not guilty.
Okay, and I'm gonna interrupt you. I know that's not polite, but what you say makes a lot of sense. If this is a case where you and Ms. Wood are saying, why would he plead to anything? Because he didn't do anything, then we're heading you in very much the right direction. Because the next time I'm going to see you is a trial calendar. And at that trial, the state has the burden of proving your guilt, if it can, by a pretty high burden, beyond a reasonable doubt. And that's when Ms. Wood would be able to argue to a jury, they got the wrong guy, or it's the right guy, but nothing happened. The alleged victim is lying or exaggerating or whatever the defense is going to be in your case. So I want to be clear. I'm not encouraging you to do one thing or the other. I just need to make sure you understood that by saying no thank you to the state's offer today, you're just giving up that one right to withdraw your plea if you don't like the sentence I give you. But you will get you a trial. You may decide that you do want to plead because the state reduces something, but all that stuff can happen later on. I just need to make sure we keep moving your case forward, and that's what we'll do, okay? All right. Do you need Mr. Fallon to stay around, Ms. Wood?
No, Your Honor.
All right, Mr. Fallon, you are free to go.
Okay, sir. Have a nice day.
You too. Let's turn to Mr. Kilgore. Can we bring him out to the podium, please? Yes. You too. Yes, please. If you go to the, are you okay standing up? Okay, if you go to the podium. Right there. Whoop, perfect. I'm gonna get this set up. I just gotta send this one message. right, and let's do that. Okay, Ms. Rivers, are you ready?
Yes, I am ready.
Great. We are going to move forward with a plea in case 22 SC 182810. It's State versus Reginald Kilgore. That's you, Mr. Kilgore?
Yes, sir.
All right, Mr. Kilgore, you are charged with aggravated assault and aggravated battery. Ms. Taylor, your lawyer, is appearing virtually. You can see her on the screen there. You have a right to have your lawyer right next to you so that you can consult with her if you've got questions. But you can waive that right so we can go forward with the plea, knowing that Ms. Taylor is able to see you and hear you, see me and hear me. So she's actively participating. She's just not standing right next to you. Are you okay going forward in that format?
Yes, sir.
Mr. Kilgore, it's real important that if at any point you have any questions for me or for Ms. Taylor, you let me know that. I'll do my best to answer them. If in the off chance you need to speak privately with Ms. Taylor, we can try to set that up. It's a little complicated, but we can basically get all the lawyers out of the courtroom. And then you and Ms. Taylor could speak privately. But if it's just sort of a, wait, what did that person say? Or I don't understand what that word means, let me know. And one of us will do our best to explain it to you. Will you do that?
Yes, sir.
Okay. Mr. Whitenauer, who's the prosecutor on your case, is going to put you under oath in just a moment. Once you're under oath, please answer all of his questions truthfully and completely. And again, if at any time you don't understand what's happening or something confuses you, let me know. All right. When you're ready, Mr. Whitenauer.
Yes, Judge. Sir, if you'd raise your right hand, please. Do you swear affirm the testimony you're about to give in the matter pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please lower your right hand. Please state and spell your true, correct, and legal name.
Reginald Sherrod Kilgore, Reginald Kilgore.
Please state your date of birth and your age today.
11/4/71. My age is 50.
And are you now under the influence of any medicine, drugs, or alcohol?
No, I'm not.
How far did you go in school?
Graduated
Graduated what?
12th grade.
And can you read and write in the English language?
Yes, I can.
Have you had an opportunity to review the document that charges you in this case, that is the indictment?
Yes,
All right. Do you fully understand the nature of the charges pending against you?
yes,
By pleading guilty today, you are giving up certain rights. I'm going to read those rights to you, and after each one, if you please acknowledge that you understand that you're giving up that right. Today, by entering a plea of guilty, you are giving up the right to a trial by jury. Do you understand?
yes,
The right to be presumed innocent,
yes,
the right to confront any witnesses who may testify against you,
yes,
the right to subpoena any witnesses for your defense,
yes,
the right to testify yourself and to offer any other evidence in your defense,
yes,
the right to have an attorney to assist you throughout the trial proceedings,
yes,
and the right to not incriminate yourself.
yes,
Again, do you understand that by entering a plea of guilty today, you are giving up all of those rights?
yes, sir.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by a jury?
Yes,
Today, you're entering a plea of guilty to the two charges in the indictment. On count one, aggravated assault, family violence, that carries a sentencing range of 3 to 20 years in confinement. On count two, aggravated battery, that carries a sentencing range of 1 to 20 years in confinement. Do you understand?
yes, sir.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, I'm not.
Do you understand that this is a negotiated plea?
Yes,
Do you understand that the state is going to recommend to the court that you be sentenced to 8 years to serve 6 months with credit time served? You've already spent 184 days in confinement as of today, with the balance on probation with certain special conditions.
yes,
Do you understand that the court is not required to follow that recommendation, but can sentence you up to the maximum sentence by law, which would be 40 years in confinement? Well, I think, Your Honor, that aggravated assault would merge into aggravated battery by the way it's charged. So I think that it would be 20 years in confinement. Do you understand?
yes, sir.
Do you understand that, however, if the court does not accept this negotiation, you have the right to withdraw your guilty plea today?
Yes, sir.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. Do you understand?
Sir.
You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. There will also be special conditions that the state will be recommending, and those are that you have no contact with the victim in this case except for the purpose of child care, including the exchange of custody and the discussion of the children's education and medical issues and the like. That during custody exchanges, that there be no violent contact with the victim or the minor children, that you otherwise stay away from the victim's residence and place of employment, that you submit to random drug screens and alcohol screens monthly for the first year, and then at the probation officer's discretion, that you possess no weapons, that you submit to a mental health evaluation and comply with any treatment as recommended, that you attend and complete an anger management program, that you attend and complete a parenting class, that you obtain your GED. Well, you indicated that you've graduated from high school, and that you maintain gainful employment. Do you understand that those are the special conditions that the state will be recommending to the court?
Yes.
Are you entering your plea of guilty with an understanding of everything we've just talked about?
Yes.
And also, let me ask you, do you understand that a violation of any of those conditions that were just mentioned could lead to a revocation of your probation?
Yes.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No.
Are you satisfied with what your attorney has done for you in this case?
Yes.
Do you have any more questions for your attorney before we go on?
No, I do not.
Have you understood everything I've asked you so far?
Yes, sir.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
How do you plead?
Guilty.
Is your decision to plead guilty made freely and voluntarily?
Yes, it is.
Are you a United States citizen?
Yes, I am.
Sir, I have to inform you of some filing timelines. If you wish to challenge this plea for legal error, you have one of two ways to do it. Your attorney can explain what these ways are and how they work, but I have to advise you of those time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file a direct appeal. The second way is a habeas corpus petition, and for these two felony counts, you have 4 years from today to file a habeas corpus petition. Do you understand these time limits?
Yes, sir.
Your Honor, if this case were to proceed to trial, the state would prove beyond a reasonable doubt that on or about December 14th of 2021, officers with the Atlanta Police Department were dispatched to 1177 Constitution Road, which is located in Fulton County. There, they encountered the victim in this case, Arlanda, that's Arlanda, Cookendall, that's Kuykendall, who had her arm wrapped in clothing with visible blood on it. She advised that she needed the paramedics because she was bleeding, and that bleeding was caused by an assault by the defendant. The two of them had been in an argument, and during that argument, the defendant picked up a hedge trimmer and struck Ms. Cookendall with it while she was attempting to block and protect her face. It made contact with her forearm, causing a laceration. At that time, the defendant wrapped the victim's arm with a piece of fabric and fled. Officer showed the victim a picture of the defendant, and she identified him as the individual who caused that laceration to her arm. Grady EMS took the victim to the hospital for stitches. Your Honor, I've spoken with the victim. She advised that she had been in a relationship with this defendant for about 13 years, and during that period, he beat her, that he was controlling and had an anger problem and wanted him to have a psych evaluation. I spoke to her about the state's proposed resolution, and she was in agreement. She does want him to have contact with the minor children, but does not want to have any other contact for any other purpose beyond that. She did indicate some interest in attending today. We did provide her with the Zoom link, but this morning and following up, we've not yet seen her on the Zoom. So she may have not been able to attend for whatever reason. This defendant does have a criminal history here in Fulton County and in Clayton County. First in Clayton County in 1993 for VGCSA, 1995 for VGCSA in Fulton, and 2000 for VGCSA in Fulton, and 2011 for VGCSA, that one specifically possession of cocaine here in Fulton. Your Honor, we are asking that you do sentence the defendant to 8 years to serve 6 months, credit for time served. The balance on probation with those special conditions previously mentioned, he has been in for 184 days as of today. And I do think for purposes of sentencing, count 1 merges into count 2.
Okay, thank you for all that. Let's start with merger because that's where you ended. I didn't think so at first, but for whatever reason, the aggravated battery has added an element of the nature of the relationship between Mr. Kilgore and Ms. Cookendall. And so I do think 1 merges into 2. Otherwise, it had a unique element because it was family violence aggravated assault, but your colleague effectively charged family violence aggravated battery, with which I'm not familiar, but it's in there. So I will merge them when we get to sentencing. I've got some questions for you, Mr. Kilgore, but I want to hear from Ms. Taylor. But before that, let me hear from folks at pretrial. Does Mr. Kilgore have any cycles more recent than 2011 that aren't this case?
Yes, Judge, he does. He does have an open misdemeanor case for battery family violence, same victim, 20 CR 00598F. My Odyssey is running slow. I'm trying to pull up the order to see if it was a stay away on that case.
Okay. And that was 20 CR 00598F?
Yes, Judge.
Okay.
Sorry, Judge.
Go ahead.
Your Honor, I also neglected to mention that the victim in this case, she was also arrested at some point for an aggravated assault for a May 7th, 2021 incident in which the defendant was listed as a victim. However, I'd also note that the grand jury no-billed that indictment on February 1st, 2022.
Okay. Got it.
Judge,
Yes, ma'am.
December the 20th, 2011, Judge Law signed a no further contact with the victim, no weapons, no firearm. Stay away from 1177 Constitution Road, Atlanta, Georgia. And that case is still open.
Okay. So it's a little more complicated, Mr. Kilgore. There is a stay away order that, well, I guess it's somewhat consistent. Your home is not that address on Constitution Road, or is that your home?
No, that was my home. She was not supposed to be there.
Well, a judge from state court has told you have to stay away from that address on Constitution Road. When you get out, where are you planning on?
No, I don't stay there no more.
Okay, good.
No more.
You've got a different address.
Yes, sir.
Okay, all right. Thank you, Ms. Bostic, for that. Let me hear from Ms. Taylor, please.
Good morning, Judge. Can you hear me okay?
Yes, ma'am.
On behalf of Mr. Kilgore, Judge, and just to kind of piggyback on the last part there, Mr. Kilgore had been living at that residence for quite some time. So that was his residence, and there was a stay away. But like I said, he that was his residence, and she came back to his residence. Also, Judge, as the state, there was a case pending with him as the victim, charged with aggravated assault. I wasn't even aware that there had been no bill in February. So this has been that kind of situation. Mr. Kilgore is stepping up to the plate, Judge, and accepting responsibility for the incident that happened on that day. Obviously his residency of the facts are a little different from hers, but he is accepting responsibility for the incident that day. He wants to move on forward. Ms. Cookendall has also moved away. I think she actually lives somewhere, but bottom line, they would not be living together. Mr. Kilgore would be going to a different residence once he is released. Judge, the plea is negotiated, and that says Mr. Kilgore has his own business. He has a business, Judge, where he does truck washing by a truck for truck landscaping business. He has some children, his Cookendall, but he has adult children, 50-year.
Sorry, I'm having
and
Yeah, Ms. Taylor, you're breaking up a little bit. You said he's got adult children as well as minor children?
yes, he has adult children, and the minor children with Ms. Cookendall.
Got it.
So Judge, while the plea is negotiated, I did want to indicate that the mental health part is something that I was report about, in the sense I heard this indicate that she said something about mental health. Mr. Kilgore never had a mental health issue, and I'm not going to demean the victim in any way in the case, but I don't think she's the judge of anything like that. He has not had a case since 2011 until the incident with her in 2020, which is still pending in state court. He has entered a plea of not guilty in that case. I don't think mental health is necessary. I heard the state also indicate that they special condition of probation, monthly drug and alcohol screens for the first year. I'm not necessarily opposed to it, but I don't think that is necessary. I think probation makes the decision as to when they want to screen. They do random screens anyway. When they want to screen, again, Mr. Kilgore has not had any problems since 2011. So we're talking about more than 10 years ago. So I don't think that is a necessary condition, but it's the court's discretion. All the other terms, Judge, the probation, obviously we recognize that there's a need for, and always in these type cases, the domestic violence intervention program, parenting, if the court feels like that's necessary. Again, this is a 50-year-old man with adult children, and now these minor children with Ms. Cookendall. He has been in custody, judges, the state indicated, more than the 6 months. So we were saying the 6 months obviously reduced the time served and whatever other conditions the court wants to place. Mr. Kilgore been in jail now for this period of time, and he's ready to resolve the case and move on forward with his life.
Thank you, Ms. Taylor. Mr. Kilgore, how many children do you have with Ms. Cookendall?
3.
And what are their ages approximately?
5, 4, 5, and 8.
4, 5, and 8. Boys, girls,
2 boys and 1 girl.
and they live with Ms. Cookendall.
Yes,
Is Ms. Cookendall your age, younger, or older?
she's younger.
A lot younger?
She's 34.
34. How'd you meet her?
Just a random date.
Okay. But a bunch of years ago, because you've been together
14 years.
Okay. And then you have adult children through another relationship.
Yes, I have 3 more. I have a 27-year-old, I have a 25-year-old, and then I have a 16-year-old.
Okay. That 16-year-old stays with his or her mother?
Yes.
And that's not Ms. Cookendall?
No.
All right. I think I understood, Ms. Taylor, you do work cleaning trucks?
Cut trees. My main business is cutting trees.
You're a tree cutter?
Yes.
Do you work for a place like Gunnison, or you have Kilgore Tree?
All around professional landscape.
Okay. Is that your company?
Yes.
Who's been running it over the last 6 months?
No one. The thing I'm gonna have to get done is now, because the business license was in her name, is I got to change everything.
You do? No more licenses in Ms. Cookendall's name? Okay, so you're gonna restart that business?
Yes.
And you have a place to live when you get out?
Yes.
Okay, and that's not with Ms. Cookendall? Okay, and you're wearing an orange jumpsuit. Is that because you were in Cobb County, or? All right, and you've been in these past 6 months only on this case or in connection with something else?
Just this.
Just this case, okay. Mr. Kilgore, we don't pass around the indictments anymore for people to sign them. Do you authorize my staff to sign your indictment indicating your guilty plea?
Yes, sir.
And Ms. Taylor, may we sign for you?
Yes, Judge.
And Mr. Whitenauer?
Yes, sir.
We'll take care of that. Mr. Kilgore, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. Knowing means you've understood all the things the 3 people, Whitenauer, Taylor, and I have been discussing. Is that a fair statement?
Yes, sir.
Any questions about anything?
No, sir.
Okay. Voluntary just means no one's forcing you to do this. You've decided after consulting with Ms. Taylor that it's in your best interest to go forward with this plea. Is that correct?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a technical violation, something small, you and probation will work that out. But if it is a substantive violation, that comes back to me. If you're
Like, one quick. Talking about, when you say something like drugs or something?
No, good question. Not, because that's a good example of a technical violation. I'm going to have you submit to drug screens. If you tested positive for, just hear me out. Let's say you tested positive for cocaine. You're not going to come back and see me. It may be that probation says, all right, you need to go to some NA meetings or get some treatment or something, but that's probation. By substantive, I should have said this, bigger or more serious violations. If you get arrested for anything, that comes to me. If you have contact with Ms. Cookendall, if she has a little video from her phone and you're coming at her with a hedge trimmer, not only are you going to have a new case, but you'll be back here lickety split. And without a trial, you get a hearing and Ms. Taylor can be here for you, but with a much lower burden of proof, the state could show that you were having violent contact with Ms. Cookendall. I'll tell you what's going to happen. I'll revoke every remaining minute of your probation. So that would be what I mean by a substantive violation. It's going to be in your best interest to head in a very, very different direction from Ms. Cookendall, with one exception. It's really three. It's your kids. You may still want to have an active presence in their life. And that will necessarily mean that you will intersect with Ms. Cookendall, but it will be, I'll pick the kids up. You drop the kids off. It's not, hey, let's the five of us go to Wendy's or the park. When you're with the kids, she's not around. When she's got the kids, you're not around. You and she, Ms. Cookendall, aren't going to be doing things together other than handing the kids off.
Well, may I speak?
You may.
So the thing I'm gonna be doing is, I'm gonna be filing custody for them anyway, so.
Great.
If I get through, with everything I got to do, because in the best interest of the kids, not getting into any details or anything like that, I know that I am the sole provider. For the past 14 years, I the one been doing everything. No job for her, no nothing. It's just being me. And
okay. You will go about that the right way. You'll come to Fulton County and there'll be a judge who will determine custody and all that. And you may be exactly right. That'll simplify things. You won't need to interact with Ms. Cookendall to spend time with your kids because they'll be with you. Yes, so you'll navigate that. But until that's resolved, that's really the only reason why you're interacting with Ms. Cookendall is to get access to the kids.
I let her do it with my mom. I'm not going to.
Even better. That's I won't require that, but if your mom is the intermediary, so she swings by, gets your kids, and then you're with them, that's cleaner.
And they in Columbus anyway, so.
Okay, so Ms. Cookendall has gone down to Columbus?
Yes.
Okay, got it. So I'm going to sentence you, first of all, count one, I find merges into count two. So there's really only one count of conviction. That's the aggravated battery. And in that case, I'm going to sentence you to 6 years. I understand the recommendation was 8, but 6 years to serve 6 months. You'll get credit for the time you've been in. So it sounds like you served 6 months. The sheriff's going to have to verify that, but you ought to be released in the next couple days. If it is Tuesday of next week and you're not out, you call Ms. Taylor, she'll call my staff, and we'll figure out why you have not been released. It ought to happen over the weekend, but things move more slowly on the weekend. So if it's Tuesday, you're still in the orange jumpsuit and not in the all-purpose landscape or whatever your company name outfit, call Ms. Taylor, and we'll help out with that. The balance will be probated, so you're going to be on probation. Yes, Ms. Taylor?
I'm sorry to interrupt you. I was going to say he's already done, I believe, 184 days. So he's done the 180 days. So that would be 6 months. So this should be a reduced to time served sentence.
It's not reduced to time served. It's to serve 6 months, credit for time served. I believe that you're accurate. And that's what Mr. Whitenauer said as well. But I'm not the mathematician. It's the sheriff. That's why I flagged that for Mr. Kilgore. Like you, I believe he ought to be released tomorrow, but tomorrow's a Saturday. And so I don't know that you'll necessarily be processed out on Saturday. I'm going to repeat the sentence. It's 6 years to serve 6 months, balance probated, credit for time served. And you've done 6 months and a few days, so you ought to get out right away. Several special conditions of your probation. And that word special simply means that if you violate that condition, that's one of those substantive things I mentioned, and I could revoke all your probation. Number one is no contact with Ms. Cookendall except in connection with childcare. So you don't write her, you don't call her, you can serve legal papers on her, but you're not showing up saying, hey, let's go get a bite to eat. If she documents that you're calling or writing her about anything other than the kids, that's the kind of thing that could get you revoked. That means staying away from her. So if she lives down in Columbus, you don't need to be in Columbus. No reason to be down there. You'll need to submit to random drug and alcohol screens 2 times a month for the first 6 months of probation. If all 12 of those are clean, probation can say, let's not do this anymore, or we'll do 1 a year or something like that. But it's going to be 2 times a month for the first 6 months of probation. And last but not least, you'll need to complete what we call a family violence intervention program. It's a series of courses. It's not one class for 5 minutes, but you meet, I think it's like 12 weeks. It's only 1 time a week. It's not like going back to college, but it's a series of classes that touch on all the things that I heard Mr. Whitenauer talk about, which is parenting, anger management, how you manage your personal relationships. Something about you and Ms. Cookendall was passionate. You had 3 kids, but it was also tumultuous because it sounds like she got arrested for pounding on you, you got arrested for pounding on her, and neither of you was managing that relationship in a healthy way, especially if it was in front of those kids. They ought to never see one parent strike another or just get real verbally violent with another. So family violence intervention program will help with that. And that is it. I want you back on your feet, running your business, taking care of these kids. If you're the primary or the best provider for them, let a judge get you that custody. Stay away from Ms. Cookendall. You got 50 more years to head in a different direction. And I hope that's how it works out for you. Okay. Mr. Whitenauer, anything else for Mr. Kilgore?
Nothing to say.
Ms. Taylor?
Nothing else, Judge.
Oh. Okay. Ms. Tucson, what information do you want to get from Mr. Kilgore and do you need to give him?
Well, if it's easier, I could get all his information from Mrs. Taylor. If that helps, I'll need his address and phone number.
All right.
And what county he's going to be living in to give him reporting instructions.
All right.
I don't have a current address for him, so he may need to give you that information.
All right, let's do that right now. Are you able to write it down, Ms. Tucson?
I am.
All right, Mr. Kilgore. Yes, sir.
Only thing about it, is questions for Ms. Taylor. My kid's mom. She said she sent you the address.
No, I don't have an address from her.
Can you?
I can. You know, you talking about a local address for you?
Yeah, Clayton County. Yeah, it's gonna be Clayton County. I forgot the address.
I'm sorry. You know what? And you're not talking about Ms. Cookendall. You're talking about your other children's mother.
Yes.
So why don't we do this then? It sounds like Ms. Taylor has the information, so I want to free up everyone else. Ms. Tucson, if you and Ms. Taylor would coordinate, you'll be able to get that information. It sounds like Mr. Kilgore will be in Clayton County, so you'll be giving him Clayton County reporting instructions, okay?
Correct. That'll be in Morrow, Georgia. May I have your phone number, Ms. Taylor?
It's 404 370 0440.
404-370-0440.
Yes, and Ms. Cook, can you put your email in the chat? For me.
I sure will.
And then I can also email you as well if you don't. I'm sorry, I have it. It's 2903 Botany, BOTANY, Botany Drive.
I'm sorry. I must have missed that because I was typing in my email address.
Yeah, Ms. Taylor, let's not do it in this format because you're hard to hear. So I'm going to have Ms. Tucson give you a call. That'll be a better connection. You guys can exchange that information and we'll get it to Mr. Kilgore, okay?
Okay, now I also gotta put it in the chat to Mr. Tucson, Judge.
Great. Sounds like a plan.
All right, thank you.
Thank you, everyone.
Bye.
Bye. So if you are not out by Tuesday, you call Ms. Taylor and we'll figure out what's going on.
Sure.
All right. He's good to go.
Judge, I believe that concludes my business. May I be excused.
You may indeed. Thank you for helping with that.
Yes, sir.
Let's talk about Mr. Trapatis. So it's getting complicated. Do we have any more thoughts about how to work through his situation? The sheriff is saying there aren't,
I don't know why they're not on the verdict, because I put that out in the system. So if the city is with that, they can book them in, and with the letter that Ms. Wood has just submitted, that should be the turnaround.
Okay.
We set a bond after that.
meaning he has to come back for a bond or
No, we can set a bond
for now?
after, right.
Okay.
after, Yeah.
Okay, great. So I think the only piece I need is the size of bond that you think is appropriate, and obviously hear from Mr. Hand as well, so that we get that right. And Ms. Bostic, you are free to go. We are back up at 1 o'clock for the trial calendar. I don't know if you'll be able to cover that or a colleague, but we may have a plea or two off the trial calendar. So it'd be great if you could rejoin us at 1.
Okay, thank you.
Thank you. And same with you, Ms. Tucson. Once you've sorted things out with Ms. Taylor, we'll see you at 1.
Okay, sounds good. So there's not another plea right now at the moment?
Sadly, no.
No. Okay, all right, good deal. Thank you.
Bye-bye. What's up, Major? It's fun saying that. Major, now you get to wear the polo shirts because of the promotion. Soon it'll be what, a tank top? And when you get to Colonel? All the jokes. So these are all the warrants. And if we need to file them, we can file them. Judge Cottle signed them in April of 2016.
Okay.
So I mean, they're valid. They just apparently aren't like showing up in the system. And no one's fighting this. I mean, that's Mr. Trapatis right there. And we're wanting this to be a round trip. He needs to be booked in. I'm going to sign a bond that he can make. Yeah.
It'd be easier for us to.
Yeah.
Yeah.
Yeah. So you just tell me what you need from us to make it happen. Okay. And we're just working on the bond amount and we'll do it.
So the latest one I sent you is the ordinance. Which
Oh, there's something in my inbox. Excellent. So Roscoe just got invited to the Georgia game. He's going to be there. He's going to not appreciate it like you would, but I know he's going to come back and say, that team got a beat down. Who are those guys? I say, it's Deputy Gordon's people.
Yeah.
He's going to miss his little flag football game because he's going to that. So do the second one that you sent?
Yes.
Judge, that, I hope that works. That came from Ms. Markowitz, so I'm trusting she didn't lead me astray.
She's usually pretty good with that kind of stuff. It's two different things. Well, one of them says order for bond. I think we'll do a normal bond order. So we'll just do the front one. Defendant to be fingerprinted, photographed. So why don't I'll print it out and sign it. We'll see if Major says that would make it work on their end. Then we just need to get from you a bond amount that your client thinks he can make, and then we'll see what Mr. Hand thinks about that.
Thank you, Judge.
Sure.
I predict the score to be 50-6.
That's your number?
50-6.
2 field goals or a missed extra point?
We'll get 2 field goals. Might get a touchdown.
Oh, wow, we swaggering now.
Yeah, good.
50-13? Yeah, but George is terrible.
Jordan.
Come on. Yeah, exactly.
McKenna's no slouch.
Okay. What's their record so far?
We played Oklahoma, Washington.
You played Oklahoma? Who made your schedule? It is. Good Lord.
Washington and beat 3 schools.
Well,
We beat 6-10.
how about you play like folks who aren't way below you and way above you?
We are.
Okay, later in the season. Okay. After all your good players are out with concussions because they got killed by Oklahoma and Georgia.
Always wants one of those guys. Front line, kickoff.
He said he's gonna do whatever we say. Okay. What's your name?
You want to see here's his paperwork. And I just signed the order that says, could you please book them in, fingerprint them, et cetera. So I don't know if that'll help.
EVERETT and TRIPODIS. I'm gonna go ahead. Okay, I just see.
All right, I got to get on at 11:30. So I'm gonna go to my office and do that. We can do the bond whenever.
So do you want to just, that's it, or he can go to the jail and do it himself. Either way, we're gonna get him in and get him out.
Right. We don't have the bond done yet. So I think I would prefer that he go from here on your van to the.
Easier if we take him in custody.
Yeah.
And he comes to the back door with these and we can.
Yep.
Get him up.
Get them processed and out, and we'll have the bond in place. All right. So I got to leave the bench. I'll be back at 1. Before then, I'm happy to sign the bond. I've already signed the Markowitz special. That's with Ms. Nelson.
Okay.
Major Edwards has copies of all the warrants.
Okay.
He needs to carry those with him. And we'll just, once you guys agree on a bond amount, let Ms. Nelson know, and then I'll sign that bond and we'll go from there.
And it's only, so I think I'm understanding the theft charges can be UJR, but the burglary needs an amount.
Correct.
Okay.
Right.
Thank you, Judge.
And just given the nature of the charges and the Bentleys and whatnot, it's not going to be a $1 bond.
Yes, Judge.
Okay.
Understood.
I'm gonna file this and then I'll give you a copy. Okay.
We'll let you know.
They're not paperwork, but I said.
Okay.
And then just, we got a number.
Yes. Okay. We're taking, we do.
Did you get a number for him by chance?
That's right.
Oh, you got it? You I can find it. I'm just looking for.
Who's there? I think that's it. Oh. That's it.
Do you have an amount in mind?
I was gonna ask you that question.
Okay.
We come back up that one. So, no, no.
I'll be right back. Okay, cool.
Ms. Wood,
Yes.
I don't know if the deputy needs copies, but I put a copy of that order there.
Thank you.
And so I already e-filed it.
Perfect. Thank you so much.
And about the bond on your guy?
Yes, Mr. Hand, do you have an amount in mind yet?
It was gonna go through the 10% jail, what did he say?
I thought the judge said that he would allow it to go to the 2%.
Okay.
We can double check that.
Sorry, I'm just
You're okay.
looking at the amounts of the car.
Oh, okay.
They're crazy. It's like
I mean, yeah, but he's been in
$400,000.
federal custody for a number of years.
I understand that. My question is, and I wasn't clear on that. It sounded like one of those years was for this case and 5 were for another case. I just want to make sure I'm not misunderstanding in case that's wrong.
Hold on, I don't think I follow. Like a whole separate indictment number?
No, earlier when he was talking about splitting up his time, and he said like he's been in for 6 years, and he said,
Oh, that was for
1
the
year
federal,
for-
so he had to go, he was in the first, or like the first prison, first federal prison, and then he was in a transition center that was run through the Fed.
Okay.
Mhm.
So I heard him explain that next. I thought at first he was talking about serving time for 2 different
No.
cases. So it was only one case?
Yes, it is. I have that federal number somewhere. Hold on. I can send that to you.
Given that, I guess the value of the vehicles, I'm not sure if you've seen them, but I was looking at the police report, that was small. And then burglary, came around, this may seem high to you, but 90, which is 10 for the actual burglary, and then 10 for each car.
Okay.
Obviously, based on the values, if this were just like a regular case, I wouldn't recommend bond at all, just because of the value of the vehicles. But being that there's some confusion around this federal case, and whether it may be the exact same one, but that's where I came in. And what do you have an idea of what he's able to?
So I was gonna ask for 10,000 on the burglary, and then the UJRs on the thefts. So yeah, if we need to have like a quick hearing when the judge is back out, I'm happy to do that.
Yeah.
I actually need to run down and print some stuff from are you gonna be here?
For the trial calendar?
Like, are you gonna stay here between the lunch break?
Oh, depends on how much time we have.
That's
It looks
fine.
like we may not have any, but
Miss Nelson, is Judge McBurney coming back out, or is he coming back out at 1?
I thought he was, you guys don't have anything else left, right?
I don't think so.
I didn't think you had anything.
I think that was our last one.
Oh, about the
Mm-hmm.
bond. He said, I thought he said, present the bond and he'll sign it, you know, depending on what you guys came up with.
Okay.
Now you're not in agreement?
No.
Okay, if they're not in agreement, you didn't take them down? Okay.
Not yet.
Okay, leave them up there.
Yeah.
Was that case in Northern District?
I'm sorry, what did you say?
The case number you sent me, was that from Northern District?
Yeah, let me double check. I think so.
Like Jesus, when's the last time I
I'm not
logged into
sure.
a federal?
Yes, Northern District.
Okay.
Oh, I'll sing the song. Just gonna come out. Oh, go ahead. So I can bring them out.
I mean, I can waive it. Am I ready?
So y'all came over them? Y'all came over them?
We don't, that's not the same number.
Would you, Lacey?
Sorry.
The number aside,
Mhm.
would you oppose also ankle monitor as well?
Given, yes, I would, only because he's reached out to me every week since he's come into my caseload. I don't have any reason to think that he wouldn't show up.
Okay.
Mhm.
If I came down to 10, would you oppose the ankle monitor? That's because I know you wouldn't have any concern. I am concerned. I want to be able to place him.
If they'll let me ask him real quick. Hold on.
Okay.
Deputy Gordon. Thank you.
$60,1300. So one doing what we can do.
Thank you. I'm seeing your email, Pierce.
Okay. What happened?
Hold on.
So Joe's not coming back. We got the winners. So you just touch them
Maybe something else. No, did you text him? What did he say?
Oh, he just you.
He probably trying to see what he's trying to do. It's $60 an hour. How many hours is it? What you work for?
I'll be working.
It's 11 at night. 8 to 8 is 12 plus 3 15 hours. 65, 15. He gave y'all the most hours. He cut off. I don't want to work that long. Now, 60 times 15. 9.
Oh, that's what 18.
Spears.
Wait, 12.
Hey.
12 plus 3, 15 hours. 15 hours. Yeah, that's right. That's 18 hours. Yeah. Yeah, I was trying to figure out. 15 hours is $900. That was so much work there.
I'm going here to adjourn because I will make my snacks. There if you need me.
Okay.
Thank you. Hang on, this one. What'd you say? Yeah, everything's fine. I'm good. The deputy will be here. All right.
If you don't make it by 4, they have an 82 bill, so you don't spend that every day when they take care of the 82 moving. Probably help with, it's like, I would take care.
Judge is gonna do that bond hearing at 12:50.
At 12:50, right?
So you have till 12:50 before he'll come back out.
Okay, thank you.
Where's Ms. Wood at, you know?
I don't. When I stepped out, she was still here, so I don't know where she went.
The judge is gonna be back on the bench at 12:50.
Okay, sounds good, thank you.
Uh-huh.
Okay, he gonna come back like it's 12:50. He gonna go ahead and take us on lunch. Okay, so you wanna go breakfast, so we got dinner, she's on the second floor, okay?
Okay.
Yeah,
Gotcha.
okay.
I appreciate it.
Okay, you're welcome. Okay, second floor. Jury will send you, the jury side is set. Set. So it's 1,300. Chauffeur on AB, a day will be in recess until 12:50. Oh, you can't go all day. Yeah.
The case started to move.
Hmm?
And so I would like more time to, not for next week, if you have something else. It would be, I'd like to continue that discussion because as you mentioned, he has 3 cases.
He does, and none of them is a happy set of charges.
Right. So if there's some package deal in the works from Mr. Bach and Mr. Hand, then I'd like more time to work on that rather than trying to face the going through three trials and hoping that I win all 3.
Right. But you're certain that the week of the 17th, that's not going to work for you because of your conflict. Then maybe what you can do when we're done calling the calendar is talk a little bit more with Mr. Abate, maybe Mr. Hand as well, and see where you are. This case right now, I have as a good fit for next week. There are other cases as well. It's not the only one, but it's one that is less likely to be a plea given the seriousness of the charges. So it's good to lock it in somewhere. And it doesn't sound like I can put it the week of the 17th because of your schedule. So why don't you and Mr. Abate talk a little bit more, and then let's reconnect before people leave today. So I've got a better sense. Mr. Abate may have something to add.
So obviously, I guess the amendment was filed today for his leave. I was aware that the second week was not going to be an option. On Wednesday, I announced to the court that Detective Lane Packer had done all.
Oh, you did. That's right. Mr. Tolles, I had just a scheduling session with the lawyers who are routinely in here to figure out, are there certain cases that we can't do on any of these weeks because a defense attorney's on leave or something like that. And Mr. Abate had mentioned that a witness who is one of these, well, I can tell you where, if the person had his phone, I can tell you where he is because the phone at least was in this location. That kind of witness is not available next week. So the state was good to go. The week you're not good to go. And the only way it would work, we could try it next week, but then this witness would have to be able to testify remotely rather than being here in person. He's not an eyewitness or anything, but why don't you all talk about that? Because if the defense isn't willing to waive the detective, not the lead detective, but this detective's physical presence, then the first week won't work either. All that being said, Mr. Norris has been in jail for a long time and we need to get closure one way or the other. You know that better than I do because you're the one who talks with Mr. Norris. But you want it to be a meaningful resolution and not a rushed one. So please talk with Mr. Abate and Mr. Hand to see where we are. But it may be that we can't finesse this one in on this calendar.
I'll be happy to talk to you.
All right, thank you. Yeah, okay, got a big crowd back there. Mr. Finley. Michael Finley. Be a good day for you to be here. Okay.
I'm gonna reach out to him because this is supposed to be a negotiated plea today.
Oh, and is Ms. Taylor? You are Ms. Taylor. Excellent. Your understanding is that it's a negotiated plea. Great. Then you should try to find him because this will be a bad turn of events for him.
Yes, Judge.
All right. We'll hold on that.
Judge, if we may go back to Braylon Brown, I have one more thing I wanted to add.
Yeah.
I'm gonna see if we can do a non-negotiated today, so. just
Okay,
wanted to throw that out
great.
there.
Love to explore that. Anthony Johnson is here. All right. I need to get the sense of the public defender's office as to whether that office, Ms. Feely in particular, is going to be in a position to try something next week, or next week is off, but maybe by the week of October 17th, she would be in a position to pick her caseload back up. And I'm not applying any pressure. I don't know. I know she is very, very committed to her clients and may say, you know what, life is complicated, but for these 2 or 3 cases, I remain ready for next week. And I just don't know what you've heard, if anything, from her.
Judge, perhaps for a different case, but from what I know about this case, this would not be ready for next week.
Okay. Mr. Johnson, I think I have heard in talking with the lawyers about the case, are you contemplating representing yourself? No.
She was supposed to be asking today. I spoke with her day before yesterday. I had a surgery in 6 weeks to remove my hip and 6 vertebrae. So we was trying to get the actual case put out after I had my surgery. And as far as the public defense office, as you see, I'm here and she's not here. And I haven't really given any information or anything going on with them. I'm not even counseling because at the end of the day, I came down here on the 20th because they told me my case was on the 20th. I got here, no one was here. I actually contacted Roger Allen to the front of the police office to actually do a contact with someone. I had a call for someone one time since I, got over my case. And I've been, like I said, doing all the doing is calling me up, no one sent me information for trial via email, telephone call, anything. With the same interest that, like I said, I've been having this surgery that she was supposed to speak to you the last time we was here about, and as well, putting out my report on my for the probation officer because my health is deteriorating very fast. I don't think the surgery is possible. Paralyzed for the rest of my life.
Okay, well, we don't want that to happen. Ms. Feely is not here today because of a family emergency she's encountered that is very serious, and it is perfectly acceptable that she's not here today. It has nothing to do with you're here and she's not. I'm hearing you that you feel like she's been less responsive than you would like, and we'll need to explore that. But for today, we're not able to move forward with your case because of her unavailability, which has nothing to do with her professional commitment to any of her clients. But I had heard we might need to have the kind of conversation that you started, and it's good. We need to talk more about that. Today won't be the day we do that. And so what it sounds like I need to do is probably have a conference with Ms. Feely and Mr. Whitenauer, who is the prosecutor handling your case, to talk about that scheduling concern you've got. And the state may not object to putting things on hold for a bit so you can have your surgery. The state, I may want to see some paperwork so it's not just you saying this is going to happen. Okay. Well, what we'll do is engage with, and I can not talk to just one side. I always have to be talking to both. So what I'll do is have a conference with Ms. Feely and Mr. Whitenauer to get a better sense of what you're explaining so that we make sure that we are paying attention to the important criminal charges, but also paying attention to your important health needs. All right. Ms. Wood, do you need Mr. Johnson to stick around, or have we come up with a plan to move his case along?
He doesn't need to stick around, Judge.
All right, Mr. Johnson, I appreciate you coming down here. You did not come down here in vain. If Ms. Feely had been here, you needed to show up anyway. You're the one on bond, and so it was important you showed up for the call of the calendar. Don't hold this one against Ms. Feely. I'm the one who needed you to be down here, okay? All right.
Judge, might I ask, are you there for continuing this case off that?
The answer is yes. Mr. Johnson, you take your time. You don't have to leave till you're in a position. If you need us to get some medical attention, we can do that, okay? All right, you just sit tight for a little bit. Deputy Gordon will be watching you, and if he needs to radio someone in, he will, okay? Position 10 has been continued. That gets us to Mr. Blanding. Mr. Blanding, are you here? Hey, my understanding is this is going to be a plea?
Yes, Judge.
Yes,
Great.
sir.
And I think I saw Mr. Fleming walk in. Mr. Fleming, you here now? Nope. Could have sworn it was Mr. Fleming. All right. Did I say the wrong name? Finley, Mr. Finley. Yeah, he walked in. Okay. Mr. Finley is here. You were looking this way, but he just walked in. So Mr. Finley is here. That's good. Glad you made it, Mr. Finley. Gary Adkins. So that's one that should be ready. Tell me what Ms. Feely is saying about that.
Judge, I believe we could be ready for this next week.
Okay. And if not, then definitely the week of the 17th.
Yes, Judge.
Okay. All right. Do you need Mr. Adkins to come out for any reason? He's here. All the folks in custody are here.
I'm happy to pop back there. and
Okay.
see what's happening.
All right. If he needs to chat, just let me know. Mr. English is not in person. He is appearing remotely. Hey, Mr. English, how are you?
All right. How are you?
I'm okay. So this is Ms. Feely's case as well. And she had said next week. Still?
Stands, Judge.
Okay, all right. And I still have Ms. Charles's name next to this. Did I make a mistake? Is it actually Mr. Hands?
It is me.
It is,
Your Honor.
okay.
Yes.
Mr. Hand, any reason you couldn't be ready on Mr. English's case next week?
No, Your Honor.
All right. Mr. English, I'm not quite sure why you're not here physically, but I can see you and that's great. You're going to need to stay in close touch with Ms. Feely or Ms. Wood because you may need to be here in person next Tuesday to help your lawyer pick a jury in your case, okay?
Yes, sir.
You'll be able to make it down here?
Yes.
All right. You have any questions about anything?
No. What time do I need to be there?
Well, you need to be here at 9 on Tuesday, but I don't want you showing up yet. I'm going to look over all the cases that are ready and not, and I'll send an email out to your lawyer letting her know, are you going to need to be here next Tuesday or in a few weeks in October? And then she can let you know that. So you'll really want to circle back with her so that you come to court on the magic day, okay?
All right.
All right, Mr. Hand, how long do you think the trial would last in Mr. English's case?
Thinking 1 day, Your Honor.
1 day. If only we could get juries every 2 days. Oh, Halloween. Okay. Mr. English, I appreciate you dialing in. Do you need to communicate with him at all? You have good numbers for him?
I believe Ms. Feely has good numbers.
Okay. Mr. English, has Ms. Feely been able to reach you in the past when she needed to?
Yes, we was talking through email recently, all last week and this week.
Excellent. We'll keep that channel open. She'll be reaching out to you soon, okay?
Yes, sir.
Thank you.
All right.
All right. Position 14 is Marion Davenport. And my understanding is that's a maybe for week 2. But then I'm remembering your schedule week 2.
Judge, I have a very reasonable offer from Mr. Abadi, and we've been talking about this at length. I think we talked about it. How long do you think this will take if it goes?
3 days.
So we could do this before I leave town in October.
Okay, but it may resolve before then.
And I would like to speak to Mr. Davenport after the call as
Great.
Judge.
I will leave it on the week of the 17th, but it may be that it can come off that week. Thank you.
Thank you, Judge.
A very reasonable offer. Position 15 is Brandon Way, and we have a stand-in, an understudy for Ed Adams. Mr. Mallon is here. What says Mr. Adams about Brandon Way's triple homicide?
I am instructed to announce ready, subject to negotiation with Mr. Abate.
Okay, that's a frequent refrain we hear here. Mr. Abadi, my understanding is if this one were to go out, you'd prefer it to be the week of October 17th.
Yes, Your Honor.
Okay, we'll make sure it's on that list. And when Mr. Adams returns from parts unknown, but at least within this continent, maybe he'll engage with you. Will you let Mr. Adams know that Mr. Abate would love to hear from him so those negotiations could either continue or begin?
I will, Your Honor, and I will also remind Mr. Adams that there will be no pleas on the first day of trial because of jurors.
Exactly. Thank you. That will be helpful. If Mr. Adams is unavailable that week, are you going to be standing in to take care of things for Mr. Way?
I have not been invited to do so.
Okay. All right. So you're an understudy for calendar announcements only. Okay.
That concludes my business. May I please be excused?
You may. Thank you. Bless you. Clifton Kilpatrick.
That's my case, Your Honor, Ms. Feely.
Okay. I will let you, Ms. Wood, see if you can track Mr. Kilpatrick down. This is not a bond. He wants to. Hey, Mr. Johnson, why don't you have Deputy Gordon just be with you when you're going to do that, okay? All right, Ms. Charles. So I wrote down tentatively bench warrant, but we'll circle back after we go through the calendar once. Okay? Yes, ma'am. Number 17 has already pled. Apparently another reasonable offer from Mr. Abate. 18, Harvey Johnson. Right here. Excellent. Good afternoon, Mr. Johnson. So another Ms. Feely case.
Yes, Judge, and if Mr. Johnson would stick around, I would like to speak with him, to see if we can't resolve this today.
Got it. Mr. Johnson, there's an offer in from the state that Ms. Wood wants to chat with you about. She is a very close partner to Ms. Feely. Ms. Feely can't be here today because of a family emergency she has had. And so I'd ask you to chat with Ms. Wood to see if you're interested in what she has to share. Okay? And we'll take it from there. You're welcome. Rhonda Walker. There's Ms. Walker. Good afternoon, ma'am. Ms. Wood, your case.
Ready, Judge.
Ready week 1?
Ready week 1.
Mr. Whitenauer, your case.
Ready.
Good. I've got it on my list for week 1. So should Ms. Walker stick around, or you and she have been in good contact?
We have good contact.
All right. So Ms. Walker, Ms. Wood will be letting you know if you need to be back here. It'll be this courtroom at 9 in the morning on Tuesday, because we're going to have a trial in your case. You've got a right to do that, and it's time to make it happen. So that may be on Tuesday. There'll be more than one case that'll be ready to go. So we'll need to figure out that Tuesday morning, the order in which they'll go. But it's just important you stay in touch with Ms. Wood. So if you're supposed to be here Tuesday morning, you don't miss it. Okay? Any questions? All right. Thank you. Kenneth Bradley.
He's in custody, Judge.
Oh. Huh. All right.
There's a misprint. He's booked in under Brantley.
Okay.
Judge, if we could come back to this, I would like to see if this could resolve today.
Is he-
Otherwise, I'd be ready.
Well, he is here? Okay, good. He's here. Great. Please do chat with him, and any reason you couldn't do Bradley week 1?
No, Your Honor.
All right, Mr. Hand? I think I had written down week 1 from our discussion. It remains week 1?
Yes, Your Honor.
Okay, great. Mr. Galt?
Morning, Your Honor.
Hey, Mr. Rouse, how are you?
Good afternoon, Your
Yeah,
Honor. Mr. Gold is in the courtroom.
he is?
And yes,
No, I see him. No, I.
okay. From my discussion, Your Honor, it appears I'm gonna have a trial. I've had some discussions with the new prosecutor on the case. All our discussions have just begun. I'm expecting that we're gonna move forward.
Okay. This is a case that will be on the list of cases for the week of October 17th, just so you can plan and Mr. Galt can plan. You don't need to worry about being hailed to court next Tuesday. You'll be on the list for October 17th. I don't know how long that list will be. There are a couple cases that I thought were going to be on it that may plead out this afternoon. So if this is going to be a trial, that's very likely when it'll happen. Will be the week of October 17th. Between now and then, Mr. Galt, you can be at ease. It may be that Mr. Hand wants to talk more with your lawyer, and he'll, of course, let you know if negotiations change. But if they don't, everyone should be ready to go for trial on October 17th.
Understood.
Great.
That be excused?
You both may. Thank you.
Thank you, Judge.
Stuart Bryant. There he is. Ms. Wood, when we last spoke, week 1 worked for you.
Yes, Judge.
Still does.
Still does.
All right, Mr. Whitenauer? Okay. Do you need Mr. Bryant to stick around?
No, Your Honor.
All right, so Mr. Bryant, you've heard me say this before. Stay close to Ms. Wood electronically, because she'll let you know if you're on the list to be here on Tuesday morning to pick the jury in your case. Okay? All right, see ya. Raymond Carter. There's Mr. Carter, and there's his new lawyer. Hey, Ms. Rockwell.
Never a dull moment in your courtroom.
Nope. So, Mr. Carter, I had a chance to speak with Ms. Rockwell, and your former attorney, Ms. Wood, and your former prosecutor, Mr. Hand, and Ms. Charles, and your current prosecutor, Mr. Whitenauer. And I explained that we're still going forward with your case, even though you chose to bring in a new attorney, which is your absolute right. That just doesn't slow things down. We don't say, oh, Mr. Carter got a lawyer now, so we ought to wait. You've been on a trial calendar before, all that jazz. So your case is one that I've put down to go out on Tuesday morning if there's not a case that goes out before it. But I'll get an email out to your lawyer that lists the order in which we're going to go and all that, so no one has to guess. But you should expect to be here Tuesday morning at 9, and if your case goes out for the duration of that trial, which based on the charges, I assume will only be a couple days, but it'll be your full-time occupation while we go forward with that, okay? Any update, Ms. Rockwell, in terms of sorting the case out, or as far as you can tell, based on where the state is trial time?
I don't know, I always feel good about it. What I didn't hear is that y'all don't let pleas go forward when there's a jury outside typically.
So,
I missed that part.
Because I can't get jurors the very next day, for the next few weeks, as it has been for the last few years, each judge has a shot at a jury once a month, once every 3 weeks, and not just whenever. And so what I can't do the day of jury selection is take 5 pleas and then cruise down there at 1 and say, you know what, we'll get through half this pool and the rest of you all come back the next day, because I don't get 1C the next day. I have that room with the 48 or 60 jurors that one day. And so it's not impossible to take a plea the morning of jury selection, but what I would likely do is find a colleague who would take the plea, while I then go to case number 2 on my list and say, are we ready to go? Is voir dire ready? Let's all go down to 1D and pick that jury. So a better plan is to plead it out today or Monday, if that's the direction in which it's heading. Mr. Whitenauer.
I'd also add, Judge, that I have filed a citizen's notice of agency in this case, and we're trying to plead today. I'm not controlling it.
Okay, so let me make clear what that means, Mr. Carter. You may already know what it means, and Ms. Rockwell is probably going to want to talk to you a little bit more about that. Mr. Whitenauer, the prosecutor, has filed a notice that invokes something that only the state can invoke. I can't do that. But apparently, we don't need to get into the details. You have a criminal history, so that if you go to trial on this and you are found guilty, so that's some ifs, if you go to trial and if you're found guilty, if I sentence you to any jail time, it is non-parolable. So let's make it up. And I have to, your sentence has to start with the maximum number. It doesn't mean it's all jail, but let's say you were found guilty of the aggravated assault. I have to give you a sentence of 20. It could be 20 years probation. But if I gave you a sentence of 20 to serve 3 with a balance on probation, normally an aggravated assault, you might do half of that, maybe less than half. But because the state has said you're a recidivist and filed this paperwork, if I sentence you to 20 to serve 3, you will do 3 years in prison. You will not be eligible for parole for any aspect of that. That's what it means to be sentenced as a recidivist. And I don't get to say, well, wait a minute, Mr. Carter's a nice guy. His convictions are from 20 years ago. If the state invokes the recidivist provision, it requires me to have that sentence start at the maximum, so 20, and then any jail sentence that I give it requires you to serve it to the door, as they call it. So if it's 3 years, it's all 3 years. And you don't see the folks at pardons and parole. So I share that with you, not to influence your decision-making process, to inform you, because you and Ms. Rockwell should probably talk one more time before I say, we'll see you on Tuesday, because the other piece of Mr. Whitenauer's announcement is if you don't work the case out today, then that recidivist notice is staying in place. Meaning, if you decide on Tuesday morning, I don't really want to go to trial, I'm making this part up. There's a video of me doing whatever I'm alleged to do. It's not going to be a good trial. You can go ahead and plead. That's great, but it will be as a recidivist. So your sentence will be 20 to do something. Okay. So please talk with Ms. Rockwell. Ms. Rockwell, after you two have spoken, if Mr. Carter remains committed to having his trial on Tuesday, that's all you need to let me know. I'll jot that down, and you and he are free to go. You'll get that email letting you know where on the list Mr. Carter is. Then you'll use your expertise. Hey, we're number 9 on the list. We're not going to trial on Tuesday. We're number 2 on the list. We better be ready to go on Tuesday. Okay?
Thank you, Judge.
You're very welcome.
I took away the fancy word and I told him what recidivist was a repeat offender, so we're still, we're only about 5 years apart.
Okay. All right. I'm going to keep moving on. Position 24 is Ms. Brinkley, who I think we have appearing virtually.
Yes, Your Honor. Good afternoon to this honorable court. Ms. Brinkley is on the virtual platform.
She is. There she is. Hey, Ms. Brinkley.
By the court. Court gave her previous permission. She is recovering from a hernia surgery that she had this week. She has doctor's orders, Your Honor, to be where she is right now for a little while. ADA Hand and I have been in communication on this matter. I've provided some documentation to ADA Hand, and hopefully ADA Hand will be in a position to tell me what his perspective is on this case after the call of the calendar.
Okay. So Ms. Brinkley, if you don't mind staying on the call, you can turn your video off and your audio off as long as you can hear us. Your lawyer and the prosecutor are going to talk some more, and we'll figure out which direction we're going. If the case is not resolving today, then I'll need to talk to you a little bit, Ms. Brinkley, about your ability to come to court and when that will be. I'm not going to interfere with your recovery. That's important. But at the same time, these are some serious charges, and we need to make sure we're sorting those out in a timely manner. So at a minimum, we'll talk today about Ms. Brinkley's availability to come to court and when that would be, then work with the lawyer schedules to see where this falls on a calendar if it's not being resolved. Okay? All right. Thank you, Ms. Brinkley. We'll talk with you in a minute. Mr. Lloyd, I didn't see Mr. Melnick. He's on leave. Okay. Mr. Hand, or Ms. Charles, I'm not pulling you back into the case, but has Mr. Melnick filled out paperwork for an evaluation, or he simply talked about he is thinking about it?
Your Honor, I believe he emailed your chambers and us about it, but I have not seen any paperwork.
Okay, all right. Is there anyone here? I know Mr. Lloyd often has family members here. I don't want them sticking around. Okay, all right. Mr. Rhodes?
Good afternoon, Your Honor. He is here.
He has two cases.
The first one's no
The
problem.
first case, my understanding and looking at the beach courts that there has been a filing of a no cross for the first case.
Right. So Mr. Rhodes had a criminal damage to property. I was given a null pros. I signed it. That case is gone. We've got the shooting case as his other matter. And we need to figure out which of these weeks we ought to try to tee it up.
We will be ready on either week, Your Honor.
Okay. And Mr. Hand, I think your preference was week 2.
Yes, Your Honor, October date.
Because, just remind me.
I think at the time I had multiple cases on the first one.
Because you've got so many on the first one. And Mr. Smith, you don't object to having it be teed up for the week of October 17th?
That's fine.
Okay. Mr. Rhodes, you've been out on bond for a while. Any issues with bond? Okay. And you're not planning on moving anytime soon? Okay. Then what we'll do is add your case to the October 17th list. And Mr. Smith, you'll get an email from me or Ms. Nelson or both of us that shows the order in which tentatively I'm thinking things will go. It's usually jail first and then by age of case, but not always. There's sometimes reasons why position 27, your case, jumps ahead of position 10. I don't explain why, but you'll just see it, and they are ordered purposefully. But that'll just give you a sense to share with your client where you are on the list, how ready you're going to need to be the week of October 17th. We can only try one case that week, and we'll see where that ends up. Okay? You bet. You may. Thank you for being here. Christavius Smith.
Good afternoon, Judge. How are you?
Hey, Mr. Richardson. Oh, your client is in state custody.
Sumter County, yes, Judge. We were before the court on June 28th. He had 4 cases. We resolved 3 of them. This is a young man with the purses and.
Yes, right.
Right. Ms. Charles and I had been talking, then we kind of lost track of each other. It was a restitution issue with the people who own the purse place. I was told by his fiance wife that his potential release date is in February. If we can come up with a restitution amount, the court wants to bring him in, I think we can have a plea on this case. He was on probation revocation. Then we sentenced him on 3 cases. You told him you thought he needed a little more time. Then we'd address this final case once it finally came up. So here it is.
This one didn't resolve because
it was a restitution amount. Ms. Charles was going to present it to the victim and see if they were comfortable with a lump sum and then some form of payments.
And these were the fancy handbags.
Right,
Yeah.
a smash and grab purse bag, something like that.
Got it. Okay. This is shifted to Mr. Hand, who has replaced Ms. Charles as the assigned to the courtroom, not in special unit ADA. Mr. Hand, what's the state's perspective on this one? I remember now everything Mr. Richardson said. He was angling for his client to have a global resolution. Ms. Charles wasn't in a position to resolve this last case because of that restitution question, but it wasn't ever, yeah, well, then it's going to be a trial. It was more, what do these dollars look like? What's happening with the state right now?
If I may.
Please.
So when I spoke to the victim, she considered for a moment the offer for a partial lump sum and then the rest throughout the course of probation. However, in subsequent conversations, she feels that she would, if the only way she would accept that is if she was going to get all of her money up front. She has 2 locations, one in Sand Springs, one in Buckhead, and to preserve her reputation in the community, she's been in this business for well over 20 years. She had to come out of pocket a significant amount. Her insurance dropped her, State Farm. She has to now get insurance from Idaho, where she pays a significant premium per month. And so at this point, you know, we would need to come up a whole lot more than what the previous offer was as far as a lump sum restitution.
So I know
So
Mr. Smith
when-
isn't here, so I don't want to talk about it too much, although his lawyer's here, so we can talk about it. But I want to make sure tail isn't wagging dog here. The victim is entitled to full compensation. Victim is not entitled to say, these are the payment terms. I want my $1 million now, or you rot in jail. That's not how the process works. So I appreciate you sharing her perspective, and I very much appreciate what she's been through. And it's terrible that she has now had to insure with a different place that's more expensive, et cetera. Mr. Smith, insofar as he accepts responsibility, needs to work hard to make her whole. But if the reality of his situation is that he's earning no money right now, and when he gets out, he will have a slow route towards earning more, I'm just trying to figure out what the end game is for the state.
Well, if that's going to be, you know, that's her preference. However, when we get to the point of a plea, I'm sure she'll want to be in person.
Sure.
So Your Honor can hear from her.
Right.
And take that into account before you pronounce final judgment.
But I follow all that. But even if I were to say you need to pay, I'm making the number up, $100,000 up front. If he doesn't have the money, I'm not going to revoke his probation. That I don't think would be legal. It wouldn't be right, regardless. So I'm just trying to understand the trade-off. Was the trade-off, hey, you can't, if you want probation, you're going to need to be able to come up with some money to make the victim whole.
Yes.
Otherwise, the state is recommending more time.
Yes, Your Honor. And then
That's the trade-off.
Negotiated, and you'll hear from everyone involved.
Okay, got it. And so it could end up being what you just said, a non-negotiated plea. Mr. Richardson can explain why additional incarceration is not necessary or not appropriate. You can explain, as you just did rather eloquently, the impact this has had on yet another victim.
Yes,
and then I'll work through that.
Yes.
Okay. So Mr. Richardson, I know you need to talk with Mr. Smith, but and you described his timeline. Is this a case where we got to just wait till he's done with his revocation, or should we either connect him virtually, not today, but sometime soon, or produce him from wherever he is so that he can do this non-negotiated plea? I'm not sure where the two sides are, not numbers wise, but procedurally wise.
Judge, I think probably the smartest way is probably do it virtually. I will speak with his wife and his family. If the state will tell me what their final number was, because that was kind of a mystery as well. And I understand joint and several liability, but tell us what they're talking about, because right now we don't have a number.
Okay.
I mean, I guess we have a restitution hearing and she could produce receipts or no, however, or we might be able to stipulate to the amount. And,
right. I think if we are going to be patching your client in virtually and we're providing the state with enough notice, it will either be a stipulated to restitution amount, or the state will need to be in a position to prove it up then and there for the non-negotiated plea, so that we don't then leave hanging, well, what are we going to do with restitution? In particular, because that's such a significant driver for the state's negotiating posture. It sounds like the more money made available, in other words, making the victim more whole, then the less of another sanction that the state would be pursuing. So it sounds like, are you keeping the case, Ms. Charles, or you're just helping out because
I'll go
you're
ahead
close?
and keep helping him out, Your Honor.
Pardon?
I'll help him out.
But it's a Mr. Hand
It's
case.
Mr.
in the
Hand's
end.
case,
It won't
but-
be mine, right?
Yes.
It's just that the last communication.
Was with me.
With 88 Charles.
Got it. Okay. Mr. Richardson needs to have a place to go, and it sounds like it'll be Hand going forward. So what I'm going to do then is have Ms. Nelson coordinate with you, Mr. Richardson, because you have to be in lots of places, and Mr. Hand to figure out a date in the near future that we could patch Mr. Smith in virtually for a non-negotiated plea, but we need to set that date out far enough that the state can either get you that dollar amount or say, well, we're not giving it to you right now, but we're bringing in whatever proof we've got for purposes of the restitution piece of the sentencing hearing, so that we bag it all up into one event. Does that work for you, Mr. Richardson?
it does, Judge.
Okay, and you'll be free. You can appear from the sky blue room or in person because your client will be appearing virtually.
Yes, sir.
All right. Mr. Hand, does that work for you?
Yes, Your Honor.
All right, great.
Thank you, Judge.
Have a great weekend.
Like excuse?
You are. That's the have a great weekend part.
All right, take care. Bye.
Bye. Reginald Watson. Okay, just need to make sure which one was you. Ms. Wood, your client, and you had announced ready.
Ready, Judge.
No change in that one?
No change.
Okay, and did you have a preference as to, I've got them down for week 1.
I'm good for next week, Judge.
Okay, Mr. Hand,
Yes, Your Honor, we can do it.
you can do that?
So, Your Honor, in case I do want to talk to Ms. Woods about, because we may be able to resolve it.
Okay, so Mr. Watson, I need you to stick around. The prosecutor may have a new offer. So he's going to talk with Ms. Wood. She'll talk with you, okay? Great. Kiara Christian. Hello? He is, let's see, Mr. Lewis. Okay, he may be taking a plea in another county right now. So if you don't mind sitting tight, when he appears virtually, we'll have the conversation, okay? Thank you. Jarvis Ortiz.
Good afternoon, Judge. Zach Sherricker from Mr. Ortiz.
He's right there. Okay. I got a somewhat cryptic, not message, it was a conversation with Ms. Nelson about mediation and things I didn't understand. So do we need to chat?
Mediation, I don't know anything about mediation, but I think a good chat would be in order for us. Yes, Judge.
Okay. Well, why don't we only have one more case on the calendar to fully call it, and then people can be doing their pre-trying, and part of that can be, we can talk about Mr. Ortiz's case. Is Mr. Ortiz's case the one where there was momentarily, let's revoke his bond because I want to make sure I'm remembering because he bought a truck and that brought him near an address he wasn't, okay, same case. Got it. That gets us to Jason Mansfield, which is, I assume, why Ms. Singleton is here.
Good afternoon, Your Honor.
Hey, Mr. Abitabi, how are you?
I'm doing well, Your Honor. Good to see you.
Good to see you. Is your client here?
He will be shortly, Your Honor. He's
Okay.
on the way.
All right. Mr. Shapiro, when you and Mr. Abitabi and I last spoke, this was going to be a plea or structured in some way so that it ends up going to juvenile court.
We're still there, Your Honor, and I think we've made a lot of progress. The only issue that's left now is to fine tune the language of the proposed order to incorporate what you propose.
About the evaluation.
Correct.
Okay, we can do that. We'll make that happen.
Okay, Your Honor.
We need to get your client here and then we can get things on the record.
Okay. I don't know if we actually will need him, Your Honor, because we have agreed that it will be a plea. The only thing that's left is to pick a date.
Why would the plea not be today?
That's a possibility if he's here. Otherwise, we could do it week 1 or week 2.
Yeah, except we can't because week 1 or week 2, we're trying cases. So today is a great day for a plea, assuming that's what both sides are prepared to do, which is why we do need Mr. Mans. And he has to show up anyway because it's the call of the calendar, but he's on his way. So when he gets here, why don't you all talk? But my preference, as I expressed on the phone when we last spoke, was that we use the opportunity of today to resolve the case from Superior Court perspective and get it headed to juvenile court, because that was my understanding. And I've done this a couple of times before, not with Mr. Shapiro, but with a colleague. We do the whole plea colloquy, and then what I end up signing is basically an order that says now this goes to juvenile court, but with some parameters that you all have agreed to.
Correct.
Okay.
Thank you, Your Honor.
You bet.
We'll be back
Good. Today.
today.
Yes. All right. Is there anyone here who didn't hear their name called? They thought they had a case. Well, I did call you. You just came late. We got you, Mr. Finley, and I think you got a plea. But I'm gonna let you talk with Ms. Wood, make sure that's all set up. Anyone else?
Your Honor, did we skip over position 30?
3-0. We did not, Ms. Christian is here. Her lawyer is taking a plea in Gwinnett right now. And is going to appear virtually. He got the green light to appear virtually, but importantly, his client is here. Did you have an announcement on that one?
No, I didn't hear a call, but I might have been.
Oh, you were probably dealing with one of your many other cases, but Ms. Christian is here. All right, Ms. Wood, I know you've got a lot of potential pleas. You're covering 2 dockets. Hopefully your team of support can assist with that. I'm going to have that brief conversation with although they just ran away, the lawyers who were handling Mr. Ortiz's case. Then we can start taking pleas when they're ready. So I'll let you figure out how to prioritize them in a way that's best for you.
If it's okay, I was gonna sign Mr. Finley up first, because I know that's Ms. Taylor's only case.
Yep,
And
that was going to be my suggestion, but I didn't want to lay a heavy hand on the process.
Thank you, Judge.
Great. If I leave the bench, is it easier for you to get lawyers back to talk to their clients? All right, so I will come back as soon as something is ready. Mr. Katz, if your case is ready, we can do that one. I know you need to talk to your client, so I'm going to leave the bench so you can do that.
I know Mr. Body's here. I just talked to my client. He's wavering now, Judge.
Well, if I need to talk to him, I'm happy to do that. Let him know what the other option is.
Okay.
That affidavit is very interesting. Can I tell you, because I just talked to her. Yes. Good question. I have to put that in my voicemail. I mean, in my phone messages. Probably yesterday.
Here, you can use my laptop.
Had to be at least afternoon,
Yeah.
but sometime yesterday I did call her. Okay.
Any restitution?
Is that when she signed
Or is
that?
it just
affidavit?
3 years probation?
Really?
Did any special conditions?
Because
Yes.
when I had a conversation with her yesterday,
I'll talk to
she
him after.
was telling me that she was
And this is
going to
the yes.
verify
Yes.
the restitution damages for the car.
Yeah.
That was our conversation, which was completely different from that.
from
So
that.
let me give her a call.
Yeah.
And figure out.
Yeah.
Should we
You know
leave
where
or
she
something?
is. I'm really just, because it's really just two girls, a cat fight.
No, I believe that. The problem is, right, that when there's 2 cars involved, then it becomes an aggravated assault.
Harvey Johnson.
Just because of the amount of force. I do want to talk to her. I'm open to it just being downgraded to a simple assault.
Or misdemeanor, criminal damage to property, or reckless conduct.
Well, the problem is that there are 4 victims. If we do criminal damage to property, then it's only 1, right? Because she's on 1 of them.
How about reckless conduct? Because these kids, these young people. These young people.
Yes. Which one? Yes. Okay.
It's crazy. Yeah, it's like, no, never.
Mr. Finley. Okay. Here, you may pop back there right now. Can you go ahead and take your ticket in the hallway and just go ahead and show her? And then he knows. Have him sit in the hallway and then I'll.
Let me talk to Ms.
And her lawyer just one.
What's your name? Oh, okay. She did, oh, so he just logged. Okay, thank you. No, not Nora. No, Davenport.
Norris.
Oh, Nora.
Marius Norris.
Yeah, you can sit right up. No, when you on this side, right? I heard your last name. Yeah.
It's always that way.
Right. Whether you want to make it.
Right, yeah. 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 Right.
Did he say? Yeah, he didn't say.
Okay.
Oh, yeah. Too much. Mr. Willis, can I take a minute? Well, supposed to get back to me. No, they were printed. Yes. I thought I had found them. I was looking for them this morning. I don't have it on I must have left them in the office. Okay. Because they were printed out. I did see them.
Oh, so I'm bad.
No.
All right, look at what I can put right here.
That's a problem. He does. I gotta be.
Yeah. I don't know what it is. I mean, I may have. Landon. And there are a couple of little predicaments. Things that I've heard.
Right. And then it comes down. And then I'll talk to her more. I'll be right.
Yeah. I had some good games.
Did you?
Good.
Yeah, 8 and 9. Yeah.
You're gonna let me have the laptop or you just gonna- Oh, you say yes.
Yeah.
Okay, so I had a quick question. I did. So now back to Brian. So you got print on paper?
Yes.
No, I just had to get one, and then they worked amongst themselves. Yeah.
Yeah.
She's got one.
Okay, there's another question? Okay. Thank you. So Berlin's a whole. Go back. But I'm gonna sign it.
Okay.
Okay, thank you.
Hey, really quick, it's something there that we should show the actual physical indictment. Do we get to?
Oh, I'll show you.
Yeah. Her brother.
And then obviously.
Smart.
Yeah.
No, that's what I think you and I. That, is there, the front. But she doesn't.
Yeah, it's gotta get in here and argue for it.
But you need a break. Good to see you.
So she picked up, then like, something happened with more than background. I called her again, and she did, so I'm gonna need some time.
Okay, good.
I know, but I'm gonna ask the judge to give me a moment to look at it. I don't think.
And this is my first one.
Huh.
You don't think you get read the second one.
What do you mean? Oh, on the calendar. I mean, my thing is, I mean, you just gave me something I haven't had time to look at, like, even if we were to trial, right, I need to explore, look at that. So I guess I'm gonna ask for.
But don't you have some?
I don't know if you can bring it.
Yeah, so I have that as a rate. But he.
Yeah. That may be the request, because, you know, I want to talk to her, and, I mean, of course, that's only for her, right, there's 3 other folks that we're gonna talk, which I submitted, and 2 others, so.
And I got 413.
So, let's just take a moment and look at it and see.
Made a bad choice in how much.
Yes, with the restitution.
Yeah, that'll be fun.
Yeah.
Or that she's gonna pay for it, not. Because I saw in there, a lot of people pay. Oh, your people. Oh, okay. Yeah, I didn't know that. See, and that's the stuff I want to talk to her about, right? Because it's her car, she should know. I did see it in the application.
Okay, so if you confirm from her.
We tried to, but we decided
The middle there is the boyfriend, right? That was his like. Right. So.
Yeah, so we might have got that.
She did a month, right?
Or
3 weeks.
I don't know, I haven't but I mean, yes, that makes sense for her, right? Then if you're at the car. And I want to talk to them first, because I'm not solving one thing, I'm solving 4. That's all I want. The last time I spoke to them, and we actually lost contact with them to locate fine. You know, Shankita has all that as well. It's talking. So if they, you know, we can contact them or can feel the same. Right. Then we make it forward. So that's what we'll say. I will need a moment to, I mean,
Yeah, me too.
So that. But for the judge, I know that it's beforehand. All right. Yeah. Which means high school is probably. Oh, wow. All year. Yeah. Same.
You're about to bring the judge up? Yeah, I'll go get him. All right.
It is.
had it yesterday, that's on my damn name. I just had stuff.
Yes. Really?
Oh,
Right? Yeah. So he's good enough.
he's turning into work on Friday. Getting ready on. Oh, darn, take home.
I think so. I mean, that was the request,
For my following of that.
Yeah. Nice to meet you. You're representing Mr. Mary?
Yeah. How's everything?
All right. So,
That's really, so, how many you got there?
Yeah, I have.
It's all the charges.
So you're on right. You don't have like a identification.
what do you mean identification? I think-
Facial identification.
Facial for so no, and I think that's what made it a partial ID, but they did ID based on the clothing. They did ID based on the car. They did ID based on three gentlemen, you know, one short hair, one dread, how many, so there's the first case where there's, you know, entering auto. You can look at the calendar here, but the first case is that, wait, I said it. Where's the calendar? So, armed robbery, criminal intent. This is actually the first victim. She was almost robbed, but she wasn't. She's one, Jessica Smith, who screamed and then they drove away. But then you have case number 2. Oh, wait, no. Why does it say criminal intent?
Okay.
Oh, you know why? Because the second victim, they tried to take her bag and they did it. She struggled for it. Okay. That's right. But this is the one with the 2 victims, Antoinette Frazier, Darius Bussey. This was on both of them. And then Justice Smith.
That's actually better than what I'm doing. Just because all the stuff we get.
So, I mean, those are all the charges. Okay.
Oh, okay.
I'm actually.
Yeah.
Yeah. I mean, like, I didn't think of high murder or rape,
Yeah.
I ain't got time for that.
I'd say those
Yeah.
See, Miss Charles. Miss Charles.
Charles?
Miss Charles, you know what you want?
Oh, no, she's second. I think she ran her off.
Anybody ready right now? Anybody ready?
I have to wait for her.
Yeah, she.
Do we need to come all the way out or we need to step to the door?
You probably just, well, I don't know, see how the judge wants to do it.
Not because I'm by myself right now.
No, I know. I think you just shut the door. Put it on the record.
We have some motions.
They are here.
We got to call out before we.
Yes, yeah, it was starting. Yeah.
Everything I see is in being rude.
Oh, did you? Oh, you figured it. Well, these are the ones that, yeah.
So I was too.
Oh, yeah.
Which one?
For blending. I was just asking, was that a misdemeanor?
Oh, I think,
It was the only guy.
so he took a bunch. No, that's just the max. So reduced it on the size of the maximum.
Okay. Okay, that's all good.
So you could just.
Okay, yeah, I think. By the time they're 15.
Middle school.
You're right. Okay, yeah. Because I know you need virtual stuff. Okay.
No, that was before. That's what I had before. I just redo it each time, so.
Okay.
His stuff. Yes. Can we grab your file?
Yeah, it's in there somewhere, there's a bunch of files.
It's so. Like this, I like it if you get on my face. But. No, go see it. Yes, it's not too much. Well, that's one. Yeah, what is it? Yeah. Most of it is. Yeah, it's a real village. So it's not. You still on the range? Or no, your kitchen. It's like a big festival. She's right there and so around. I can say everybody else that. Yeah, I
What's up? Okay, cool. Yeah, okay.
Okay.
Lacey,
Yes.
can I talk to you?
Yes.
Hold on, let me,
Yes, I believe I do. So. Let me go ahead. Yes, that can be done. So are we not doing the police today?
And there's no way to withdraw it.
Okay, so it sounds like not today. I'll have my assistant send
You got a phone, Mr. Terrence?
Oh, I did.
she'll email you a link to evidence document.
Oh. Can I send that to him? Will I have the capability, will I have permission to send it all to him?
Yeah.
How are you doing 3 years? They're all back at school.
Yeah, the tool. Yeah.
That's right, you don't need a call.
So we can bring one.
Work on order, please, remain seated.
We get the DA.
Okay. We got lots of moving parts here. Let me start with Mr. Tolles. Mr. Tolles, you and we need Mr. Abate in here?
Yes.
Okay, he's coming. All right. Then let me turn to, while we're waiting on that, Ms. Christian. We have Brandon Lewis, and we have Mr. Hand. We don't have Mr. Hand. Okay. But we needed you. All right. And Ms. Taylor, are you ready to go with your plea? Okay, great. Understood. Yep. I'll talk to him. So Mr. Hand, we're going to get the announcement from Mr. Lewis for Ms. Christian, and then we will keep pressing on with all our business. So there is Mr. Lewis. Mr. Lewis, you can hear us?
I can, Judge.
Can you pull over while we're talking?
I am pulled over, Judge.
Okay, well, you weren't, because unless you had like a TV in your back window making it look like scenery was rolling by. All right, now you're pulled over. Ms. Christian, why don't you come on up to the podium, please, so Mr. Lewis can see you and you can see him. How did the plea go in Gwinnett or wherever it was you were just driving?
It was a motion, Judge. It went well, Judge. Thank you.
Okay, a motion. All right. So there is Ms. Christian. She's right there beside you. So we're just calling a trial calendar and trying to figure out which of the 2 weeks you'd be ready to go. If this is still a trial, I need to get your update on behalf of Ms. Christian.
At this point, Judge, it is a trial, although we are in negotiations. We are just a little bit apart, but I can be ready the second week if need be.
Okay, the week of October 17th?
Yes, sir.
All right, so we will add Ms. Christian's case to that now long list. I'll be sending out an email, Mr. Lewis, that will have the specific lineup for that week so you know where you fall. It may not be in the order in which the calendar was published. So Ms. Christian may be hired closer to the top because of the seriousness of these charges. Mr. Hand, week 2 works for you?
Yes, Your Honor. Second be ready, week 2.
Great.
Will be.
Okay, and you'll keep talking with Mr. Lewis because it sounds like you're also maybe trending towards a resolution.
I will keep talking about it.
Okay, great. Ms. Christian, you're going to remain on bond. Any questions about any of that? Okay, any questions for Mr. Lewis? No?
No.
Okay, all right. Thank you, Mr. Lewis. You're free to go. So are you, Ms. Christian.
Thank you, Judge.
All right, you can resume driving.
Make an updated announcement.
Please.
Thank you. Your Honor, this is on State versus Quadricia Brinkley.
Right, number 24. Let's get Ms. Brinkley. Can you turn back on, please? There she is.
Yes.
All right, we got you.
So Your Honor, the state and I have been in discussions. We have provided some documentation to the state. They are vetting that information with the alleged victim in the case. There are 3 other alleged victims in the case as well that the state of Georgia wants to communicate with. I think that we have a resolution that we're seeking to get accomplished in this case. Judge, I think the state and I have agreed that if we can ask that this case roll over to the second week, that'll give the state an opportunity to continue its diligence and be able to report back to the court a date certain that perhaps we can get a resolution date to resolve.
Okay. If it is not resolved by way of your negotiations, is Ms. Brinkley in a position by October 17th, so almost a month from now, to come into court for a trial? I don't know her recovery trajectory.
Right. So Judge, with the hernia surgery that she had, she was placed on bed rest for a week or so. Do I have that right, Ms. Brinkley?
Yes, I actually go back on the 5th of October for my post-op, so it's a good chance that I should be okay to come.
Great. Okay. Well, that all will allow us to get the results of the post-op, because that October 5th is between now and the 17th. State can be working on communicating with the alleged victims in the case and with you, Mr. Matthews, and I will add this case to the week of October 17th. The only reason it will come off would be 1, Ms. Brinkley's medically unavailable, or 2, you all work it out. Obviously, no need to bring you in for trial that week if you've worked things out.
And we'll certainly make the court aware of any conflicts that we have in letters and things of that nature.
Great. Sounds good.
Thank you, Judge. May we be excused?
You may. Ms. Brinkley, you continue to heal, and Mr. Matthews will be in touch with you, okay?
Thank you.
All right, take care.
Thank you, Judge.
All right, in terms of pleas, do we have any that are ready? Oh, we have Mr. Abate back in here. Tell me, now that Mr. Abate's here, Mr. Tolles, what's going on with Mr. Norris?
What we're gonna do is you're aware he has 3 cases, and I was talking with Mr. Abate, and I met Mr. Hand for the first time. I'd asked Mr. Abate, I'll be honest with you, Judge, the trial calendar kind of snuck up on me. Mr. Nelson had sent me a calendar. For some reason, I didn't calendar it, and I didn't even realize things were going on until I started getting all the stuff from the state. So I thought something must be afoot, because I'm getting all these filings, and I called her, and it kind of just snuck up on me. I will be ready the next trial calendar, Judge. But I'm going on leave in October. The state's not ready next week. I was going to ask the court, would it be possible for this case to go on a motions calendar? There was a motion on the murder case. I wanted to have heard. And then I think that will give us more time to discuss resolution of the 3 matters.
You filed a motion to suppress. I'm looking at it. Okay, so you're challenging, he did give, according to you, Mr. Norris did give a statement. You've got concerns about whether he was properly Mirandized, if he was Mirandized at all.
Correct, and there was also a cell phone that was seized based on a 4th Amendment waiver and things of that nature that was also challenging as well, and I'd like to have that heard.
Okay, and it looks like the state has filed a 404B notice. So we need to talk about that anyway. So that seems like the right next step is to set down a hearing to argue and take evidence on the suppression motion and give the state a chance to proffer up and argue on the 404B. Does that work for you, Mr. Abadi? Okay. All right. We will handle it that way. Do I need to address Mr. Norris at all, or you're managing that?
I'm managing that, Judge.
Okay, appreciate it. Where are you going in October? This super secret, oh, Italy. All right, enjoy it.
Thank you, Judge.
Okay.
I believe these are my only case. If the court did anything else, I'd like to be excused.
You are.
Thank you, Judge.
Mr. Katz, we need to bring Mr. Warner out to get on the record, the state's offer, the consequences of saying no thanks, et cetera. And it's my understanding before he comes out that Mr. Abate is very ready to try it the week of the 17th. And you don't have a conflict then. So I can let Mr. Warner know this is what's happening.
I think we had a couple motions pending. I know there was a motion limiting.
Those we deal with then. That's not an issue. Okay. All right.
And Mr. Body is also graciously told me that he would keep the offer open, so plan to have another conversation at some point.
Well, then do we need to talk now, or I'm happy to tell him something, but if the state's going to leave the offer open, I don't add a whole lot of pressure to things other than to say, we're going to have your trial the week of the 17th. I'm happy to tell him that.
Well, that's fine, Judge. I think I'd just like to put it on the record now.
Okay.
Just so that we cover everything.
That's smart.
Just sometimes you have to get family members involved, and that's what happens.
For Mr. Warner, yes, please. Right to the podium. Great. All right. Ms. Rivers, are you ready?
Yes, Judge, I'm ready.
Great. Let's get on the record in State versus Warner. It's 20 SC 175773. We've got Mr. Warner here. Good afternoon.
Good afternoon.
And his lawyer, Mr. Katz, and the prosecutor, Mr. Abadi. Mr. Warner, Mr. Katz and the prosecutor and I had been talking a little bit, and Mr. Katz had shared with me he thought there may have been a non-trial resolution worked out. He said now, not so much. I just want to make sure everyone is on the same page. So I'm going to ask Mr. Abadi to tell me what the state's offer is, so that you've heard it, I've heard it, and it's on the record. And if you're saying no thank you to that, which is 100% you're right, you're doing that on the record. And then we'll map out what's happening next, which will be a trial in your case. Mr. Abadi, if Mr. Warner were interested in entering a plea in his case, and I think he only has one case here, what would the state be recommending?
The state would be recommending that count one murder would be reduced to voluntary manslaughter, which the state would recommend is 20 years to serve, followed by the felony murder would then vacate back operation of law. Same with count three would merge with count one, and then the remaining aggravated assault would be as to count 4, 10 years consecutive. So a global resolution of 30 years to serve, all parolable, followed by the rest of the indictment to, excuse me, I apologize. What we had negotiated was the aggravated assault would be 5 years, the possession of firearm and the commission of felony count 8 would be 5 years consecutive for a global resolution of 30 years. Everything else would run concurrent. And Mr. Katz requested today that if I would consider null processing count 7, which was the criminal damage to property in the first degree. I said, no problem.
Sure.
Do that based on the negotiations that we had. It didn't really change the global offer.
Okay, but it's 30 years. Mr. Warner would get credit for the 1,000-ish days that he's been in towards that 30. But importantly, it's a parolable sentence. Whereas if Mr. Warner would go to trial and be found guilty of murder, if he is, he would be eligible for a sentence of life without parole. Not saying that's what I'd give unless he's also a recidivist. I don't know.
He's not a recidivist. That would require the court gave him life without possibility parole, but the state would be asking for life without possibility parole consecutive, with a consecutive 75 years.
Okay, that's if there's a trial and big if you secure a guilty verdict.
That's correct.
Okay, so it's a big swing, but it's also a big number that you're offering.
Yes, and Mr. Katz is correct. I will leave it open, but I'm gonna leave it open until Friday. Next week is the holiday.
Okay,
But as we move into the following week, we'll be pressing again to make sure that we're ready for trial. We're ready for trial this upcoming week, so.
okay.
Spit them out with us.
So we're clear on the dates. Today is the 23rd. You're leaving the offer of the 30 years parolable until next Friday, which would be September 30th. If Mr. Katz hasn't gotten Mr. Warner in here, and we'll take a lunch break from the trial that I'm starting next week to do that, by close of business on the 30th, the state's withdrawing the offer, and this would be what we try the week of October 17th. Got it. Mr. Warner, has there been anything Mr. Abate described that you do not understand? Any questions about any of that?
No, sir.
You understand how things will flow?
Yes, sir.
If you want a trial, you'll get it. It will be the week of October 17th. You've waited long enough for that. And so we'll do that. If trial doesn't go well, the consequences are much more dire than the plea. If trial goes well, obviously, then there's no sentence, and you would be back amongst friends and family. If you don't have any other questions, then Mr. Katz, is there anything you want to add to the mix?
No, Judge, I've just gone over this case. Mr. Body and I have probably in nauseam have continuously negotiated, and this is where we've come up with. I've explained everything fully to Mr. Warner, and of course, obviously, it's his decision. And I'll probably speak to him again before next Friday, but that's where we are at this point.
No, please do. But you have done just that. I think we're about a year into negotiations, and you've been at times optimistic that it might work out in a way that's favorable to Mr. Warner, short of trial, because those are some serious stakes if he goes to trial. You're also right that it is 100% his call after he listens to your counsel. But if you could connect with him one more time next week, I know you have some time off next week and take that time off, but you'll be able to connect with him. And then you can just let Ms. Nelson know. And if we need to get Mr. Warner over on any of those last days of next week, we'll do it, and I'll pause the trial and we'll take a plea. If not, we know what we're doing the week of October 17th.
Very good, Judge.
All right, Mr. Warner, anything else?
No, sir.
All right, I'll either see you next week or a judge will see you the week of October 17th. Thank you.
Thank you, Judge.
So, Ms. Wood, the keeper of many pleas, Deputy Gordon has asked that we try to take pleas of folks in custody, if you have any of those. And then I know Ms. Taylor was ready to go for a while on Mr. Finley, so we might do that after we do our custodial pleas, but it's kind of congested back there. If you have any, if they're not signed up yet, then we will wait on those while folks get signed up.
He is not signed up yet. It will be a non-negotiated plea. I do have 3 out of custody people signed up and ready to go.
Okay. And he is the one who's not signed up yet is who?
Mr. Kenneth.
Bradley.
Yes, this is Bradley's name, Brantley.
Brantley. Okay. All right. And I know you had a colleague here. Is that someone who's helping sign people up?
She can take the judge. She wants to put more money on her meter.
Okay, great. So she might be able to take one of the non-negotiateds while you're back with Mr. Brantley, getting him signed up.
Correct.
Okay.
Your Honor, I'm sorry. For point of clarification, is this Brantley or is this Brown?
Oh, I haven't had a chance to talk to Mr. Brown yet.
Oh,
So it'll
okay.
be Brantley.
Okay, I just want to make sure, Your Honor, I had the right.
Yeah, position 20 is what I was talking about. I was just sensitive to the sheriff's needs to decrease population back there. So if that's all right, we're going to hold on the folks in custody. So why don't we do, because I committed to it, Mr. Findley, and then if we can do Mr. Mansfield, because we've got a lot of folks sitting around for Mr. Mansfield. We would do that unless there's some discussion we need to have before we do Mr. Mansfield. There's not. So we'll do Mr. Findley first, then we'll do Mr. Mansfield. Do you have other things here, or were you waiting to say, can I go now?
No, Judge, I was wondering if the court would inquire back to position 23, Raymond Carter. You could indicate that defense counsel.
Oh, right. Let's find out. Let's just get that inquiry. So Ms. Rockwell, what is Mr. Carter's pleasure? Are we going to see him next week for trial, or is he working his case out today?
Judge, I really think I need to at least glance over the discovery before I do a non-negotiated plea. Miss Woods trying to send it, for some reason it keeps bouncing back, maybe there's some HIPAA protection, so I think the state's trying to get it, axomevidence.com sent directly to me. So.
Okay. So what does that mean in terms of you want more time today? I'm not going anywhere. Or you we may see you on Monday for a plea, but for now, if it's not a plea, then it means it's a trial.
Right. And I figured that Judge, I really think I need to go to discovery with him.
I get it. I think that's a totally fair request. Mr. Carter's put himself in that position by bringing you on when he did, but he can work through that. You can get the discovery and you and he can speak. My understanding from Mr. Whitenauer is that if it works out next week, phenomenal, but it will be a plea as a recidivist, just like it would be a trial as a recidivist. So I'll excuse you and Mr. Carter and Mr. Whitenauer if that's the thing that was holding him here. I'll be happy to take a plea on Monday if it's going to be a plea. Just people need to understand the parameters of that based on Mr. Whitenauer's announcement. And if I don't see you all on Monday, I will likely see you on Tuesday, but I'll get an email out to everyone saying, this is the ranking.
And listen, I see some Zoom. If I can get it and look at it, I'm staying here because I have access to the computers downstairs.
Okay.
I'll
Just let Ms. Nelson know. We're going to press on with other stuff. Okay. Thank you, Mr. Whitenauer.
Can I excuse run to a doctor's appointment? I'll be back at 3:45 just in case Ms. Davenport, or just in case Ms. Wood gets a different decision from Mr. Davenport.
I can make that announcement and save you the trouble. I think he might be going back. Judge, that's not going to resolve today. I would like to inquire if Mr. Body would leave the current offer open. Thank you. So we're still working on that one, Judge. He did have a lot of family here and they also want to have a chance to tell him their thoughts.
Okay. Are they aligned with your thoughts or not aligned?
Closely.
Okay, good. I had received some good intel from Deputy Gordon that we weren't going to probably handle Davenport today. So go to the doctor, don't come back. I mean, come back, but you don't have to come here. All right? Yeah. All right, let me find. Here you are, position 8. All right, Ms. Rivers, are you ready?
I'm ready.
Great. This is position 8. It's 21 SC 177645, State versus Michael Findley. Ms. Wood represents Mr. Finley. They are both here at the podium. Ms. Taylor represents the state. Mr. Finley, in just a moment, Ms. Taylor is going to put you under oath. Once you're under oath, you need to answer her questions truthfully and completely. My questions also. You need to let Ms. Wood or me know if you've got any questions. This is a dialogue. Mostly you'll be saying yes or no, that kind of thing. But if at any point you've got a question because something doesn't make sense or it's different from what you and Ms. Wood had been talking about, I need you to stop things and let me know that. Will you do that?
Yes.
Great. When you're ready, Ms. Taylor.
Mr. Finley, if you could raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you? Yes. Thank you. And Your Honor, for the record, Mr. Finley is charged with 7 counts. He will be pleading to count 5, possession of cocaine today. Counts 1 through 4, as well as 6 and 7 will be no cross. And I will give a synopsis of that after.
I look forward to that.
Yes, Your Honor. Mr. Finley, if you could give us your full and correct name.
Michael Finley.
And at this time, are you under the influence of any medication or alcohol?
No,
How old are you?
I'm 38,
And how far have you gone in school?
11th.
So I'm assuming you are able to read, write, and understand the English language?
Yes,
Are you a United States citizen?
yes,
Have you had enough time to speak with your lawyer, Mrs. Woods, regarding all the facts and circumstances known to you regarding the charges in this indictment?
yes, ma'am.
Do you need any more time to speak with Mrs. Woods?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Now, Ms. Woods, do you waive formal reading of the indictment?
So waived.
And do you waive any defects in the indictment?
So waived for purposes of this hearing.
Now, Mr. Finley, do you understand that you're charged with 7 counts and that today you'll be pleading to count 5 possession of cocaine?
Yes.
Your Honor, again, counts 1 through 4, as well as count 6 and 7 will be no crossed. Mr. Finley, do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty, you may have the right to receive a jury trial.
Yes, ma'am.
Are you aware that there's a minimum of 1 year that you could serve and a maximum of 3 years that you can serve on a possession of cocaine charge?
Yes, ma'am.
Now, do you understand that this is a negotiated plea? And it
Yes.
means that the state will recommend to the court a sentence of 3 years to serve 4 months. That jail time can be commuted to time served, as I'm aware that you've already served at least that amount of time. The balance should be served on probation. There's also a special condition that you stay away from Tanika Miller, who is listed in the indictment, as well as stay away from the Texaco at 4555 Fulton Industrial Avenue in Atlanta. Are you?
Yes. Yes, ma'am.
You understand that the court does not have to accept this recommendation and that the court can sentence you to the maximum on these charges?
Yes, ma'am.
You understand that the judge, well, you understand that you are not eligible for first offender treatment based on your
Yes.
prior
Yes,
history?
ma'am. Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you do use, receive, possess, or transport a firearm, you may be guilty of an additional crime, which can carry a sentence of 1 to 5 years in prison?
Yes, ma'am.
And that in use of a firearm in any future crime, do you understand that you could serve a sentence of 15 years consecutive to any sentence that you have?
Yes, ma'am.
Now, do you understand that by pleading guilty, you're giving up the following rights?
Yes, ma'am.
The right to follow to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel, the right to presumption of innocence, the right to testify on your own behalf and to present evidence, the right to subpoena witnesses and compel production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of charges after a trial. Do you understand?
Yes, ma'am.
Now, has anyone forced, threatened, or promised you anything to get a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
In indictment 21 SC 177645, how do you plead to the allegation of possession of cocaine, which is count 5?
Guilty.
Do you understand that you may have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
And do you understand that if you do file a direct appeal, you must do so within 30 days of this date?
Yes, ma'am.
And if you wish to file a habeas corpus petition, you have 4 years from today to file said petition challenging the constitutionality of this guilty plea.
Yes, ma'am.
Your Honor, in support of his plea to count 5, basically the defendant during an investigation was found to be with a runaway juvenile. During questioning, Mr. Finley was later arrested. During a search incident to arrest, Mr. Finley was found to have cocaine on his person. Based on those facts, we came with the possession of cocaine charge. Now, as far as the counts that will be null prossed, again, 1 through 4 and 6 and 7, Your Honor, we have a situation where this case is from 2018. The victim and material witness in this case is basically unavailable. We have spoken with her. She is suffering from some trauma and is unable to recall the events that happened to her in 2018. There was probable cause for the arrest, as well as for the eventual indictment. However, rather than re-traumatize this victim who cannot recall anything that happened, give any details, put her through cross-examination and a trial, we have chosen to move forward with the case with this type of resolution. Mr. Finley is willing to move forward with his accountability for the possession of cocaine. So we all felt that that would be the best resolution in this case, Your Honor. The victim has been made aware of the plea negotiation.
Is she getting help for what she's working through?
She is, Your Honor.
Okay, good. And she's how old now?
She is 22, Your Honor.
Okay, all right. I appreciate you sharing all that. Do you have anything you want to share about Mr. Finley's criminal history?
So Mr. Finley does have at least 3 prior felony convictions. They were theft and assault type charges, Your Honor.
Okay, nothing along these lines?
Nothing along these lines at all.
Okay. Ms. Tucson, is Mr. Finley on active probation at this time?
I'm double checking. I did not see that, but just give me one more moment to check it again, since she said there was a conviction, but I didn't see. I'm looking one more time.
Okay. While she's looking, Mr. Finley, and I'll let Ms. Wood speak in a minute, your indictment has you as Michael Finley, AKA Malik Walton. Is that an alias you've used, or if we're looking for your criminal history, should we be looking under Walton instead of Finley?
My name is definitely Michael Finley.
Okay. I'm not doubting you, but where'd the Malik Walton come from?
That was probably 04 or something like that in DeKalb County, where I used the name.
Okay, and it has followed you around since then. Okay, got it.
Okay, yes, there is an alias. He's on current probation at the moment in Rockdale County.
He is?
Yes.
Correct. He
Okay,
is.
for what?
Theft by taking.
All right, for how much longer?
Looks like. That case ends in Rockdale, 8 months, 11 days.
Got it. Ms. Wood.
Thank you, Judge. Mr. Finley is 38 years old. He does live here in the metro area. He is gainfully employed with Fugitive Recovery Task Force for the past 1.5 years. He has 4 children, and he's also been with his partner for the past 7 years. He's so eager to get this behind him, Judge. It's from December 2019. I do appreciate ADA Taylor's thoroughness with this case. We've spoken many times about this, and so I think this is the appropriate outcome. I do want to get the dates on the record that he served. He was incarcerated in Fulton County Jail from December 3rd, 2019 to April 26th, 2020 for a total of 146 days. Otherwise, Judge, we would just ask that you accept the state's recommendation.
Okay. Mr. Finley, are you a bounty hunter?
No, sir.
What does it mean to have whatever job it was that Ms. Wood just said?
Okay, the Fugitive Task Force are bounty hunter services, but I don't work that department.
What do you do?
I'm actually a security guard.
A security guard? Where are you a security guard?
We have different stations. One is North DeKalb Mall. It's closed down, but there's a jewelry store, several jewelry stores there that we do, and we have apartment complexes, South Fulton, that we patrol.
Okay. Do you carry a weapon while you're patrolling?
No, this is an unarmed service.
Got it. Okay. Anything you want to add?
You don't have to say anything.
Okay. Well, Mr. Finley, I find there's a factual basis for your plea. To be clear, all you're pleading to is you had cocaine on you at the time you were arrested, December 3rd, 2019, which is almost 3 years ago. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this, but you've decided this is how you want to sort things out. And knowing means you've understood all the things we've talked about. Do you agree with both those?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have a small or technical violation, you and probation will work that out. But if it's bigger, you get arrested for something, or you are at the Texaco at 4 or 5 55 Fulton Industrial Boulevard. That comes back to me and we'll work through the consequences for your probation. Mr. Finley, I'm asking this question not because I'm going to make your sentence any more severe. I'm going to follow the recommendation here, but you had cocaine on you back in December 2019. Are you someone who struggles with drug use such that counseling would be helpful?
No, sir.
Okay. What was going on with cocaine at the time?
At that time, to be honest with you, Judge, I was selling drugs at that time.
Okay. So it was business as opposed to use.
Yes.
Understood. And then Tanika Walker, I assume that's someone you have not had any contact with for a good long time.
To be honest, Judge, I don't even know her.
Okay, that's going to make it easy to have no contact with her. I will follow the recommendation and on count 5, sentence you to 3 years. I'm actually going to change it a little bit just so how many days did you say it was? 120?
How many he served?
Yeah.
146.
Okay, great. So I'll follow the recommendation. Your sentence is 3 years to serve 4 months. You'll get credit for time served, so you're not going back into custody. And the balance is probated. So you will have 2 years and 8 months of probation. That'll be overlapping with your probation in Rockdale for 8 months. It will be a special condition of your probation that you stay away from Ms. Walker, which should be easy according to you because you don't know her. And you stay away from this Texaco on Fulton Industrial Boulevard. Do you know the Texaco I'm talking about?
Yes, sir.
All right, you don't know it anymore. No need to go there. If you got to get gas or do whatever you were doing, selling cocaine, don't do that anymore. But if you're going to hang out somewhere, hang out at a different gas station. Better yet, hang out at North DeKalb Mall where you're working. Do you have any questions about your sentence?
No, sir.
Ms. Toussaint, what kind of information do you need from Mr. Finley, or do you have it because he's under supervision now?
I will just verify what I have in the computer. And do you still live in Rockdale County?
No, I never lived in Rockdale.
Can you hear him? He's very quiet.
I can hear him.
Okay.
I never lived in Rockdale.
Okay, then I will need your address and phone number.
I have it written down, but what county will you be in?
Fulton.
Fulton? Okay.
Okay, then he'll need to report to 276. So if you give me your phone number, I will get all this information over to you.
770-896-6415.
770-896-6415.
Correct.
So Ms. Toussaint's going to call you in a minute. You'll give her your address, any other identifying information she needs. She'll give you reporting instructions. It's not far from here.
Okay.
Probation in Fulton County. And you'll only need to report to one place. They will be pulling in the Rockdale case too. So you're supervised by one officer for both cases.
Okay.
Ms. Taylor, anything else in Mr. Finley's case?
No, Your Honor. nothing else.
Thank you for your work on it. Ms. Wood, anything else?
No, Your Honor.
All right, that's it.
This is for you.
Thank you, Your Honor. May I be excused?
You may.
This is a call once you got it, okay? And I just wrote down the address for you. All right? Good luck to you.
It makes the most sense if Ms. Rosenhuber takes some negotiated fees if I speak to Mr. Brandon.
It would. Ms. Rosenhuber?
Yes, Your Honor.
That's how one says it. Okay. Whoa.
Spelled as it sounds.
I'm gonna do this.
Okay. So who are you ready to go forward on?
I'm ready on position 18, Mr. Harvey Johnson, as well as position 11, Mr. Marcus Blanding. And those are
Okay.
Present in the courtroom.
Let me ask about 2 other cases and then we'll make a plan. But we'll definitely do those. We still need to talk about Ortiz. Is that a long conversation or a short conversation?
I think it could be relatively short, Judge.
Okay, it's going to be infinite right now because we don't have Ms. Charles, but when you,
Definitely need Ms. Charles for that.
so your job is to find Ms. Charles and we'll have that conversation. And are we ready to go, Mr. Ebbett Tabai, on your client? Okay, so what I'm going to do actually is take that plea because we're keeping Ms. Singleton here for that. So we'll do Mr. Mansfield and then we'll do, remind me please by a show of hand, find the case, Harvey Johnson. All right, Mr. Johnson, you're going to be right after this plea, okay? So don't go far. But when we're done with Mr. Mansfield, we'll have our Ortiz discussion, and then we will take Mr. Johnson's plea. A lot of moving parts here. All right. Ms. Rivers, are you ready?
I am ready.
Okay. Before we get on the record, Mr. Shapiro, the way I've done these in the past, it's actually a full-blown plea. We don't do the sentencing. There's then an order, the terms of which you may describe on the record. That's up to you. But ultimately, an order that I enter, not a final disposition, because this is not yielding a conviction in superior court. It is locking in an admission of guilt and the conditions and terms of the order, and then it hands the case off to juvenile court.
That's all correct, Judge. And we've submitted to the court this afternoon a proposed order for that transfer to juvenile court. Defense counsel's had the opportunity to review that with his client. And so both the state defense counsel and Mr. Manfield have signed that order. So I will get the signature page submitted to Ms. Nelson as well.
Fantastic. And Mr. Ebert Tabai, that's your understanding of what we're doing.
Correct. We just signed the proposed order.
Good.
My client did sign it. I just signed it. It's the one I described earlier this morning. We reviewed it. He read it, and it's just ready for your signature, Your Honor.
Okay. Well, we'll get all that on the record once we get going. I just wanted to make sure I understood the procedure and didn't start doing something different. Okay. This is 22 SC 181494, State versus Jason Mansfield. Mr. Mansfield is here with his lawyer, and Mr. Shapiro is here for the state. Mr. Mansfield, are you ready to go forward?
Yes, sir.
Okay. Tell me how old you are.
16.
16. Mr. Mansfield, if at any point during our conversation we're having, when I'm talking to you or Mr. Shapiro is talking to you, if you have questions about what's going on, will you let your lawyer know?
Yes, sir.
You'll stop us so we can work through whatever your concern is. Will you do that?
Yes, sir.
Okay. Once Mr. Shapiro puts you under oath, because in a minute you're going to raise your right hand. Once you're under oath, it's important that everything you say is the truth. So it could be, I don't know if that's the truth, but make sure you're listening carefully and answering truthfully all his questions. Okay?
Okay.
Thank you.
All right, Mr. Mansfield, will you please raise your right hand? Do you swear or affirm that any statements or testimony you shall give in this matter before the court will be the truth, the whole truth, and nothing but the truth, so help you?
Yes, sir.
Thank you, Mr. Mansfield. And Judge, just for clarity of the record, Mr. Mansfield has been charged with 5 counts as part of this indictment. As part of the negotiated plea, the state will be entering a null cross as to counts 1, 3, and 4. So the plea will be only to count 2, involuntary manslaughter, and count 5, reckless conduct.
Okay.
All right, Mr. Mansfield, would you please state your true and correct legal name for the record?
Jason Gerard Mansfield, Jr.
Are you at this time taking or under the influence of any medications, drugs, or alcohol?
No, sir.
Is there any medication that you normally take that you have not taken today?
No, sir.
How old are you, Mr. Mansfield?
16.
And how far did you go in school?
I'm in the 10th.
Okay. Are you?
You're in school right now. I mean, not right now, but you are enrolled in school as a 10th grader.
Mhm.
Okay. And when you're answering, I'm sorry to keep interrupting you. When you're answering, make sure it's yes or no and not because the court reporter is going to just say he mumbled. So we just need to make sure yes, no, maybe, whatever it is, but full words. Okay.
Okay.
Thank you.
Excuse me, is the prosecutor near the microphone? He sounds underwater.
Is that better?
Yes, much better. Thank you.
All right, Mr. Mansfield, are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that in indictment number 22 SC 181494, you were charged with the offenses of murder in the 2nd degree, involuntary manslaughter, cruelty to children in the 2nd degree, possession of a firearm during the commission of a felony, and reckless conduct?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to those charges?
Yes, sir.
And do you understand that if you were to plead not guilty or were to remain silent and refuse to enter any plea at all, then the state would be required to prove those charges against you at a jury trial?
Yes, sir.
Mr. Mansfield, in agreement with the state and your attorney on your behalf, are you entering a plea to the offense of involuntary manslaughter and reckless conduct, involuntary manslaughter being a lesser included offense of murder in the 2nd degree?
Yes, sir.
And do you understand that your attorney on your behalf and the state have agreed to recommend that this case be transferred to juvenile court for disposition, and you are entering a guilty plea today for that express purpose?
Yes, sir.
And has your attorney advised you that this court will not handle the sentencing if the recommendation is accepted and disposition will then be handled in juvenile court of Fulton County?
Yes, sir.
And do you understand that this plea may result in a criminal conviction, but it will result in a juvenile court disposition, which may appear on your criminal history?
Yes, sir.
And do you understand that the disposition of this case could result in commitment to the Department of Juvenile Justice, which may include incarceration in a DJJ facility? However, it could also result in probation and release to the community. Are you aware of that?
Yes, sir.
And do you understand that disposition may involve a transfer of disposition to another state such as Florida if under the interstate compact for juveniles, you should end up residing with a parent or guardian outside of the jurisdiction of Georgia?
Yes, sir.
Is that something contemplated? There's family, you pick Florida specifically.
Judge, the state's aware that Mr. Mansfield's father, Jason Mansfield Sr., resides in Florida. At least that was the last known information to the state. And so given that that was a possibility that was discussed during several of the bond hearings that were had before this court, we simply wanted to cover that as a possibility that disposition could be had in a juvenile court in another state.
Sure.
Now, Mr. Mansfield, I'm holding in my hand what's called a waiver of rights form. You've had the opportunity to review this form with your attorney, correct?
Yes, sir.
And are those your initials in this form?
Yes, sir.
And did you have the opportunity to review and sign it with your attorney present?
Yes, sir.
All right, thank you very much, sir. Have you had enough time to speak with your attorney about the charges in the indictment, including all the facts and circumstances related to those charges?
Yes, sir.
Do you need additional time to discuss the case with your attorney?
No, sir.
And are you satisfied with your attorney's services?
Yes, sir.
And counsel, are we waiving a formal reading of the indictment for purposes of the plea?
Yes.
And are we waiving any and all defects in the indictment for purposes of this plea?
Yes.
Mr. Mansfield, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in any federal courts?
Yes, sir.
And do you understand that if you're placed on probation of any kind in juvenile court, that you cannot violate the criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes, sir.
And do you understand that if the juvenile court imposes any special conditions as part of your probation, you must follow all of those special conditions of your probation? Do you understand that?
Yes, sir.
And do you understand that if you were to fail to follow the special conditions of your probation, you may be subject to a revocation of that probation for the balance of your sentence?
Yes, sir.
Mr. Mansfield, do you understand that although this case is being transferred to juvenile court, it may or may not appear as a guilty conviction on your criminal history?
Sir.
And do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that?
Yes, sir.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, sir.
Have you ever pleaded guilty or nolo to, have you ever pleaded guilty or nolo contende or ever been convicted of a felony in the state of Georgia or in any other jurisdiction?
No, sir.
Have you been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, sir.
Has your lawyer explained the First Offender Act to you?
Yes, sir.
And you understand that if you were to violate the terms of your juvenile court disposition or commit a new offense while on probation, if probation is imposed by juvenile court, your first offender status could be revoked and you could be adjudicated guilty?
Yes, sir.
Do you understand that you are waiving any and all defenses, including any mental health defenses, by entering a guilty plea today?
Yes, sir.
And do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify yourself, or alternatively to remain silent and not incriminate yourself? Do you understand that you would have those rights?
Yes, sir.
And is your decision to waive those rights and to enter a guilty plea today?
Yes, sir.
Do you understand that by pleading guilty, you are also giving up the following rights: the right to the trial by jury, the right to remain silent and not to incriminate yourself, the right to confront witnesses against you, the right to the right to the assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, the right to testify on your behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, And finally, the right to appeal if convicted of these charges at a trial. Do you understand those rights, sir?
Yes, sir.
And do you understand that by entering a guilty plea, you're voluntarily waiving those rights?
Yes, sir.
Mr. Mansfield, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Mr. Mansfield, in indictment number 22 SC 181494, how do you plead to the offenses of involuntary manslaughter and reckless conduct?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
So you pause for a minute, Mr. Mansfield. I just want to make sure you understand what you're charged with and that the state is going to dismiss, Mr. Shapiro used a fancier term, but they're going to dismiss the most serious charge and some of the related ones. But you understand what this case is all about?
Yes, sir.
Okay.
Mr. Mansfield, do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that if you wish to challenge the voluntariness or any other constitutional aspect of this guilty plea, you must do so by filing what's called a habeas corpus petition?
Yes, sir.
And do you understand that for reckless conduct, which is a misdemeanor conviction, you have only 12 months from today to file a habeas corpus petition?
Yes, sir.
And do you understand that for any felonies, including involuntary manslaughter, you have 4 years from today to file a habeas corpus petition?
Yes, sir.
All right, thank you very much, Mr. Mansfield. Your Honor, as to the factual basis for this plea, on November 13th of 2021, officers with the Atlanta Police Department were dispatched to 2060 Allison Court Southwest, apartment B3 in response to reports of a person that was shot at that location. Upon arriving at the apartment, the officers entered and discovered lying on the ground of the living room area the victim, who was later identified as Caden Jones, who is age 8 with what appeared to be a single gunshot wound to his head. Caden Jones, the victim, is the stepbrother of the defendant, Mr. Mansfield. Officers observed that Caden was not breathing. They began administering chest compressions. They then spoke to the defendant, Mr. Mansfield, who had placed the call to 911 to report the person having been shot. The defendant gave a very brief statement to officers while on the scene that stated in sum and substance that Caden had accidentally shot himself with an AR-15 style rifle that was in the apartment. Officers located that rifle in a master bedroom towards the back of the apartment, and they also located a loaded magazine in the bathroom of the apartment placed on top of a toilet. Grady EMS arrived at the scene and transported Caden to Grady Hospital, where he was later pronounced deceased. The mother of the victim, Caden Jones, and the defendant, Mr. Mansfield, her name is Ms. Parker, was notified, and she was asked to report to APD headquarters where Mr. Mansfield had been transported. Both of them were then placed in an interview room. Mr. Mansfield was advised of and decided to waive his rights under Miranda. He then gave a statement to officers alleging that he had been left to care for Caden while his mother was out that evening. And that at some point during the night, he had heard what he believed to be someone attempting to break into the apartment through a back door. At that time, he went and retrieved the AR-15 rifle from under the bedroom, under the bed in that back bedroom. He then came out to the kitchen area, threatened the intruder, told him to leave, and stated that after approximately 10 minutes, he left the rifle unattended. In that kitchen area. He then went to his bedroom where he took a nap, and after awaking, went to the bathroom to shower. He stated that while in the bathroom, he heard a single gunshot, rushed out to the living room area where he discovered Caden lying on the floor with the gunshot wound and the rifle lying next to him. As part of the investigation of this case, Dr. Michael Henninger with the Fulton County Medical Examiner's Office conducted an autopsy of the victim. For purposes of the plea, what's most notable in the medical examiner's report is that Dr. Henninger did not discover any soot or stippling around the entrance wound. Caden ultimately died of a single gunshot wound to the head area.
From a distance.
That's correct, Judge. The medical examiner's report also allowed investigators to conduct measurements, which confirmed that Caden's reach would have been unable to trigger the rifle. All of that led to the exclusion of a self-inflicted gunshot wound as the cause of death. And so the death was ultimately ruled a homicide. As part of the investigation, investigators also obtained the victim and the defendant's cell phones and completed a data download where they discovered several photos taken weeks before this incident occurred in which both the victim and the defendant were seen posing with the rifle. Finally, on December 1st of 2021, Mr. Mansfield, along with his father, Jason Mansfield Sr., returned to APD headquarters to be re-interviewed. And at that time, Mr. Mansfield gave a somewhat differing account of what transpired that night. After again being read and explained his Miranda rights, he stated that he and Caden were alone in the apartment that evening, that they had ordered food around 8 p.m. And at that time, he went and retrieved the AR-15 from the master bedroom. He removed the clip from the rifle, placing it on the toilet where it was later discovered by officers. However, he neglected to remove the single round that had been chambered in the rifle. The rifle at some point was taken off of safety. Mr. Mansfield admits to having fingered the trigger, which ultimately caused the fatal shot to Caden. So at that time, Detective Ronald Slust with APD obtained warrants for his arrest. The defendant was taken into custody and transported to Metro Detention Center at that time. As Your Honor has noted, under the concurrent jurisdiction statute, which is OCGA 15-11-560, the court would have original jurisdiction over this matter since it is a juvenile charged with murder in the second degree. However, under subsection F of that statute, the court has the ability to transfer this matter for disposition to juvenile court upon conviction of a lesser included offense. And so in conference with defense counsel for Mr. Mansfield, both the state and the defendant are requesting that under that subsection, this matter be transferred to juvenile court for disposition. And as I've stated, we've submitted a proposed order to the court to that effect. And finally, Judge, I'll just state that the state has been in contact with Ms. Parker, who is the mother of both Mr. Mansfield and the victim. The family is in agreement with this resolution. This appears to have been a very tragic accident in which Caden unfortunately died, but we believe that transfer to juvenile court for ultimate disposition is the most appropriate course of action.
So Caden, the deceased, was a half-brother or a step-brother of Mr. Mansfield?
It's my understanding that Ms. Parker is the mother of both Caden and Mr. Mansfield. However, and all out defense counsel, correct me if I'm wrong here, they do have different fathers.
Okay, so they're half-brothers, and Mr. Mansfield Sr., the person who accompanied the defendant down to APS for the final version, the most truthful of the versions, that would be the defendant's father, but not Caden Jones's biological father.
That's correct, Your Honor.
Okay.
That's the state's understanding, at least.
Understood. Okay. Ms. Singleton, is there any juvenile history that I ought to be factoring in as I think about someone who is approaching adulthood from the criminal justice perspective being sent back? We don't usually see someone who's 16 going back to juvenile court for final disposition. 13, maybe 14. So this is a little older. I don't have an issue with it as long as you're not about to tell me, well, this is the 9th time he shot someone.
No, Your Honor, the defendant has no prior history.
Okay, thank you. Mr. Ebotabai, anything you want to add?
Yes, Your Honor. I would just want to mention the fact that if the court agrees to transfer this matter to juvenile court, even though the state has gone lengthily into the sentencing aspect, granted the fact that it will be disposed of at the juvenile court, the sentencing aspect will be handled at that level. And Mr. Mansfield will be subject to the regime, whatever regime he's placed at the juvenile center. That being said, Your Honor, what we have here is an accused and a victim. The circumstances of this incident, this unfortunate incident, is very tragic. During my interaction with Mr. Mansfield, I find him broken, including this afternoon. So it's unfortunate it happened, but that's what we have to deal with. These were two kids playing. It could have happened any home, any two sets of kids. As the state mentioned, they've done it before. They got away with it. And
any home with a loaded AR-15 sitting around in it. It could not happen in my home.
Thank you. Thank you for that. Thank you for that correction. But the idea of a single round always being forgotten in a gun has always come back to cause tragedies like this, which is what didn't occur to him. But Your Honor, we are praying and asking the court to accept the terms of the negotiated plea. All said and done, Mr. Mansfield is going to live with this the rest of his life. That punishment in itself is one that no court can hand down. No court. Whatever punishment he receives here, he can walk through it. But the idea of living with the consequences of what happened, it's in itself a major burden. So we are praying that the court accept the plea as negotiated. We are hopeful that when we go to the juvenile court, we'll be able to, again, explain why the punishment, he's already undergone a lot. His education is already being affected now because he now have to look for a different school and all things that might not be necessary for us to go into. But we would pray that the court accept the plea as arranged.
Okay. I have the proposed order here. You've reviewed it and the terms of the order are satisfactory to you.
Yes, Your Honor.
Okay. And so, Mr. Shapiro, assuming I accept the plea, which I'm about to do, what I'll actually be signing is this order, and that will affect the transfer of this case, Mr. Mansfield's case, from Superior Court to Juvenile Court. And it will, Mr. Ibo Tobias will stay with it, with Mr. Mansfield, but you'll have a colleague who is dealing with it in Juvenile Court?
Judge, the process for transfer to juvenile court has already been handled on the state's end. This case has been reviewed by the deputy over SB 440 unit, as well as the deputy over juvenile court. They've approved of the transfer. So once the order is entered, I'll provide a copy to Ms. Singleton, because it's my understanding she will then be terminating services for Mr. Mansfield. But once that is done, the transfer to juvenile court will happen within the district attorney's office.
Okay.
It's my understanding that immediately it's transferred, the juvenile court would contact me. On a previous case I did, we started with a conference at the level of the juvenile court, where an idea of where we're going with it. There will be another whole series of negotiations with the guys over there. There's one thing I forgot. Ms. Singleton indicated that his ankle monitor would have to be taken off in a day or two before.
It'll be removed after I get the order.
Got it. She's going to wait till it's official, then she can take care of that.
Okay.
All right. Mr. Mansfield, do you have any questions about any of the things we've been talking about?
No, sir.
Okay. Are you living with your mother right now or your father?
My sister.
Your sister. Okay. Is she here today? Okay. Where is she? Right there. Great. Thank you for being here. Mr. Mansfield, I find there is a factual basis for your plea. I think we all understand, in a sense, what happened, the tragedy that occurred. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this, but you've talked about it with the people you trust and care about, and you've decided that this is the right way to move forward. Is that correct?
Yes, sir.
And a knowing plea is just one where a defendant understands all the things that people have been talking to him about. Is that you?
Yes, sir.
Okay, then I'm going to accept your plea. I will sign the paperwork that will transfer your case to juvenile court so that the ultimate resolution will be there. My hope is that what that resolution is something that gets you some help, in the sense that you have gone through something that no one age 15 or 16 should ever have to do. You watched your brother die. And to Mr. Ibo Tobias' point, that's going to be with you forever. We would lock you up for 10 years, and that doesn't heal that part of what you went through. And it doesn't sound like this is a case where there's the dangerous aspect that we need to protect people from, because this wasn't someone being hostile or aggressive. It was someone being careless and had real tragic outcome. So I'm sorry for your family's loss. I'm sorry for you because you caused that loss. And that's a real heavy burden for someone my age. I'm old. It's got to be real tough for you as you're navigating all the complicated things about being a 10th grader and figuring out what you're going to do with yourself. So I hope juvenile court in your journey there results in some kind of outcome that helps you out some, because we can't bring Caden back. Mr. Ebo Tabai, I appreciate your help on behalf of Mr. Mansfield, and Mr. Shapiro, I appreciate the district attorney's office's approach to this case. This seems like a way to salvage something out of a real sad story. Anything else from the state?
Nothing from the state, Judge.
Anything else from the defense?
No, we just need to extend our appreciation to the state. They've been very diligent. They listen to us, we listen to them. And like you said, this is a testament to our judicial system. We accommodate the circumstances of each case and tailor the outcome as best as we could see fit.
Yep.
We appreciate the court having giving us an ear and willing to work with the outcome.
Ms. Singleton, anything you need to get on the record in connection with Mr. Mansfield's case? Okay. You had mentioned a signature page. Does it make more sense for me to take from you the copy that everyone has signed and I'll sign it and then we can just scan it in?
I think so, Judge. I was going to provide it to Ms. Nelson. So.
Okay, why don't you do that? And is that something that they filled out that you're holding, or is that a different case? But in this case?
Yes, Judge.
Okay. Mr. Mansfield, I have two documents in my hand. One is called the waiver of rights. It's something, it's called plea of guilty, but it's something that your lawyer went over with you, a bunch of questions. Can you read and write English? You satisfied with your lawyer? A bunch of initials you put everywhere. Did you go over this with your lawyer?
Yes, sir.
And did you sign it?
Yes, sir.
And Mr. Ebo Tabai, you signed it as well?
Yes, Your Honor.
Just as important is the order I'm going to sign that transfers your case to juvenile court. And on the back, there's a place for all sorts of signatures, including Jason Mansfield. Is that your signature on there?
Yes, sir.
And Mr. Ebo Tabai, you have a fascinating signature. Is that yours on there?
I did the wet signature, Your Honor.
Okay. And it looks like we have two district attorney signatures on this, making this doubly official. All right. That's it. We're going to move on to the next case. Thank you for your time.
Thank you, Your Honor. Will we be excused?
You may.
And Judge, I need to confer with Ms. Nelson for just a second, but that's my last matter. May I be excused?
You may, after Ms. Nelson excuses you. Okay. Ortiz, can we talk briefly about Ortiz while we are getting Mr. Harvey Johnson up to the podium? Do we need to get it on the record, or we can just chat?
I think we can just chat.
Okay, you can come a little closer and we'll let those folks get situated. I'm well. So Ms. Charles had told me that she thought this was something that might work out, but there's a hiccup. So I just need to know, not so much what the hiccup is unless I need to know that, but what's next for this, because it's on a trial calendar. And so I'm happy to bring everyone in for that if that's where we're headed.
Oh, he's not here.
So the victim is not I thought the victim was a kid. It's not a kid. It would be significant other. Okay. Is that who's sitting back there? Okay. Great. Good.
So she's living in Los Angeles. The biggest issue is
I mean, I can wait.
I'm Sarah.
I'm here. Nice to meet you, Sarah.
So we're going to be checking out if we do come up
And you got to hear how they went through the comments. Do you have any questions about anything? Okay. How old are your kiddos? How old are your kids?
Oh, I have a 2-year-old, 1-year-old, 2 6-year-olds, and a 7-year-old.
You got your plate full.
Yeah.
So So they both have immigration issues. Okay.
So what we were trying to do, not negotiate, what she would prefer. That's when the mediation came up because she tried to go to a civil attorney and because they're not married, but no one helped.
Sure. It's not like there's a, okay.
And so we.
But people could enter into contracts that would say, here's what we're going to do.
We were invited to say she would like us to not disturb her.
Hmm.
He now lives in DeKalb County, I understand with his sister.
And are the things he needs to put in her name?
If she would even agree either to keep, there's another car that's needs some work, but she needs to hold on to that car. It's also in his name.
Okay.
She would want him to sell, trade it in. So he would agree in writing to give her the car, but she has to get around to find the son. And the house is the biggest thing, whether he would be inclined to allow her to stay there or would it be something they have to petition, sell and get some money because she pays the bills in his name.
Sure. But then that would be if they don't agree, another lawsuit of, well, what would her, based on her contributions, what does she get from the sale? It sounds like it's the kind of thing where there could be some arrangements made between the two of them that are definitely outside the four corners of a resolution here. Time is of the essence because we may need to try the case. How much time do you all need to bring in a third party, a second party to help sort this out?
We're more than happy to negotiate along the lines. Me and Michelle's on the same page. It's a matter of, we're more than comfortable doing negotiations on behalf of our client, whatever they may be. If she wants to retain counsel, I think that would probably be the time counsel, not her to retain counsel.
Okay.
As much time as the court feels reasonable.
Well, I think it's reasonable as we try the case since it's on the calendar, but I'm not going to, I mean, it sounds like we're heading in a different direction. So I'd like to keep the pressure on. And you certainly don't represent the victim. I get that. And so.
She wasn't sure. So I would like to tell her he's open to that negotiation.
Right.
And then see, because she's like, she's spoken to her attorney, so she's able to do so and see how quickly.
So you could do dual purpose. You could handle civil negotiations for Mr. Ortiz. Okay. Yeah. Okay. Right, because Mr. Cooper can speak with her. Yeah.
I can absolutely speak with her. Absolutely.
So why don't we do this? This won't be on the first week. I'm going to keep it on the second week, which is October 17th. That's a ways away. And Ms. Nelson is going to poke you guys in about a week or so to say, where are we progress wise? Because if you reach a point where you know that we are able to do this, but it just absolutely cannot be before October 17th, and I believe you, then we'll say, all right, we'll move it out. Otherwise, I want to keep that pressure of serious charges and we got to move forward. You've got your victim in hand, so it's not where people are, just to keep people very focused on coming up with a resolution. Does that work? Great. All right. You're welcome. I'm sorry to keep you standing right there.
Judge, with the court's permission, could we take the plea for position number 11, Mr. Blanding first?
That's fine, as long as you're not breaking the other guy's heart. He seemed pretty excited he was about to plead. If you're managing that, that's fine.
He's been very, very gracious, Judge.
All right, thank you for being gracious. Let me just write one thing down based on that conversation. All right, which position number did you say? Number 11, this is Mr. Blanding?
That's correct.
Got it. Okay. Yes, yeah, that's your space. You don't have to ask. Make sure you use that microphone so Ms. Rivers can hear you. Ms. Rivers, are you ready?
I am ready.
Great. This is position 11 on our trial calendar, State versus Marcus Blanding, 21 SC 178584. And we have representing Mr. Blanding, Ms. Rosenhoover.
That's correct.
From where?
I'm from Peachtree City, Georgia, but I work with the public defender.
Sorry, I didn't ask that well. You're usually in a different courtroom.
That's
You could be from Texas, as long as you got a Georgia bar license. What courtroom are you normally in?
So I'm in the pink division. I just started.
Oh, the pink,
But I've been an attorney.
Oh.
I'm brand new to this.
Yes,
court.
yeah.
okay. You've taken a plea before?
Yes, Judge. I worked in Carroll County and Superior Court for 2 years.
Excellent. Okay. So Ms. Rosenhoover is handling Mr. Blanding's plea on the defense side. We've got Mr. Hand ready to go for the state. Mr. Blanding, in just a moment, Mr. Hand's going to put you under oath. You've seen how that works for other folks. Make sure you provide truthful answers. And please make sure you let Ms. Rosenhoover or me know if you've got your own questions, okay?
Yes, sir.
Thanks so much. When you're ready, Mr. Hand.
Thank you, Your Honor. Can you raise your right hand for me, sir? Do you swear that the testimony that you're about to give this court for the matter before the court is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can lower your hand. Please state your full name for the court.
Marcus Lee on the Blanding.
And Mr. Blanding, are you currently taking or under the influence of any medicine, drugs, or alcohol at the moment?
No, sir.
Is there any medication that you would normally take that you have not taken or been given already today?
No, sir.
Okay. And how far have you gone in school?
Graduate.
I'm sorry?
Graduated.
Graduate, is it high school, college?
Yes, high school.
Okay. Can you say your age again? I'm sorry.
31.
Okay, 31, you finished high school.
Yes, sir.
Great.
That was my next question. 31 years old. How far have you, okay, sorry. Is it accurate that you can read, write, and understand the English language, Mr. Blanding?
Yes, sir.
And do you understand that you have been charged with the following charges today? Those are burglary in the second degree and theft by taking, and indictment 21 SC 178584.
Yes, sir.
Do you understand that you have the right to plead guilty or not guilty to the charges today?
Yes, sir.
Do you understand that if you plead not guilty or remain silent or refuse to enter a plea at all, that the state is required to prove the charges against you at a jury trial?
Yes, sir.
Have you had an opportunity to review your rights with your attorney today?
Yes, sir.
Have you had enough time to speak with your lawyer about all of the charges in your indictment?
Yes, sir.
Would you like more time to speak with your lawyer?
No, sir.
And are you satisfied with your lawyer services today?
Yes, sir.
And I'm sorry, Attorney
Rosenhoover.
Rosenhoover.
From Carroll County
From Carroll County.
in Peachtree City.
Do you waive a formal reading of the indictment for purposes of today's plea?
Yes, I do.
And do you waive any and all defects in the indictment for purposes of the plea today?
I do.
And Your Honor, never mind.
Okay, I was ready for you.
Mr. Blanding, do you understand that the minimum and maximum charges in your case, the minimum and maximum sentence for each charge in your case today are 1 to 5 years imprisonment for the burglary in the second degree charge, and then 1 to 5 years as well for the theft by taking based on the value of the items taken?
Yes, sir.
And do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence? That recommendation is 5 years probation, restitution in the amount of $2,385, and a stay away from 4600 Roswell Road, which is the business gateway Chastain.
Yes, sir.
Can you, I missed one, I got the stay away, the restitution amount?
Yes, Your Honor, $2,385.
That's for the pressure washer?
Yeah, and the attachments.
Okay, and then did you say the actual sentence or you?
That's the recommendation.
Right, but what was the recommendation?
Just 5 years.
5P?
Yes.
Okay,
For total, Your Honor.
understood. Thank you.
Mr. Blanding, do you understand that the court is not required to accept the state's recommended sentence today?
Yes, sir.
And do you understand that the court has the right to sentence you to the maximum sentence for each charge today?
Yes, sir.
And do you understand that if there are multiple charges, which there are, which you're pleading guilty to today, the court also has the right to run those charges consecutively,
Yes, sir.
which means one after the other?
Yes, sir.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea that you're expecting today, that you have the right to withdraw your plea of guilty?
Yes, sir.
Do you understand that if you are currently on probation or parole, that probation or parole may be revoked based on you entering a guilty plea today?
Yes, sir.
And do you understand that if you are placed on probation of any kind, which is the recommendation today, that you cannot violate any criminal laws of any governmental unit, that being municipal, county, state, or federal?
Yes, sir.
Do you understand that if you are on probation, you must follow all of the special conditions of your probation, including any restitution order?
Yes, sir.
Do you understand that if you fail to follow all of the special conditions of your probation, then you will be subject to revocation of that probation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess, use a firearm while you're on probation?
Yes, sir.
Mr. Blanding, are you a U.S. citizen?
Yes, sir.
Do you understand that by pleading guilty to a charge that you may not receive, possess, or transport a firearm ever?
Yes, sir.
Do you understand that doing so will result in new criminal charges for which you will face a sentence between 1 and 10 years?
Yes, sir.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, sir.
Do you understand that you're giving up the following rights? Those include the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a jury trial?
Yes, sir.
So is it your decision to waive these rights, which means to not use them, and enter a guilty plea today?
Yes, sir.
Has anyone forced, threatened, or promised you in any way to get you to enter into a guilty plea?
No, sir.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charges of burglary in the second degree and theft by taking in indictment 21 SC 178584?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
And do you understand that if you wish to challenge the voluntariness of this guilty plea, you must do so by filing a document that's called a habeas corpus petition?
Yes, sir.
Do you understand that for a felony, you only have 4 years from today to file this habeas corpus petition?
Yes, sir.
And for they're both felonies. At this time, Your Honor, I'll give a factual basis for the plea today.
All right.
On August 31st, in 2022, at about 1:30 p.m. at 4600 Roswell Road in Sandy Springs, the defendant was a former employee at the time. He was terminated from that particular location. He entered the premises wearing his previous work uniform, went into the storage unit on the premises and took a pressure washer valued at $1,595 and accessories, which included a wand, hose, and surfacing attachment, all valued together at $800. 2 employees witnessed the defendant walk into the storage room. The defendant told the employees that he worked for another company and that he needed the equipment. And then he took the items and left. On September 2nd, a few days later, Melissa Uhas, that's spelled Y-U-H-A-S, who works at the company, called the police and reported the items being stolen. And she identified Mr. Blanding as being the one who entered the storage area, who had spoken with the other individuals who witnessed him being there.
So they knew who he was?
No, Your Honor, they did not know who he was. But Miss Melissa Uhas knew who he was based on the description to her of who
Got
took
it.
the items.
These two people.
Witnesses told her, yes, Your Honor.
It's this guy, he looked like this, and she says, that's got to be Blanding.
Yes, Your Honor.
Okay.
And then She identified him. The security guard was new, did not know who he was, but he was the one who was told that he was an employee there as well. And so that's how he got in. He didn't know he was no longer working there, Your Honor. Also, another employee, Ron Hitzman, identified him as well, was there that day and was familiar with his vehicle, saw him leave the premises with those two items.
Okay.
That's the factual basis, Your Honor. I would like to add that as far as criminal history, the state is aware of 2 convictions, one out of DeKalb County for VGCSA in 2012, and then a second conviction for the same VGCSA violation, and that was out of Clayton County, Your Honor, in 2018. At this time, the state would just request that the court accept the plea as offered.
4 years probation, $2,385 restitution, and stay away from this location.
5 years, Your Honor, and yes.
Did it? I wrote 5. What did I say?
Oh, I thought you said 4.
I may have. It's 4 o'clock. The indictment says it's the property of Core Property Capital. In other words, that's to whom the restitution would go. But I thought you gave the name of the company for which Mr. Blanding had worked as something different.
Yes, Your Honor. I have Gateway Chastain.
I just need to know to whom the restitution needs to be paid, because Mr. Blanding will be providing a little bit of money as time goes on to probation, and they need to get it to the right place.
It should be who's listed in the indictment, Your Honor. So that would be the company that you just.
Okay. What is if you've got police report paperwork in there, Ms. Uhas is listed here. What does it say where Ms. Uhas works?
Well, Ms. Uhas is employee. Okay, I see what you're saying.
Because I can always amend the sentence to change the name of the company, but Core Property Capital sounds like the landlord, like the people who own the office complex, and they're not. You may know, Mr. Blanding.
Yeah, it was U.S. Merchant Services.
U.S. Merchant Services?
Yeah.
That's the company you used to work for.
Yeah, USMS.
USMS. Okay, U.S. Merchant Services. That was your employer. So Ms. Uhas works for U.S. Merchant Services.
Yeah, but it was the Gateway property. It was the Gateway property, but the company was U.S. Merchant Services.
Okay, Gateway property, I mean, that's the name of the property.
Yeah, that was on.
Got it. Okay.
And Your Honor, if it will help at all, U.S. Merchant Services is a subsidiary of Core Property Capital.
Oh, okay. Then we'll use Core Property Capital.
Yes, Your Honor.
Might as well pay the parent. Okay, that's very helpful. All right. Ms. Rosenhoover,
Yes, Judge.
anything you want to add?
We would just ask that the court accepts the negotiated agreement. I believe there may have been an agreement with the state and defense that termination or that probation could terminate upon payment of restitution. But I know that that wasn't listed. Is that something the state would?
That is correct. Your Honor, the state would not object. That was the agreement that we wouldn't object to terminating.
Okay, well, I'll let probation work through that. Let me ask Ms. Tucson, is Mr. Blanding on active probation anywhere? And did you have any other convictions beyond the 2 that Mr. Hand mentioned?
He is currently on probation at the moment. Expires July 5th, 2023. So he has 9 months, 12 days remaining on this case. And that is for Clayton County.
Okay.
And then there's a DeKalb County one as well. So.
Okay, great. Mr. Blanding, anything you want to add? You've heard people talking about you. Anything you want to share?
No, sir.
Okay. Was this a crime of opportunity, or were you mad at your former employer? What was behind it? Just I'm curious.
Stupid decision.
Definitely that. I see on that one. You just figured you could get away with it because you had on the uniform?
Yeah.
Okay. And what happened to the pressure washer?
I no longer have it. I no longer possess it.
But did you use it professionally or did you fence it? You sold it to someone else?
No, sir. I actually, yeah, I sold it to someone.
Okay. All right. Well, Mr. Blanding, I find there's a factual basis for your plea, for your stupid decision, in that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this. You agree?
Yes, sir.
And knowing means you've understood all the things we've been talking about because of the help of your lawyer. You also agree with that?
Yes, sir.
You'd be sentenced pursuant to the Probation Option Management Act, which means that while you're on probation, if you have a small or technical violation, you and probation can work that one out. But if it is more serious, you get arrested again, something like that, that'll come back to me and you and I will work it out. Do you, Mr. Blanding, authorize my staff to sign the indictment indicating your guilty plea? We don't pass those around anymore. Is that all right?
Yes, sir.
And Ms. Rosenhoover, may we sign for you?
Yes, please.
And Mr. Hand?
Yes, Your Honor.
Excellent. Mr. Blanding, I will follow the recommendation that has been shared with me, the negotiated outcome. You will have a sentence of 5 years probation on count 1 and 5 years probation on count 2. Those will run concurrently with each other at the same time.
Yes, sir.
Special condition of probation number 1, you will pay $2,385 of restitution to core property capital. You don't have to pay that all at once. You'll pay it as you are able. If you are rolling up in a Mercedes each time you report to probation, they're going to wonder why you're paying $5 a month. But if you're working hard, trying to make ends meet, you'll pay as you are able. It will also be a special condition of your probation that you stay away from that address I don't know if the address, I guess it is 4600 Roswell Road in Sandy Springs. Where do you live these days? What town?
Oh, DeKalb County.
DeKalb. Any reason to be in Sandy Springs?
No, I was just there because I used to work there.
Okay. Well, how about this? Just stay out of Sandy Springs.
Yes, sir.
Done. So you'll stay out of Sandy Springs while you're on probation. And I am perfectly open to your probation ending early if you have paid your restitution, but I defer to probation. They'll decide that. If you are low maintenance, not bothering them, working hard, staying out of trouble, then the only reason they're going to keep you on probation is to pay the restitution. And as soon as you hand in that final amount, they're going to say, great, let's either suspend the probation or close the case out. And I will happily sign that order. But I'm going to leave that up to them.
Yes, sir. Thank
you. All right. Are you working now?
Currently, yes.
Doing what?
The same type of work, landscape.
Okay. With equipment that the company owns?
No, sir. Most definitely.
I mean, like you're working with the equipment that belongs to the people doing the work.
No. The people that gave me the job, I use their equipment.
That's what I meant to say. Thank you. Okay. Anything else, Mr. Hand?
No, Your Honor, not from the state.
Anything from the defense?
No, Your Honor.
All right. Ms. Tucson, do you need information from Mr. Blanding?
Do you still reside on Crest Lane?
Yes, ma'am.
And is your phone number 770-771-8079?
Yes, ma'am. But
Okay.
currently, that number, my phone is cracked. So can you, if you send any information over, can you send it to my email, or I can give you another number at this moment to use until I get my cell phone fixed?
Yes, that's fine. May I have the number?
Yes, it's 470-595-2052.
Okay, like right now after court, is this a number I can call you on?
Yes, ma'am.
Okay, I will give you a call on this number 470-595-2052.
Yes, ma'am.
Okay, yeah, and I'll give you your reporting date.
All right.
And as far as the restitution goes, may I have that email to me where it's supposed to be paid?
Sure. It'll be on the sentencing information as well, but you can get that from us.
Okay, thank you.
All right. Thanks, everyone. You're done.
Thank you.
Thanks, Mr. Blanding. Good luck with things. Keep your phone on you.
Yes, ma'am.
All right.
Who, Mr. Shapiro?
Judge, can I just approach briefly?
Me or Ms. Nelson?
Ms. Nelson.
Sure.
Thank you.
Go for it. Who's next?
You.
Mr. Johnson.
Yes, we're ready again on position 18, Judge.
All right, Mr. Johnson, come on up. You ready, Mr. Hand?
Yes, Your Honor.
All right. This is position 18, 21 SC 179818, Harvey Paul Johnson, represented for now by Ms. Rosenhoover. We have Mr. Hand as the prosecutor. Mr. Johnson, you ready to go forward?
Yes, I am.
Okay. You are wearing the world's smallest tie, but it looks good. Mr. Johnson, Mr. Hand is going to put you under oath in just a moment. Once you're under oath, make sure you answer his questions and mine truthfully, and let your lawyer or me know if you've got your own questions, okay?
Yes, sir.
Great, let's go.
Raise your hand for me, please. All right. Do you swear to tell the truth, the whole, do you swear or affirm that the statements and testimony that you shall give in today's proceeding for the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can lower your hand. Thank you. Please state your full and correct name for the court.
Harvey Paul Johnson, Jr.
And are you currently taking or under the influence of any medicine, drugs, or alcohol?
No, I'm not.
Is there any medication that you normally take that you have not had an opportunity to take or been given today?
Hydrochlorothiazide, HTCZ blood pressure medication.
Okay, and does that affect your ability to understand today's proceeding?
No.
Okay. How old are you, Mr. Johnson?
I'm 36.
And how far have you gone in school?
The 10th grade.
Can you read, write, and understand the English language?
Yes, I can.
And do you understand that you've been charged with the following offenses today? Those are burglary in the second degree and possession of tools for commission of a crime in indictment 21 SC 179818.
Yes, I do.
Do you understand that you have the right to plead guilty or not guilty to these charges?
Yes.
And do you understand that if you plead not guilty or remain silent or refuse to enter a plea at all, that the state is required to prove the charges against you during a jury trial?
Yes.
Have you had an opportunity to review all of your rights with your attorney today?
Yes, I have.
And have you had enough time to speak with your lawyer about the charges in today's indictment, including the facts and circumstances of those charges?
Yes, I have.
Would you like more time to speak with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes, I am.
Okay. Attorney, you have to remind me again.
Rosenhoover.
Rosenhoover. From Carroll County?
Yes.
Okay. Do you waive formal reading of the indictment for purposes of today's plea?
I do.
And do you waive any and all defects in that indictment for today's plea as well?
Yes, I do.
Okay. Mr. Johnson, do you understand the minimum and maximum sentence? The minimum and maximum sentence for each charge today is for burglary in the second degree, 1 to 5 years imprisonment, and for possession of tools for commission of a crime as well, 1 to 5 years.
Yes.
Do you understand that today you're entering a negotiated plea, which means that the state will recommend the following sentence to the court, and that's a total of 3 years probation, and additionally to stay away from 2770 Donnelly Hollowell Parkway?
Yes, I do.
Do you understand that the court is not required to accept the state's recommended sentence today?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence for each charge today?
Yes.
Do you understand that if there are multiple charges to which you're pleading guilty today, that the court also has the right to run those consecutively, which means one after the other?
Yes, I do.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea that you're expecting today, that you have the right to withdraw your plea of guilty?
Yes, I do.
You understand that if you're currently on probation or parole, that probation or parole may be revoked based on you entering a guilty plea today?
Yes, I do.
And do you understand that if you are placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit that includes municipal, county, state, or federal?
Yes, I do.
Do you understand that if you're on probation, you must follow all of these special conditions of that probation?
Yes.
Do you understand that if you fail to follow all of those special conditions, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, I do.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes, I am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, I do.
Do you understand that doing so will result in new criminal charges for which you will face a sentence between 1 and 10 years?
Yes, I do.
Do Do you understand that by entering a guilty plea today, you are waiving any and all defenses, including any mental health defenses?
Yes, I do.
Do you understand that by pleading guilty, you are waiving the following rights? Those include a right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to assistance of counsel, the right to the presumption of innocence, as well as the right to appeal of the, if convicted of charges at a jury trial.
Yes, I do.
So is it your decision to waive these rights, which means to not use them, and enter a guilty plea today?
Yes, it is.
Has anyone forced, threatened, or promised you anything to get you to enter into today's guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of burglary in the second degree and possession of tools for commission of a crime in Indictment 21 SC 179818?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, it is.
And do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, I do.
Do you understand that for a felony charge, you only have 4 years from today to file a document that's called a habeas corpus petition to challenge the voluntariness of this guilty plea?
Yes.
At this time, Your Honor, the state will give a factual basis for the plea today.
Okay.
On October 20th, 2021, at roughly about 5 a.m., EMC Security, which is a security monitoring company, noted an audible alarm coming from the premises of Falcon Auto Repair, which is at 2770 Donnelly Hollowell Parkway. The EMC Security called 911, which dispatched an officer, Anthony Anderson of APD, to that location. Mr. Anderson arrived on the scene shortly thereafter and came face to face with the defendant, Mr. Johnson, who he would identify later. But at the time, Mr. Johnson was coming out of the business where the alarm was going off and carrying a large bulky bag. When asked, Johnson stated that he lived at the location, but he worked elsewhere. During that time, a conversation started where he was stalled when the officer eventually detained him after talking to him and questioning why he was there. On his person and in his bag was located a flashlight, cutters, knives, and rubber gloves. A key to a BMW was also found on his person. The key was placed, left at the location. Essentially, Your Honor, he was found at the location with tools that were commonly used for a burglar shortly after the alarm went off. And that's the basis of today's plea. The state would just recommend that Your Honor accept the 3 years probation recommended with the stay away from the location and defer to probation for a criminal reading.
Okay. Ms. Tucson, do you have any felony criminal history for Mr. Johnson?
Just one case. It was a first offender. And it expired. It was Henry County. And it was for, looks like it was theft by shoplifting. It ended in 2016.
Okay, thank you. Ms. Rosenberg.
We would just ask that the court accepts the negotiated agreement. I know Mr. Johnson is looking forward to putting this behind him.
Okay. Mr. Johnson, are you working these days?
Part-time.
What do you do part-time?
Work at Tip Top Poultry, secure plant.
Okay. How'd you get the job?
Applied and just went.
Good for you.
Yeah.
All right. Falcon Auto Repair, did you ever work there or that was just a spot?
No, it was just somewhere that I would crash in the cars that was in front of them. I would sleep sometimes so I wouldn't be late from work. I worked like, I would have to walk because my car wasn't running, but I stayed like 6-7 miles from the actual job location. So
where were you working in October of 2021?
UPS,
okay.
United Parcel Services off Fulton and Bolton.
What happened to that job?
I just got hired. Had probably been working there probably about 2.5 weeks and got off of work early, working 14 hours.
Oh, so you lost that job because of this arrest?
Yes.
Understood.
Yes, I did.
Okay, got it. There's no restitution because it sounds like nothing was taken, other than this BMW key, which was left there.
Exactly.
Okay, got it. All right. Mr. Johnson, do you have any questions about any of the things we've been talking about?
I do have a question, but not about anything that we was talking about.
Do you want to save it till we're done, or do you want to ask it now?
I can't. I mean, I could wait till we're done.
Okay, hold the thought.
Okay.
Well, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea, but you're doing it because you've decided it's the right way forward for you. Is that correct?
Yes, sir.
And then I really can't say knowing yet, because knowing means you don't have any questions, but you've got a question. Tell me your question.
My question is, when I was arrested, 2 of my billfolds were detained by the officer that arrested me.
Mhm.
And when I was released, once I bonded out, I went to get my property. Property wasn't there. Now, I called, talked to a sergeant. She told me she would check into it. Maybe the belongings that were taken from me was put in for evidence, which was a cell phone and 2 billfolds.
Sure.
$100 billfold and a Michael Kors billfold.
Okay.
Now, I don't really care about the wallets. It's just the contents that was inside. All my credentials, everything that I.
And those are hard to replace. It's a real hassle. What Ms. Rosenhoover can do after this plea is figure out, is there something in evidence in connection? Your arrest has a unique number to it. And Ms. Rosenhoover can figure out from the Atlanta Police Department, is there something in evidence in connection with that case number? And if the answer is yes, she can get me to sign an order, which I will, that would release that evidence to you, because it's not, sometimes people get arrested with drugs, you don't get that back. They get arrested with a gun, you don't get that back. But your billfold, your phone, those aren't part of some crime you were committing. And so those should be returned if they're still there. Not saying they are, but we can certainly make that inquiry, and Ms. Rosenhoover can help you with that.
So one more question, if my possessions are not there, where do I go from there?
So that's a good discussion for you to have with Ms. Rosenhoover. I'm not in a position to provide you with relief.
Okay.
You will not be the first person who will say, hey, I had a wallet, I got arrested, where's my wallet? And the answer is, hey, it went away. And that's not to make you feel better. It's an unfortunate side effect of how that it should be either with your property when you get booked in, or it's in evidence somewhere and you should be able to get it back. Okay. I hope for you that's how it plays out. And your case is new enough that it shouldn't have been destroyed. Eventually, judges sign orders saying you can destroy all that evidence because it's been there for 5 years and no one did anything with it.
Yeah.
But that's not your case. It's not that old. Any other questions?
No, sir.
All right, then I find that your plea is knowing as well. I'm sentencing you pursuant to the Probation Options Management Act, so that if you have a small violation of probation, and I hope you have none, but if it's small, you and probation will work it out. If it's big, you're caught back at that Falcon Auto Parts, or you get arrested again, that'll come back to me.
Yes, sir.
Mr. Johnson, do you authorize my staff to sign the indictment on your behalf indicating your guilty plea?
I do.
And Ms. Rosenhoover, can we sign for you?
Yes.
And Mr. Hand?
Yes, Your Honor.
Great, we'll do that. I'm going to sentence you, Mr. Johnson, on count 1 to 3 years probation. Count 2, 3 years probation. Those will run concurrently with each other at the same time. Special condition of your probation will be that you stay away from the Falcon Auto Repair business at 2770 Donnelly Hollowell Parkway. You take care of that. You should be able to do the things you want to do.
Yes, sir.
All right. Ms. Tucson, what information do you need from Mr. Johnson? Or do you want to get a number from him and you can give him a call?
That would be good. A phone number. Do you live in Fulton County?
Yes, I do.
Oh, okay. Then you will be reporting here in Fulton. What's your phone number?
My phone number is 678-592-3740. That is a secondary emergency number. My direct line is not on right now. So that's a number that you will be able to get in contact with me.
678-592-3740. Okay, where can I call you like right now after court?
It will have to be my Wi-Fi line, and that is, hold one moment. I got you right here. Hold on. It is 770-648-5916.
Okay. If you don't answer, I'll leave a message and I will give you reporting instructions, but you will report here to Fulton County.
Yes, ma'am.
Okay.
Stay in the Wi-Fi area until she calls.
Yes.
All right. I think we're done. Thank you.
Thank you, Judge. Here's my number, so you can call me next week about the property question.
Thank you so much.
You're welcome.
I appreciate it. Thank you, Judge.
You're welcome. Good luck with everything.
All right.
Next up,
Judge, am I ready to go on a non-negotiated plea for Kenneth Brantley, position 20?
all right, is that our last custodial one?
Yes.
Let's do that.
I think probation.
Ms. Wood, are we
Okay.
still going with Watson or no?
Yes, he signed up.
We're just doing it after? Okay, that makes sense.
Yeah, just so I can plan, we have how many more pleas?
Judge, I have one more plea after Mr. Brantley, it's Mr. Watson, and then I need to make an announcement on Braylon Brown.
On Braylon Brown, because we have, I see 3 people sitting back there. Are there folks we can get out of here?
I'm not sure who the gentleman is on the back, so if we could inquire.
Who? Got it. Tyler Thomas, he did have court, but he did not have lawyers. His lawyer has asked for a continuance. So Mr. Thomas was brought over. I didn't even get to see him because his lawyer said, Judge, we can't go forward on this calendar because of some issues on the defense side. So Mr. Thomas is already gone. He didn't pop out. So if you're here for him, you may want to call his lawyers. That can let you know what's coming next. Okay. Thanks for being here. And you, sir, are here for what?
That's Braylon Brown, Judge.
Oh, that's Mr. Brown. Okay. I thought Mr. Brown was in custody.
He was, Judge, he bonded out the 21st.
Holy smokes. All right. Well, congratulations, Mr. Brown. You're in jail forever. All right. So just so we're clear, we are taking a non-negotiated plea with Mr. Brantley, who's on the calendar as Bradley and is standing in front of me. Then we've got Mr. Watson. We'll do that plea. And then we need to have an announcement about Mr. Brown, or it's someone else.
Well, I was gonna make the announcement about Mr. Brown now.
Let's do that. No, since it's just an announcement, we can take care of that.
Yes, so that is not gonna work out today.
Okay.
I had the pleasure of speaking with Mr. Brown's mother in person for the first time today. We're gonna need some more time on this case and probably with her in support, Judge.
Okay. Well, we've got Mr. Brown down for week 2.
Yes.
Not week 1.
I did want to confirm that.
Yep.
So, and then I did talk to Mr. Hand before I made this announcement. So if we could keep him down on October 17th, I would appreciate it.
Oh, we will. We will. Mr. Brown's case is old. I'm glad he's not in jail anymore for his sake. I don't know about the victim's sake in position 7, but Mr. Brown's case will be at the tippy top of the list for the October 17th trial calendar.
Thank you, Judge.
Okay. Mr. Brown, any questions about stuff? You know the conditions of your bond? You'll be able to comply with them? Hope so. Good. So Ms. Wood will be in touch with you about what's going on. But I expect to see you the morning of October 17th as a Monday in here, ready to go to trial if you haven't otherwise worked out your cases, because the state's ready to go. And you're entitled to a trial, as is the alleged victim in your case. And that's going to be my goal that week. All right. You good? You don't have to thank me. Just show up. All right. So let's focus then on Mr. Brantley. This is position 20. The case is 22 SC 180173. And we've got the lawyers we need. Ms. Wood is standing by Mr. Brantley's side. Mr. Hand is ready to go. Mr. Brantley, in a moment, Mr. Hand's going to put you under oath. Once you're under oath, answer his questions and mine truthfully. And please let Ms. Wood know if you've got any questions of your own so we can answer those. All right?
Yes, sir.
Great. Mr. Hand.
Yes, Your Honor. First, I'd like to note, Your Honor, that I did share the Zoom information with the victim in this case, Mr. Anthony McElhaney. I'm not sure if you can see him or if he's on.
No, we had a Joy Collins on for a while that I didn't recognize, but he is not. You had a victim advocate named Wayne Williams, interesting, who was on for a while, but right now there is no one else on.
Is it possible, because I know he wanted to be present, is it possible I can try to get him?
Of course.
On? Okay.
Yeah. You don't have a sidekick here to help you out right now, do you?
I don't.
No, okay.
I'm not as fortunate as That's what.
Yeah, she's juggling a lot right now. Can you send him a text? What's the best way? Okay.
Text/call. He seems to think he's on.
Oh, he might be on the YouTube.
He could be watching the YouTube. There's a YouTube feed. We can't hear him, but he can hear us.
The calendar Zoom that
Okay, he is welcome to join the Zoom.
which I assume is the same as the 9 a.m.
But if you, it is, but if you sent literally the calendar, I think has some link that people can go to, which is our website, and then you find McBurney and you click there and you're watching on YouTube. It's non-interactive. It's actually very interactive, I've been told. You can leave comments. Like, nice tie.
Then it's user error, it's me.
Okay. Mr. Watson, you're Reginald Watson, is that right? Good. I'm just finding you on the calendar. We will be ready to go once we take Mr. Brantley's plea.
Okay, you should be using the new link I just sent.
While we're waiting, I'm curious just how it played out. How was Mr. Johnson's case not a plea a long time ago? He seemed so ready to plea. Was there not an offer that was conducive to a plea, or trying to figure out how to structure things so something like that happens on the status calendar and not on the trial calendar?
So Judge, when Ms. Patel left, he was on my short list of things that could be worked out, and we could not find him.
Okay.
So
it was a linkage issue.
yes.
Got it.
correct.
Well, he resurfaced.
Goodness.
So if you have reached out to him, we're going to go forward and he can dial in if he does.
Yeah, sure.
Has he confirmed that he received your communication?
He confirmed, I said I resent you the link, he said, okay.
Okay, as long as he said, okay, I'm going to ask that we go forward and he can plug in as he's able.
Yes, Your Honor. And I'm not sure if he says he just joined. I'm not sure if he wants to say anything.
I will certainly hear from him. He is not on our Zoom yet, but again, we're going to press on and
Just so we're proceeding.
great. All right. So when you're ready.
Mr. Bradley, please raise your right hand for me, please. Do you swear or affirm that the statements and testimony that you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can lower. Please state your true, full, and correct name for the court.
My name is Kenneth Wayne Bradley,
Can you spell your last name?
Brantley.
So you even say it like Bradley,
I know how to put
the way you say it, but it's your name and we got it, and it will reflect on all the paperwork. It's going to say Bradley, but we'll have also known as Brantley to make sure there's not confusion out in the big wide world. Okay.
Sir.
Are you currently at the time taking or under the influence of any medicine, drugs, or alcohol?
No, sir.
And is there any medication that you would normally take that you have not taken or been given today?
Yes, sir.
What medication is that?
Remeron, Cytmed, Seroquel.
And you not having taken that medication today, does that affect your ability to understand what's happening in today's proceeding?
No, sir.
Okay. How old are you, Mr. Bradley?
55,
And how far have you gone in school?
8th grade.
Can you read, write, and understand the English language?
No, sir.
Can you read the English language?
Third grade, probably. Yes, sir.
Okay, and can you write in English?
Yes, sir.
Okay, and you understand our conversation?
Yes,
in
sir.
English right now? Okay.
Mr. Bradley, I'm going to interject a little bit here on two topics. You mentioned that you have in the past taken Remerol.
No, I take it now at the jail.
You take it now at the jail. When do you get it? Morning or night?
Night.
Did you get it last night?
Yes, sir.
Okay, so you're on cycle. You didn't skip a dosage to be here today.
Yes, sir.
And that's the only medication you take at the jail.
Yes, sir.
Okay. In terms of your reading and writing, if I handed you the Atlanta Journal-Constitution, would you be able to read what's in the AJC?
Different word, probably.
Okay, and I'm only asking, there's nothing wrong. Your answer is the honest truth, whatever it is. Some words you'd read, some you wouldn't. I just wanted to make sure you'll be able to follow today. What we'll be doing is spoken word. We'll be communicating just like we've been so far. You're fine with spoken English.
Yes, sir.
Okay. If we use a term, a phrase, a word that you don't understand, please let Ms. Wood know so we can say it in a different way.
Yes, sir.
Thank you.
Thank you, Judge. Do you understand that you have been charged with the following offenses today? Those are aggravated assault, possession of firearm or knife during commission of a felony, and possession of firearm by convicted felon in indictment 22 SC 180178.
Yes, sir.
Do you understand that if you plead not guilty or remain silent or refuse to enter a plea at all, that the state is required to prove those charges against you at a jury trial?
Yes, sir.
You do understand you have the right to plead guilty or not guilty?
Yes, sir.
Okay. Have you had an opportunity to review your rights with your attorney today?
Yes, sir.
Do you need more time to speak with your lawyer about the charges in today's indictment, including the facts and circumstances of those charges?
No, sir.
Would you like more time to speak with your lawyer about the charges and the indictment?
No, sir.
Are you satisfied with your lawyer services?
Yes, sir.
Attorney Wood, would you waive a formal reading of the indictment for purposes of today's plea?
So waived.
And do you waive any and all defects in the indictment for today's plea as well?
So waived for purposes of this hearing.
Mr. Bradley, do you understand that the minimum and maximum sentence for each charge to which you're pleading guilty today are for aggravated assault, 1 to 20 years imprisonment, for possession of firearm during the commission of a felony, 5 years consecutive to other counts, and for possession of firearm by convicted felon, 1 to 10 years?
Yes, sir.
And do you understand that you're entering a non-negotiated plea today? And the state may recommend a sentence to the court even without your having agreed to it in advance?
Yes, sir.
Are you aware that the state's offer is 10 years to serve 5 years?
Yes, sir.
And that would include a stay away from the victim, Anthony McElhaney. That last name is spelled McElhaney, and his home address at 585 McDaniel Street, Atlanta.
What's happening with the other 5 years of the sentence? 10 serve 5, balance probated, balance suspended.
I'm sorry, Your Honor. I said 10, I meant 15, 5 being consecutive on the back of the 10 for the aggravated assault.
Okay, but if I break down the pieces, 5 years to serve,
Yes,
followed by probation or a suspended sentence?
probation, Your Honor.
Okay, and are the 5 that have to run consecutive for that gun charge, are those probated or suspended?
Probate,
Okay, so it's 5 years in custody and 10 years on probation.
yes, Your Honor.
So effectively 15 to serve 5.
Yes, Your Honor.
Okay,
My apologies. That should have been the,
that's all right. I just want to make sure I'm understanding the state's recommendation.
yes, Your Honor. Mr. Brantley, have you discussed this offer with your attorney?
Yes, sir.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence that is recommended by the state upon up to the maximum for each charge.
Yes, sir.
Do you understand that if you enter a non-negotiated plea, you do not have a right to withdraw your plea once the court enters a sentence?
Yes, sir.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, sir.
Do you understand that if you are currently on probation or parole, that probation or parole may be revoked based on you entering this guilty plea today?
Yes, sir.
Do you understand that if you are placed on a probation of any kind, you cannot violate any criminal laws of any governmental unit? That includes municipal, county, state, or federal.
Yes, sir.
Do you understand that if you are on probation, you must follow all of the special conditions of your probation?
Yes, sir.
Do you understand that if you fail to follow all of the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Are you a United States citizen?
Yes, sir.
And do you understand that by pleading guilty to a felony, you also may not receive, possess, or transport a firearm?
Yes, sir.
Do you understand that doing so will result in new criminal charges against you?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? Those include the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial.
Yes.
Is it your decision to waive these rights, which means to not use them and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of aggravated assault, possession of firearm during commission of a felony, and possession of firearm by convicted felon?
Guilty.
And those are indictment 22 SC 180173 for the record. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
And do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a document that's called a habeas corpus petition?
Yes.
And do you understand that for a felony charge, you only have 4 years from today to file this habeas corpus petition?
Yes.
Okay, at this time, Your Honor, the state will give a factual basis for the plea as well as argument for its recommendation, Your Honor.
Okay.
On October 31st of 2021, so last year, Your Honor, due to a 911 call, Officer Gover of APD responded to a person shot at 585 McDaniel Street. The victim is Mr. Anthony McElhaney, who stated that he was walking out of his apartment to get delivery food that he had just picked up when he was confronted by the defendant, Mr. Kenneth Brantley, who is his neighbor. Mr. Brantley aimed a Glock 9mm handgun and discharged it at his foot multiple times.
So I'm sorry, there was something happening in court. Mr. McElhaney and Mr. Brantley are or were neighbors.
Were, Your Honor.
So not strangers.
Right.
Got it. Okay. Important piece.
And they have had different interactions for about 2 years during which they were neighbors, Your Honor.
Okay.
Never positive interactions, but interactions.
Doesn't sound like it.
Upon arriving on the scene, the officer knocked on the front door of Mr. McElhaney, and that's when he didn't immediately answer. And that was because Mr. McElhaney, after the incident occurred, ran into his house and ran to the 3rd floor of his townhome. These are all townhomes, because he was afraid that the defendant would then start shooting through the 1st floor. But he eventually made it down to the door and spoke with the officer and told him what was happening. At that time, the defendant had went back to his apartment The victim didn't know it until he heard music coming from Mr. Brantley's unit. He told the officer as well as the emergency personnel who were entering the apartment to treat him, which was a gunshot wound to his leg. There were 2 wounds, the entry and exit wound on his, I said leg, I apologize, his foot. He told them he heard the music and that Mr. Brantley was still over there. At that time, the officer walked over to Mr. Brantley's apartment and observed the blinds moving to confirm that someone was inside the unit. Sorry, I lost my place, Your Honor, 1 second. He initially would not open the door to his unit, Your Honor, but then his family arrived on scene and were able to call him and get him to open the door. At that point, he dropped the handgun that he had once the door opened, and he was taken into custody. Later, a 9mm shell casing was found that matched the handgun that Mr. Brantley had in his possession at the scene, further corroborating that that was the handgun used to shoot Mr. McElhaney in the foot. After that incident, Mr. McElhaney went to the hospital, was treated. For several months, he could not walk up and down the stairs in his townhome. It also affected his ability to work. And the impact on him was just severe, his neighbor having shot him in the foot. Your Honor, these aren't in the warrants, but from my conversation with Mr. McElhaney, there has been a history of bad interactions between him and his neighbor, particularly as it relates to Mr. McElhaney's sexual orientation. And because of that, he felt this led up to that culminating event. And as a result, the state is requesting the recommended sentence that we gave the court. The state will also note that there are at least 5 felony convictions that exist in the defendant's criminal history.
Okay.
Nothing further.
All right, thank you. Ms. Tucson, what do you have in terms of criminal history for Mr. Brantley?
As far as right now goes, there is no active probation. And it looks like there are several priors from what I can count on here.
Tell me what you've got. So I'm in the dark. I know there are maybe 5, but are they for shoplifting or are they for shooting someone else? What do they look like in terms of charges?
Looks like there's 15 total. The most recent one ended in 2006, it looks like. I'm sorry, I had to go to page 2. Robbery. There's multiple charges for robbery, possession of opiates, theft by receiving stolen property.
That's all one case, or you're sharing with me different
They're
convictions?
different cases. There is several in Fulton, DeKalb. I don't see anything as far as shootings.
But there are multiple robberies.
Robberies, entering vehicle, theft by taking.
And what's the most recent?
Most recent. Out of Henry County, 2013. Obstruction of a law officer misdemeanor and a possession of controlled substance, sell and distribute.
Okay. Thank you. And nothing is active?
Nothing's active. No
Got
probation.
it. Ms. Wood?
Thank you, Judge. Judge, Mr. Brantley is 55 years old. He's a lifelong resident of Atlanta. He has family here. I've spoken to a sister, Karen, and a niece. Get her name. It's not right in front of me. Nicole, Judge. I'm not sure if they're watching on YouTube. They were informed of that option, but their work schedules may not have permitted them to stick around. It's my belief and opinion about this case that the charges stem from some mental health concerns that is listed in the police report when the family was called to help assist with the matter. They've told me that. They told me the same thing. It's my belief Mr. Brantley was off of his medication at the time. His sister has indicated to me that since he doesn't have a spouse, he doesn't have children, it's hard for her to take time away from her own family to help monitor him. I've been working with Ms. Patterson on this case. We thought that since that was the case with his family, that it would be appropriate for him to have a program to go into upon release. We thought he would be perfect for BHTC. This is one of the ones I was speaking about this morning where they rejected the application without doing an interview. So Ms. Patterson found a different program. It is called Metro Community Ministries. And the only aspect of that she has not secured is where exactly they will be housing him. But I do know that is a structured program that could offer a long-term plan, Judge, for Mr. Brantley if he were to be released out of custody. He has indicated to me that he worked previously as a dog groomer. And I do know that he also received some benefits from the government. So that's another reason Metro Community Ministries was eager to accept him, because he has a housing voucher. Again, Judge, I do believe this stems from a mental health situation, and other than bad blood between two neighbors. He has been in custody for 327 days at this time. He was officially booked in November 1st, 2021. So we would ask for credit for that. We are asking for the court to consider a sentence of, and I'll start by the count. So for the aggravated assault, 5 years probation to serve the first year in custody. For the possession of firearm or knife during commission of a felony, we're asking for 5 years to be served on probation consecutive to count one. And then possession of firearm by convicted felon, 5 years to be served on probation concurrent to those two, for a total of 10 years to serve the first in custody judge, with the special condition that he enter into and successfully abide by the conditions of the Metro Community Ministries program. And we would ask for credit for the 327 days that he's been in custody. He tells me he has no issue with a stay away. And of course, he won't be living at that location. So none of that should be a problem, Judge.
Okay. I'm curious about the sentence. Instead of saying 5 to serve 1, you're saying 5 years probation with the first year in custody. Is that a
5 serve 1?
Okay. All right. I just wasn't sure if that was a new probation condition. Haha, a year in custody.
No, Judge, I'm just trying to read my terrible handwriting.
Okay.
That's what I meant.
So 5 serve 1 balance probated on the aggravated assault and the firearm by felon, and then a +5 probated for the one that has to be +5.
Yes, Judge.
Okay. Mr. Brantley, that house or townhome you had next door to Mr. McElhaney, you don't have that property anymore?
No, sir.
Were you renting it?
Rent it,
Okay. And what kind of work were you doing at the time?
grooming dog, bathing dogs.
Okay. Was that through like a PetSmart or through a boutique place, or you did it personally?
Boutique place.
Okay. All right. Ms. Wood, the facts of this case surprised me less that BHTC said no without an interview. Your other case, if there's no interview, we should engage them. I think I understand why they said no thank you to this one, just based on what I've heard about the allegations.
Yes,
really, not just the allegations, the facts. Not that Mr. Brantley wouldn't benefit from BHTC, but I think this isn't just the way this case played out. It's not something that they would bring into the fold.
Understood, Judge.
All right, Mr. Brantley, do you have any questions about any of the things we've been talking about?
No, sir.
All right. I find that there's a factual basis for your plea. I don't know all that was going on between you and Mr. McElhaney. I suspect there was some back and forth and it wasn't just you, but either way, the way this played out in the end is safe for no one. You're fortunate and Mr. McElhaney is fortunate that his injury was as minor as it was. I've had lots of cases where someone's shot in the leg, but it hits, I understand it was his foot, but that's right next to the leg, but it hits an artery and they bleed out. And then all of a sudden, we're not talking about aggravated assault, we're talking about murder. And we're not talking about 3 years or 5 years, but is it life or life without parole? And you've got family that wants you to be out and about. So it's just not something to play around with. And you're going to need to figure out a good routine so you stay on the medication that might keep you out of a situation like this. I do find there's a factual basis. I also find that your plea is knowing and voluntary. I appreciate that you're under medication, but you've told me that 1, you're getting it on a regular basis, and 2, it does not interfere with your ability to understand. You've also told me that you understand our discussions just fine. Even though you might not be able to read a complicated book, this kind of discussion is something that did not escape your understanding. Is that a fair statement?
Yes, sir.
Then I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act, which simply means that while you're on probation, which you will be for part of your sentence, if you have a small problem, you and probation will fix that. If it's a big problem, you get arrested again, or Mr. McElhaney shows a picture to the DA's office that you're banging on his door, that kind of thing will come back to me and you and I will work through it. Okay? All right. I am going to sentence you as follows. On count 1, I think the appropriate sentence is 3 years to serve. I think count 3 should also be 3 years to serve. Those would run concurrently with each other at the same time. Count 2 has to be 5 years and has to be consecutive, and I'll probate that. So I think the right sentence, given your criminal history, given the seriousness of what happened here, not just waving a gun at someone, but actually firing the gun and hitting him, a sentence of 8 years to serve 3 years with a balance on probation is the right sentence. You'll get credit for all the time you've been in. So you have already done a year of the 3 if you accept this sentence, which you don't have to. You have reserved or preserved your final plea rights. So you're going to be able to say, you know what, Judge? I want to go to trial. I want the jury to hear what happened. I want them to hear from Mr. McElhaney. I want them to hear from the doctor who talks about the hole in his foot and the difficulties he had from his injuries. And we can do that. You're actually on the short list for going to trial next week. But you also could decide that this outcome, which isn't quite as favorable as your lawyer asked for, but it's a little less severe than what the district attorney's office asked for now, and they might ask for more after trial. You and Ms. Wood should talk for a minute about whether that's something that works for you. If you say, no, I don't want it, the jury will never know that you tried to enter a guilty plea. That's going to remain away from them, and you'd go to trial presumed innocent, and the state would have to prove your guilt. But if you accept it, then you've got some certainty as to how this is all going to play out, because this sentence that I am seeking to impose here reflects you accepting responsibility, coming in and say, I did it, and not putting Mr. McElhaney through the trauma of having to come in here and talk about it again. So I'm going to ask you and Ms. Wood to talk a little bit, and then you'll come back out here. She'll let me know what it is you want to do. Okay? All right. While they're talking, why don't we pivot to the other plea we've got, Mr. Watson. Ms. Rosenhoover, were you in a position to take Mr. Watson's plea?
I wasn't prepared to, Judge, but I'm happy to. Let me just look over what the recommendation was.
Is this a negotiated plea, Mr. Hand?
Yes, Your Honor, but I want to make sure I have the terms.
Okay. Let's make sure you and Ms. Rosenhoover are on the same page. I think Mr. Watson will know, because if you say a different number, he's going to say, what? Mr. Watson, would it be easier for you to take the plea seated? You do not have to stand at the podium. Okay, why don't you take a seat right there? So Mr. Walker is dead. Okay, well. I'm looking to see if it says where he was, if he was on the mental health floor or what his situation. Okay. We're going to stick with Mr. Brantley because he and Ms. Wood are back out here. Mr. Brantley, did you have a chance to speak with Ms. Wood about your options?
Yes, sir.
Okay. Ms. Wood, is Mr. Brantley going forward with his plea or withdrawing his plea?
We're going for it, Judge.
Okay. Mr. Brantley, that's going to be your sentence. Ms. Tucson, because Mr. Brantley will stay in custody for a bit more, do you need information from him now, or will that be gathered when he's wrapping up his sentence?
Usually, if he's going to be spending time in custody, I'll still need to submit it to, the field office. If there's any addresses or anything, Miss Wood, if you could send it to me, and then upon, release, he'll be given reporting instructions from the institution where he'll be housed.
Great. So what we'll do, Mr. Brantley, is Ms. Wood at a later time will get all your contact information to probation so that when you are being released, and probation is also parole now, and you're parole eligible in this case. So you'll get out whenever you do, but probation and parole will be ready to plug in with you then.
Okay.
All right. I wish you luck with things.
All right, thank you, sir.
Keep taking your medication.
You're welcome.
All right. After all that, Mr. Watson, you are back in the capable hands of Ms. Wood. And we are going to move forward, assuming Mr. Hand is ready.
Yes, Your Honor.
All right. Ms. Rivers, you ready? Can you handle one more plea?
Yes, I'm ready.
Good. So am I. I'm also hungry.
Myself as well.
Yeah, everyone is. Let's make this our last plea of the day. I gotta find Mr. Watson again. There he is, number 29. This is 22 SC 181299. Forgot to ask Mr. Brantley do you waive Mr. Brantley's right to sign that? I mean, you authorize us to sign your name and Mr. Brantley's and Mr. Hand's. Great. All right. Mr. Watson is 22 SC 181299. His lawyer, Ms. Wood, is here in court with him. Mr. Hand, the prosecutor, is here. Mr. Watson, you've now watched a bunch of pleas, so you know what's going to happen. You'll be put under oath, and let's take it from there, okay? Sure. All right.
Raise your hand for me, Ms. Watt. Perfect, thank you. Do you swear or affirm that the statements or testimony that you shall give today in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Please state your true, full, and correct name for the court.
Reginald Kilgore.
And are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you would normally take that you have not taken or been given today?
No, sir.
And how old are you, Mr. Watson?
57 years old.
How far in school have you gone?
Went to the 12th grade.
Did you graduate?
No.
Okay. How is it fair to state that you can read, write, and understand the English language?
Yes, sir.
And do you understand that you have been charged with the following charges in today's case? 21 SC 181299. Those are aggravated assault and simple battery.
Yes, sir.
Do you understand that you have the right to plead guilty or not guilty to these charges?
Yes, sir.
Do you understand that if you plead not guilty or remain silent or don't enter a plea at all, that the state is required to prove the charges against you at a jury trial?
Yes, sir.
Have you had an opportunity to review all of your rights with your attorney today?
Yes, sir.
Have you had enough time to speak with your lawyer about all of the charges in today's indictment, including all the facts and circumstances of those charges?
Yes, sir.
Would you like more time to speak with your lawyer?
No, sir. I'm ready.
All right. Are you satisfied with your lawyer's services?
Yes, sir.
Okay. Ms. Wood, Attorney Wood, would you waive a formal reading of the indictment for purposes of today's plea?
So waived.
And do you waive any and all defects in the indictment for purposes of the plea as well?
So waived.
Okay. Mr. Watson, do you understand that the minimum and maximum sentence for each charge today is 1 to 20 years for aggravated assault? That's 20 years imprisonment and 12 months for simple battery.
Yes, sir.
Do you understand that today you're entering a negotiated plea, which means that the state will recommend the following sentence to the court? That is that charge 1, aggravated assault, is downgraded to disorderly conduct, OCGA 16-1139. And for simple battery, and the recommended sentence for that is 12 months probation
Yes, sir.
and a stay away from the victim in this case, whose name is Bobby Mosley.
Yes, sir.
And for charge 2, simple battery, also 12 months probation.
Yes, sir.
So are those concurrent or consecutive?
Concurrent, Your Honor.
Okay.
Do you understand that the court is not required to accept the state's recommended sentence today?
Yes, sir.
Do you understand that the court has the right to sentence you to the maximum possible amount for each charge today?
Yes, sir.
Do you understand that if there are multiple charges to which you are pleading guilty today, which there are 2, that the court also has the right to run those consecutively, which means one after the other?
Yes, sir.
Do you understand that if the court decides to enter a sentence that differs from the negotiated plea that you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, sir.
Do you understand that if you are placed on probation of any kind, which the state is recommending, you cannot violate any criminal laws of any governmental unit, whether it's municipal, county, state, or federal?
Yes, sir.
Do you understand that if you are on probation, you must follow all special conditions of that probation?
Yes, sir.
Do you understand that if you fail to follow all of the special conditions of the probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, sir.
Do you understand that by pleading guilty, you're giving up the following rights? Those include the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, as well as the right to appeal if convicted of these charges at a jury trial.
Yes, sir.
Is it your decision to waive these rights, which means to not use them and enter a guilty plea today?
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No, sir.
Is it your decision to enter into a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charges in indictment 22 SC 181299, charge 1, amended to disorderly conduct, and charge 2, simple battery?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a document that's called a habeas corpus petition?
Yes, sir.
Do you understand that for a misdemeanor charge, you only have 12 months from today to file that habeas corpus petition?
Yes, sir.
Okay. And Your Honor, at this time, I'll give a factual basis for the plea. On April 21st of 2021, Officer White of APD was dispatched to 1754 Richmond Circle in reference to a male stating that he was assaulted. That male was the victim, Mr. Bobby Mosley. He advised that he had just left the Citgo gas station after taking $20 out of the ATM. And at that time, the defendant pulled up in a maroon Lexus where he was standing. And he's described as his supplier of crack cocaine, Your Honor.
Mr. Mosley says Mr. Watson is the supplier, or Mr. Mosley says, I am Mr. Watson's supplier?
Mr. Watson is the supplier.
Okay.
And he had owed Mr. Watson some money from prior interactions regarding the drugs, Your Honor. At that time, Mr. Watson demanded his money. The victim only had $20 at the time that he had just received from the ATM, obtained from the ATM, and so he gave him that, but it wasn't enough. He stated that he proceeded to punch him multiple times, and then he reached and obtained a sword from his car, and he raised it up at him, demanding the money that he owed him and threatening to kill him. He then retreated and left the location. And that's when Mr. Mosley called 911.
Okay.
That is the factual basis. We would just ask that Your Honor accept the amended charge for count 1 and the recommended 12 months probation and stay away from Mr. Bobby Mosley. Nothing further from the state.
Okay. Do you have anything on criminal history, or should I get that from Ms. Tucson?
Can you get it from Mr. Tucson? Yeah.
Sure. Ms. Tucson, what do you have for criminal history for Mr. Watson, the swordsman?
Looks like nothing current, older Fulton County cases, back in the 80s and 90s. So it's been a very long time. Looks like possession of cocaine, a burglary, and a misdemeanor simple battery.
What's the most recent case?
Most recent possession of cocaine, July 22nd, 1994, Z63840 is a case number.
Got it. Thank you.
No problem.
Ms. Wood.
Thank you, Judge. First, I want to say that Mr. Watson and I dispute some of the facts as alleged by Mr. Hand. However,
Is it the sword part or the he's my dealer part, or both those?
a little bit of both. Judge.
Okay.
However, that disorderly conduct was just too appealing. So Mr. Watson, I believe, is very comfortable with moving forward with this offer. He's 57. He lives in Ellenwood. He's a lifelong Atlanta resident. His whole family lives here. He has 2 adult sons, 12th grade education. He's currently disabled, so he does receive benefits from the government. And yes, as we were speaking, I believe that last 2003 arrest was for a driving offense. So we would just ask that you accept the state's recommendation, Judge.
Okay. How long have you been disabled, Mr. Watson?
Since 2015.
What were you doing for work before then?
I was I did a couple of different jobs. I was roofing, but I was working for this store that we had the contract for all the Kmart and Sears in Atlanta, and in 23 states. We would strip the floors and wax them. So I was actually the floor tech.
Got it. Serious floor tech. That's a lot of real estate until there were no more Searses or Kmarts.
There they go.
Yeah, there they go. Is Bobby Mosley someone you know?
No, not really. You know what I'm saying? I've seen him a couple of times.
I mean, you recognize him if you saw him, but he wasn't someone you were close to.
Yeah, I recognize him, but I won't, you know what I'm saying, we were friends or nothing like that.
Do you own a sword?
No.
It's one of the better aggravated assaults I've read about. I'm disappointed. I thought maybe you were a samurai. Okay. Well, Mr. Watson, I find there's a factual basis for your plea, which is to disorderly conduct and simple battery.
Yes, sir.
No swords involved. I also find that your plea is knowing and voluntary. And I will follow the joint recommendation of 12 months to serve on probation for count 1, reduced to disorderly conduct, and count 2, the simple battery. Those 12-month sentences will run concurrently with each other. And the only condition of your misdemeanor probation is that you stay away from Bobby Mosley.
Yes, sir.
Anything else, Mr. Hand?
Not from the state, Your Honor.
Anything else, Ms. Wood?
No, Your Honor.
Ms. Nelson, how is it that Mr. Watson will connect with misdemeanor probation? Because I'm confident it's not going to be today.
I will send a copy of the sentencing sheet to misdemeanor probation and also Ms. Wood, and they'll
Connect that way. Fantastic. So Mr. Mosley, you're able to leave in just a moment. Ms. Wood is going to give you some contact information for misdemeanor probation. It's a private agency and you need to connect with them because if you don't, they're going to know you're supposed to be on their books. And if they can't find you, then they send me a warrant saying we can't even get this guy. So make sure you connect with them. They're going to stay out of your hair or off the top of your head. Because your only condition is to stay away from Mr. Mosley. So it is not going to be a probation where they're making you report and do community service and all that.
Okay.
All right.
I understand.
Good. All right. That's it. Thank you, everyone.
Do you get when I text you from my phone, do you get those messages?
Yes, I can.
Okay.
Mr. Hand, you did a good job today. A lot of cases.
That's fine.
I will send an email out this weekend, not tonight, but this weekend to you and Ms. Wood and Ms. Charles and Mr. Whitenauer and Ms. Feely, letting you know the lineup for Tuesday.
Oh, I can get you a copy. Of
There are,
That's all right.
looks like 5 cases that'll be on that list. And I don't know offhand which are yours and which are Whitenauer's. I think it's going to be a combo of you and Whitenauer. If you guys work something out, Monday is when we need to work it out, not Tuesday. And we'll handle it that way. Ms. Wood, I was just telling Mr. Hand, I will send an email out this weekend to you and Ms. Feely as to what next week is going to look like. There are 5 cases left. I think they're all yours, meaning PD cases. I know some of them may be Ms. Feely's, but you were saying, look, one way or the other, you guys will be ready to go forward. The only, I think, in custody one is Mr. Adkins. Oh, no, one of them is Ms. Rockwell. So there's one non-PD case.
And Judge, she's been emailing me. I told Mr. Whitenauer as well. I was trying to share the discovery that I had and it's kicking back.
She stood up, and you may have been busy. She said, I think it's HIPAA. We always hear that. So she was going to get an evidence.com link from Mr. Whitenauer. She was wisely saying, maybe I should look at the discovery in this case. Yeah, you're going to trial. You may want to.
Oh, and Judge, there was also one of Ms. Feely's clients that was on the Zoom. I think it was Mr. English.